Are you ready, sir?
Yes, sir. I'm ready to go.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 495 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 495, to amend the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008 to provide for the expedited removal of unaccompanied alien children who are not victims of a severe form of trafficking in persons and who do not have a fear of returning to their country of nationality or last habitual residence, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. The past 4 years have witnessed the phenomenon of unaccompanied alien minors arriving at our borders in unprecedented numbers. Central American minors, largely teenagers, are making the perilous journey through Mexico and then walking miles across a hostile border environment, assisted or abandoned by smugglers, as the case may be, with the intent of entering the United States illegally. In fiscal year 2011, the number of unaccompanied minors apprehended at the border was a little over 6,000. Between 2012 and 2016, the total number caught at the border surged to almost 250,000. The Obama administration claimed that generalized violence and economic depression in Central America was the reason for this influx. However, a 2014 intelligence report illustrated that the previous administration's policies of lax immigration enforcement played the key role in enticing parents already in the U.S. illegally to hire coyotes to smuggle their children into the country. Word apparently spread throughout Central America that even if apprehended minors would not only be not removed, they would be turned over to the parents who placed them at risk in the first place by attempting to smuggle them into the U.S. The Trump administration is making strong efforts to resuscitate immigration enforcement. After only a month in office, the administration reported a 40% drop in border apprehensions. While enforcement is clearly having a big impact, in this fiscal year, so far, over 31,000 unaccompanied minors have already been apprehended at our southern border. That's 5 times the number in 2011. The statutory loopholes exploited by aliens and by statutorily required disparate treatment of apprehended minors based simply on their countries of nationality cannot be fixed even by a well-meaning administration, but must be corrected by Congress. Only in this manner can we conclusively end these systemic problems. Judge John Carter's bill does the job. It sends the urgently needed message to parents in or from Central America who are considering smuggling their children into the U.S. that once apprehended, these minors will not be released into our communities. Rather, they will be swiftly and safely returned to their home countries. The Carter bill modifies the Trafficking Victims Protection Reauthorization Act of 2008. That legislation created 2 distinct sets of rules regarding unaccompanied minors, one for minors apprehended from contiguous countries, such as Mexico, and one for minors from non-contiguous countries. Minors from contiguous countries can be immediately returned if they consent, have not been trafficked, and do not have a credible fear of persecution. However, minors from other countries must be placed in lengthy removal proceedings before the immigration courts, during which they are usually released into the United States, often to the very parents who attempted to smuggle them into the United States. Mr. Carter's bill eliminates the conflicting rules and subjects all minors to expeditious return if they have not been trafficked and do not have a credible fear of persecution. The bill also provides authority for the Secretary of State to negotiate agreements with foreign countries regarding unaccompanied minors, including protections for minors who are returned to their country of nationality. As for those unaccompanied minors who will be awaiting immigration court proceedings, Judge Carter's bill provides for greater transparency and safety. It requires the Department of Health and Human Services to finally take steps to provide DHS with biographical information regarding the sponsors or family members to whom they are released. With no requirement currently in place, minors have been lost in the system or, worse, delivered into the hands of criminals or child abusers. They are easily targeted for recruitment by street gangs and have witnessed many so-called unaccompanied, and we have witnessed many so-called unaccompanied minors joining vicious transnational gangs such as MS-13. The bill also mandates that DHS follow up with the sponsors with whom the minors are placed to verify their immigration status and issue notices for them to appear in immigration court where appropriate. And it ensures that unaccompanied minors get the same number of bites at the apple for asylum as other aliens. I want to thank Judge Carter for championing such a critical issue and introducing a bill that will curb illegal immigration, disincentivize dangerous smuggling practices, and ultimately protect children. I urge my colleagues to support this bill. We must prevent another mass influx of minors along our southern border and the suffering that inevitably comes along with it. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, the Protection of Children Act, contrary to its name, does nothing to protect children. Instead, it strips crucial protections from unaccompanied children who are fleeing trafficking and persecution in their home countries. Let me be clear. This legislation will lead to the victimization and endangerment of children at the hands of the United States government. First, this legislation would authorize lengthy detention of children in Department of Homeland Security facilities that are not suitable for children at all. Why do I say that? Because it extends the length of time that unaccompanied children can be held in Border Patrol stations from 72 hours up to 30 days. Actually, for unaccompanied children who do not pass the cursory screening performed by Border Patrol agents, the bill establishes no time limit for their detention. We have long held that children deserve heightened care. This standard should be no different for immigrant children. Incarcerating children for long periods of time in Border Patrol stations and DHS facilities, no less, is not the American way. Secondly, this legislation would return children to a parent in their home country who has abandoned, abused, or neglected them. It does this by changing a crucial eligibility requirement for special immigrant juvenile status. Under the guise of protecting children, this legislation says that if you are a child who is abused, neglected, or abandoned, the United States government will return you to your abuser. Finally, this bill will send children back who are fleeing persecution and trafficking back to the terror from which they fled without an opportunity to make their case for protection. During the summer of 2014, I had the opportunity to hear the stories of immigrant refugee children at a Congressional Progressive Caucus hearing. Excuse me. These children spoke bravely and honorably about their experiences in their home countries, about the journey north, and about what they had experienced in our country. They spoke of being assaulted and having witnesses murders in their home countries. Having witnessed murders in their home countries. The decision to leave their homes was often made because it was the last choice they had when their countries were unable to provide them with safety. While not all immigrant children will qualify for legal relief, don't we have a responsibility to give them a fair opportunity to pursue their claims under our refugee protection laws? In closing, this legislation strikes me as particularly mean-spirited and short-sighted. Our immigration system is broken, but instead of working on comprehensive solutions to meet the needs of American families, businesses, and our economy, we are considering legislation to target children for swift deportation. I yield back the balance of my time, and I thank the chairman.
Thank you, Mr. Conyers. I'd now like to recognize the ranking member of the Subcommittee on Immigration and Border Security, the gentlewoman from California, Ms. Lofgren, for her opening statement.
Mr. Chairman, as Mr. Conyers has mentioned, the Protection of Children Act actually doesn't protect children. Instead, it will result in increased child sex trafficking, the return of children to violence, the denial of legal counsel, and the prolonged detention of children. I think it's very sad that today we are amending the Wilberforce Act, which was really a triumph of bipartisanship coming together across ideological divides to say we're going to take a stand against slavery and sex trafficking. This bill would weaken that magnificent effort. To argue that the bill protects children because it discourages them from making the journey to the U.S. misses the point. These kids, many of them, are fleeing from violent and desperate situations, including forced sexual slavery, gang recruitment, and extortion. Some have labeled these children, many of them under 12 years of age, as gang members and violent criminals, but this ignores that these children are escaping the brutality, not embracing it. And as Catholic Bishop Mark Seitz testified before this committee in 2014, proposals like this, and this is a quote of the bishop, is akin to sending these children back into a burning building they just fled. We all know the stories of children escaping unspeakable violence to seek refuge, and others who were brutally murdered before having a chance to do so. Many of these children reach us after escaping from human trafficking for sex or labor. Now, the majority has argued that in some cases that this violence is no different than the violence of some of our own American cities. And no one disputes that violence in our cities is a problem, but there are crucial differences. Most importantly is that the violence in Central America is not localized, but instead pervades the entire region. Gangs control every aspect of children's lives, including the police, the government, public transportation, street corners, even schools. The truth is that many of these children simply cannot find safety within their borders. They have no choice but to seek safety outside. And in fact, they're fleeing not only to the United States, but to Mexico, Nicaragua, Belize, and other countries as well. Under the guise of protection, this bill particularly harms disabled and younger children. The bill removes the provision in the Trafficking Victims Protection Reauthorization Act that requires a DHS official to determine whether a child is able to make an independent decision to waive her application for admission and thus any right to seek protection under our laws. Now, this provision was intended to protect, and it was bipartisan, to protect younger children and those with reduced mental capacities. In practice, CBP officers transfer children under the age of 14 to DHS custody because it's understood that such children lack the capacity to make informed decisions about their own cases, particularly in the presence of enforcement officers. Transfer to Health and Human Service custody allows these younger children or mentally disabled children to undergo a longer screening process with HHS social workers, as well as the opportunity to have a hearing before an immigration judge. If this bill were actually intended to protect children, this provision would not be stricken. Instead, the proposal is a short-term solution that would result in rapid deportation of vulnerable, younger, and disabled children. It is really, I think, Orwellian to argue that this could possibly protect children. Now, it's been argued that there is a loophole in the TVPRA that allows children from non-contiguous countries, now mainly from Central America, to be treated better than children from contiguous countries who are mostly from Mexico, not Canada. The majority argues that children from all countries should be subjected to the same expedited screening mechanism as Mexican children, but this ignores what we know about expedited screening practices. At our government's request, the United Nations reviewed our screening practices and concluded that we are returning Mexican children to face trafficking and persecution. The GAO conducted a similar review a year later and also found that the CBP failed to properly screen Mexican children. Given how broken this practice of expedited removal is, it should be ended, not expanded to other children. H.R. 495 also extends DHS's ability to detain unaccompanied children for up to 30 days. Remarkably, it even authorizes the indefinite detention of those who pass the screening. Now, we all saw heartbreaking photos of children in Border Patrol stations several years ago. Some of us, including me, traveled to the border to personally assess the situation. The Border Patrol agents at the time did their very best in a difficult situation, but we should never force these officers to care for children for such lengthy periods of time. They would be the very first to tell us that a Border Patrol station is no place for a child, and certainly not for 30 days or more. This change in the law makes no sense. Now, I'm always willing to consider common sense solutions to our broken immigration system, but this bill is not that. This proposal will harm the most vulnerable, unaccompanied children fleeing violence, trafficking, and abuse. It's not good policy, and it's not in line with our American values of freedom and protection. And I yield back.
Mr. Chairman,
For what purpose, the gentleman from Michigan seek recognition?
I have an amendment at the desk, sir.
I'm going to recognize myself first for the purpose of offering an amendment. Well, he can be recognized during the consideration of my amendment. I now recognize myself for the purposes of offering an amendment. Clerk will report the amendment.
Amendment to H.R. 495, offered by Mr. Goodlatte of Virginia. Add at the end of the bill the following.
Without objection, the amendment will be considered as read, and I'll recognize myself to explain the amendment. The Protection of Children Act will improve and streamline the way our government addresses the continued influx of unaccompanied minors at our borders. It will expedite the initiation of removal proceedings in our immigration courts and ensure those minors who can be are expeditiously and safely returned. Without any method to measure its impact, however, it would be impossible for Congress to evaluate the success of such an important piece of legislation. Thanks to Customs and Border Protection's record keeping, Congress has rapid access to statistics on all aliens apprehended at our borders, including unaccompanied minors. Once an individual is apprehended, however, the record keeping becomes significantly less specific. There are no clear metrics on how many unaccompanied minors fail to appear for their immigration court hearing, or how many are granted asylum either before USCIS or the immigration court. These are crucial pieces of information that presently we only receive anecdotally and without the veracity that hard numbers provide. This manager's amendment provides a quarterly reporting requirement mandating that the Department of Justice and the Department of Homeland Security keep better records and provide Congress with a long overdue snapshot of unaccompanied minors not immediately returned. In keeping these children safe, we must get a better sense of the outcome of their cases, exercise our oversight authority, and ensure that the system is operating as intended. I urge my colleagues to join me in supporting this amendment. For what purpose the gentleman from California seek recognition?
I have an amendment to the amendment.
The clerk will report. We need to get it.
Could the staff hand the amendment to the clerk, please? While this is being distributed, maybe I can,
Let me have the clerk.
All right.
She now has it. The clerk will report the amendment.
Amendment to H.R. 495 offered by Ms. Lofgren. Strike Section 2
Without
of the...
objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
first, I think the underlying amendment,
Would the gentlewoman yield?
yes.
My amendment is not a substitute. It is just a freestanding amendment. So I think we should finish consideration of that, and then we can consider your amendment.
Procedurally, my amendment to your amendment is,
Your amendment does not amend my amendment.
well, I think it does. Did they distribute the wrong amendment?
If you have an amendment that amends the amendment I just introduced,
I do.
We should distribute that.
Where is the amendment?
All right, the clerk will report the amendment to the amendment offered by the chair.
Amendment to amendment offered by Mr. Goodlatte to H.R. 495 offered by Ms. Lofgren. Amend the amendment as follows.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. The amendment that you have offered, I think, is unlikely to yield very much information because we do not have enough judges to actually adjudicate these matters within a 3-month time period. We can find that out if you wish. But I think one of the pertinent pieces of information and why I have offered an amendment to your amendment is to find out what the implications are for children who are represented by counsel as compared to children who are not represented by counsel. Do the children who are represented by counsel show up more often? Are they granted asylum or other forms of relief? Are they removed instead? For children who are not represented by counsel, what is the impact in those cases? Now, it's obviously not a scientific study, but if you take 300 children who are 12, who have fled from Central America and who are making claims of asylum, and most of the children who are represented by counsel get relief, and most of the children who are not represented by counsel do not, I think certain conclusions can be reached that there's a due process problem involved here. And I think that's something that the Judiciary Committee, which is dedicated to defending the Constitution, including the Due Process Clause, should know. We know that, and as a matter of fact, we've had immigration judges defend the practice of 5-year-olds appearing in immigration court and defending themselves, that they would have the opportunity and the capacity to make their claims understood. I personally think that's preposterous, and the immigration judge who asserted that was widely criticized for that assertion. But let's find out. As I mentioned, I don't think your amendment is likely to reveal much information. I don't object to the amendment, but I think if we accept my amendment, we might get some very useful information, Mr. Chairman, and that's why I offer it in a spirit of comedy to you. And with that, I would yield back the balance of my time.
The chair recognizes himself in opposition to the amendment to the amendment. The William Wilberforce Act provides for and encourages the American Immigration Lawyers Association and others to provide pro bono counsel to children who are unaccompanied minors. And I do not support the taxpayers of the United States paying for counsel for these children. So I think Well, this amendment doesn't provide for that. I think the objective of the amendment is to gather data to make the case for doing that. I don't support doing that in and of itself.
Would the gentleman yield?
I'd be happy to yield.
As the chairman has recognized, this amendment does not suggest the provision of counsel to children at taxpayers' expense or at private expense. But we do have a due process clause in the Constitution, and it seems to me getting this information would be a useful thing for us. And I would hope the chairman would reconsider his opposition, because this does not lead, there's nothing in here about the provision of counsel, but we should all be concerned if the due process rights of people in our system are not being respected. And I would hope that the chairman might accept this amendment in the spirit in which it's being offered, which is to improve your amendment, not to oppose your amendment. And I thank the chairman for yielding.
Well, reclaiming my time, I would simply say that the information gathered here is not related to whether or not due process is being provided to these children, but whether or not they are provided with counsel. And there are plenty of opportunities for people to be provided with counsel, just as it is true for almost any kind of proceeding in any kind of court. And in the nature of these proceedings, we do not provide counsel. I don't think we need to know the information that's requested here, and therefore I am opposed to the amendment.
Chairman.
For the purpose of the gentleman from New York seek recognition.
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I rise in support of Ms. Lofgren's amendment. It's interesting to hear that we support due process, but we have no need, in fact, don't want to know the impact of counsel or lack of counsel on this kind of proceeding. It seems to me it's essential information. If it turns out, and maybe it does and maybe it doesn't, that's what the amendment is designed to ascertain. If it turns out that the outcomes of a proceeding for children are vastly different depending on whether they have counsel or not, then that would certainly indicate that a certain result as to due process. If the presence of counsel changes the outcome of a proceeding of this type, that would indicate that due process requires the presence of counsel. If it turns out that the presence of counsel doesn't really change the mathematics, then that would indicate that due process does not require the presence of counsel. The wish not to know, I think, is really a fear of what the information might show, and a desire to remain in public ignorance, lest we see that unrepresented children have much worse outcomes than represented children, and lest we decide, or lest there be then pressure, intellectual, political, other pressure to decide that unrepresented children should in fact be represented. Now, we don't have the facts. We have assertions by certain people that there's a great difference, and assertions that it doesn't make a difference by other people. Why not know the facts? How can we assert that due process is served either way when we don't know? The chair asserts that due process doesn't require counsel, and maybe he's right, and maybe he's wrong. Getting to
would the gentleman yield?
Yes.
The Supreme Court has ruled that taxpayer-funded counsel is not required for due process.
Reclaiming my time, the Supreme Court has ruled that due process as a legal requirement does not require this, but as a practical matter, if we were to find out that unrepresented children have vastly different outcomes from represented children, then we would say, some people would say, I would say, I assume Ms. Lofgren would say, others would say, that as a practical matter, the data indicates that due process is not served. And maybe our judicial understanding of due process is not sufficient, but due process is not served without representation. Now, the data may indicate differently, but we should know the data, and opposition to this amendment is saying we should remain willfully ignorant, lest
Would
Data show what we don't want to see.
the gentleman yield?
Sure.
Your party was in the majority. Mr. Conyers was chairman of the committee when the Wilberforce Act was adopted. There was no provision made for this at that time. I'm just amazed that you think that somehow something has changed that requires that this data be gathered or that counsel be provided, as you suggest. Data would suggest that it be provided. I'm opposed to the taxpayer-funded counsel for people who are not lawfully present in the United States.
Let me just answer that. I have not suggested, well, first of all, what my party did or didn't do, what was it, 8 years ago, 6 years ago, whatever, I'm not here to defend everything we did or didn't do then. Right now...
Gentleman yield? Nor are we.
Okay, fine. That's not the question. We're not debating who did what then, nor should we. We're trying to figure out how to improve the law, presumably. In any event, to answer your question, I have not asserted that due process is not served without counsel. My suspicion is that it isn't, but this amendment is to find out. This amendment is to find out, and we should know. We should not legislate or in ignorance, and we should not act in ignorance, and that's all this amendment says. Now, the chairman says he is opposed to provision of taxpayer-funded counsel. Fine, that's his position, but that doesn't mean we shouldn't know what, in fact, we're dealing with and how necessary that is or is not. Whatever your preconceived notion, pro or con. I yield back.
Mr. Chairman,
For purpose, the gentlewoman from Washington seek recognition.
I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I wanted to rise in strong support of Ms. Lofgren's amendment to your amendment, and I do so thinking about what exactly it is that this bill is trying to do, and I'm in opposition to the bill itself, the underlying bill itself. But it seems to me that the bill is asserting that certain things are or are not happening. For example, that children are coming over the border, that they're somehow being released, that they don't show up for their hearings. And I think your amendment then is saying, let's get the data around who exactly is showing up and whether, you know, the total number of asylum cases and the number of unaccompanied alien children who fail to appear, this is from your amendment, Mr. Chairman, who fail to appear for any proceeding. So it seems to me that if you're going to ask for the data about how many kids are not showing up, then it's relevant, very relevant, and in fact necessary that you find out why they're not showing up. I think Ms. Lofgren's amendment is saying, if you're going to ask for that information, then let's find out exactly why they're not showing up. And, you know, the reality is that we know certain things. The National Association of Immigration Judges, these are the folks who sit in those courtrooms, say that legal representation is absolutely essential to ensure that children have meaningful access to asylum or other protections. And they say that it also improves the efficiency of the courts. Now, the reason that they say it improves the efficiency of the courts is because there have been some studies showing that if somebody has an attorney to navigate these complex procedures, particularly for young children, then they will show up to court, they will know exactly what recourse they have or don't have, and that there will be much less burden on the courts. So I understand that we're not, at this point, arguing whether or not people should have legal access, should have legal representation that's provided for by the taxpayer, but it is important to know what having that legal representation does or does not do in terms of the consequences. And your amendment is getting at what are the consequences, so I think it's appropriate that we would then add in the fact that we are asking for the information about how legal representation affects those consequences. That's something that I think the American people should know, because I think a lot of people out there don't understand that the immigration system is a civil system, that 98% of people are pro se, they're unrepresented. They think that this is actually a criminal system and that everyone gets an attorney. That is not the case. You're provided an attorney if you can pay for one. But that does affect the consequences of how people understand the law and whether or not they should show up in court. Certainly in the context of children, it seems like we should understand what the impact is if a child does not have legal representation. And it is about the efficiency of the courts, and it is fundamentally about, I think, the information that you're trying to get to, because if the reality is that we find, for example, incorporating Ms. Lofgren's amendment, that people are not showing up because they don't have representation, then the solution to that is going to be very different than if that's not the case. The solution for that is not actually a harsh enforcement-only bill. The solution to that might be some other ways of making sure that even if taxpayers are not paying for representation, that we do a better job of making sure that they get pro bono representation. There are lots of solutions that don't involve the government paying for representation, which I wouldn't be opposed to, let me make that clear. But I also think that we're trying to get the information that is at the base of, in some ways, what the underlying bill is asserting. So I really hope that we incorporate Ms. Lofgren's amendment, because I think it provides very important backup information to the very information that you're seeking. What's the point of knowing that kids don't show up if you don't know why it is that they don't show up?
Would the gentlelady yield?
I would yield.
I would just thank her for her support, and it's important to get this information from the government. Now, the Lutherans and some other groups did a study, and what their report is that in a 6-month period in 2014, 94% of the unaccompanied children who were ordered removed did not have an attorney, and that over 7,000 of the kids who were ordered removed didn't show up in court. Now, they indicate that there was an increase in the problems with the notice to appear. In fact, that children were not receiving the notice of the hearings, and as you'll recall, we repealed the requirement for actual notice in 1996. So it just seems to me getting this information from a reliable source, the government itself, would inform us, because it costs money if you have to continue cases. As I mentioned, we have, I mean, it's one thing if you're 17, it's quite another. I mean, not that that's acceptable. 17-year-olds probably not able to defend or make their case, but if you're a very young child, 7 or 8 years old, and you're appearing unrepresented, I think that's something we ought to know about. And to say we don't want to know about this, I think is inexplicable, and I thank the gentlelady for yielding.
I thank you for your comments, and I will yield back and just say that, again, from the National Association of Immigration Judges, they say that children are vulnerable and lack full competency, and therefore immigration court cases must be conducted in a manner different than that of adults. I thank you and yield back, Mr. Chairman.
Chairman.
The gentleman has expired. What purpose the gentlewoman from Texas seek recognition?
Chairman, I rise to strike the last word.
The gentleman's recognized for 5 minutes.
I'm not sure whether the offer of the amendment Ms. Lofgren offered to indicate that both of us, a year or 2 or 3, were at the border in my state and watched as young children, babies, some in mother's arms, fled the extreme, horrific persecution and violence of the countries of which they were fleeing from. I don't think if anyone had a chance to see that they would oppose an amendment of common sense that the gentlelady has offered, and I rise with great concern that this is not an amendment that is accepted, which indicates the number of children who are not represented by counsel were ordered removed. These children fled because they were in fear of their lives. And therefore, this simple addition, I believe, Mr. Chairman, is a worthy one. But I want to speak to what I think is the larger breach, and that is the broken promise that has been made by several Republican presidents, from President Reagan in his immigration reform efforts, President Bush, who for 8 years as a Texan sought to have this Congress pass comprehensive immigration reform. A broken promise that literally destroys and undermines the goodness of this country. I just came from a national security briefing where we were discussing how the unraveling of the greatest democracy, because what we stand for is a refuge for those who want to do good. As I've listened to my colleagues, we have not that, but we have the deportation this morning of a woman from El Salvador who has a husband and 2 children, and even with the pardoning by the governor of Virginia of a lousy traffic ticket, of which generated her deportation, she is now gone. Where is the moral compass that I ask about? Tragically, we lost 7 sailors. One of those were from Texas, who came from Guatemala. I don't know his status, and I offer my sympathy to those families, but he came from Guatemala, wanted to serve this nation. We are breaching the basic tenets of dignity and humanity and the recognition of what this country is all about. At the same time we're dealing with this kind of legislation, Mr. Chairman, you know that we've worked together on a number of issues. We have sent a letter to you, Mr. Chairman, that I wish to hand to you at this time, that indicates every day we are going down a perilous route, and this committee is absent from the discussion. Our colleagues in the Senate on the Judiciary Committee have crafted an investigation on obstruction of justice. The way they have done it is a sensible one. They have jurisdiction over the Department of Justice, they have jurisdiction over the FBI, and these allegations deal with the FBI and the Department of Justice. Last month, President Trump took to Twitter to threaten Mr. Comey, cautioning that he better hope that there are no tapes of our conversations before he starts leaking to the press. That is a direct attack, comment about the Department of Justice. We have expressed this committee its unwillingness to debate these questions because investigations to these matters are ongoing. We acknowledge the sensitivity, but there is no bar or prohibition from the Judiciary Committee of the House to take its rightful responsibilities of oversight dealing with the Department of Justice and the FBI, and of course, the question of the obstruction of justice. I beg of my good friends, Republicans and Democrats, that we are adult enough to be able to handle this investigation as the Oversight Committee. I fear that although we may have a purpose in what we're doing, which is to quash any investigation here in the House, that we're yielding to a non-courageous journey, and as well we're allowing detestable actions to go without the House voice, and it is the people's House. I am extremely concerned, and I believe that courage calls upon us to put aside political concerns and to not allow the seething, if you will, feeling that people have about their government to continue. We cannot cede jurisdiction, Mr. Chairman. We are ceding jurisdiction not only to other committees in this body, but we are ceding it to the other body. And I would ask that you have due deliberation between you and Mr. Conyers on moving forward on at least minimally getting our documents that we requested, we've never seen, it looks like a conspiracy against it, and as well to hold these oversight hearings as quickly as possible. And I thank the gentleman. I want to give this to the chairman, and I yield, Mr. Chairman.
Time of the gentlewoman has expired. What puts the gentleman from Florida to seek recognition?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I support my friend from California's amendment to your amendment, but I wanted to follow up on what my friend from Texas said and ask a simple question, which is, when will we have a real conversation in this committee about what's going on in the White House? Will we, the members of the House Judiciary Committee, take a serious look at the evidence before the American public that the president may have obstructed justice? It's simple. As chair, this is your job, Mr. Chairman. As members of this committee, this is our job. We don't operate in a vacuum. The White House is only a few blocks away. And while we sit here, the president and his team are working to block the American people's access to real answers. They're closing the doors to the press. They're making them turn off their cameras. They're refusing to give answers to even basic policy questions. Why? Because they don't want to be held accountable to their own statements. The president's newest lawyer refused to be held accountable to his own statements when he first said that, and I quote, President Trump is under investigation, and then refused to admit that he had just said it. And the reporters who are doing the hard work of trying to get even the most basic answers from this White House are left to tweet out pictures of their socks in briefings with the White House press secretary when they're prohibited from using their cameras to give the American people a look into this administration. In this country, Mr. Chairman, the job of holding the government accountable is not limited to the free press. Let's go back to first principles here. Let's go back to the Constitution. Let's go back to Article 1, which establishes the Congress, the people's branch of government. The check on the executive powers of the president. We make the rules on behalf of those people back home who use their vote to send us here. We make sure that the president and his administration are following the rules that this Congress has set. And this committee has under its jurisdiction the responsibility to assure that our system of laws is functioning. We have the responsibility of ensuring that no one man or woman is above the law. We have the responsibility of verifying the facts that have contributed to the nationwide discussion about the possible obstruction of justice by the President of the United States. The public testimony sworn under oath, under penalty of perjury, from a public servant who has honorably served this country hints pretty strongly that the President intimidated him, asked for his loyalty above his honesty, and asked him to let Mike Flynn go because he's a good guy and to lift the cloud from his administration, and that the President went on national television and said that he fired that same public servant for an investigation into the President's campaign ties to Russia. The public has been debating the evidence of obstruction of justice. Now it is up to us whether or not we are going to engage in that same debate and do anything with that evidence. Whether the House Judiciary Committee will examine the evidence on behalf of the American people. Every year, we sit up here and exercise oversight over the criminal justice system, including the Department of Justice. And now, here is something that screams out for us to focus that oversight responsibility on. So I would ask, Mr. Chairman, we had asked, as my friend from Texas pointed out, 16 members of this committee have asked, that we start to ask some tough questions. I'd ask that we not let the administration close us out like they are trying to close out the press. Let's give the American people what they deserve above all else from this committee, the House Judiciary Committee. Let's use this committee the way it has always been used throughout its history, to provide oversight, to investigate, and to seek the truth. I thank the chairman for the time, and I yield back.
The question occurs on the amendment offered by the gentlewoman from California to the amendment offered by the chair. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Any of the chair, the noes have it.
I'd like a recorded vote.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Aye. Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Mr. Gutierrez votes yes. Ms. Bass? Mr. Richmond? Mr. Richmond votes yes. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
Rutherford is recognized.
Mr. Rutherford votes no. Mr. Liu votes aye.
The gentleman from Idaho, Mr. Labrador.
Mr. Labrador votes no.
Gentleman from Georgia, Mr. Collins.
Mr. Collins votes no.
Gentleman from Colorado, Mr. Buck.
Mr. Buck votes no.
The gentleman from Arizona, Mr. Franks.
Mr. Franks votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 12 members voted aye, 15 members voted no.
And the amendment is not agreed to. Question now occurs on the amendment offered by the chair. All those in favor respond by saying aye. Aye. Those opposed, no. No. The chair, the ayes have it, and the amendment is agreed to. Are there further amendments to H.R. 495?
I have an amendment at the
Clerk
desk,
will
sir.
report the amendment offered by the gentleman from Michigan.
Amendment to H.R. 495 offered by Mr. Conyers. In Section 2A of the bill,
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman and colleagues, under current law, unaccompanied children from Mexico and Canada receive fewer procedural protections than children from other countries. While children from other countries are transferred to Health and Human Services and placed in removal proceedings, almost all Mexican children are quickly screened before being returned without any real process at all. Now, the majority says this bill simply eliminates this disparate treatment to treat all unaccompanied children the same. They're right that this bill will treat them the same. Children fleeing violence and persecution from Honduras, El Salvador, and Guatemala will now be treated the same as children from Mexico. But the bill would actually treat all children, Mexican and otherwise, far worse than any child is treated today. The law currently requires Department of Human Services to evaluate whether a child from Mexico is capable of making an independent decision to forego possible legal protection under our laws by withdrawing his or her application for admission and simply agreeing to return to the home country. In practice, this provision ensures greater protection for children who are 13 years old or younger, who are presumed to be incapable of making such an independent decision. It also protects children with reduced intellectual capacities for whatever reason. This bill eliminates that requirement for all children. And I don't understand why the majority believes we should stop evaluating the ability of children to make independent decisions about whether they should pursue relief or give up on the protections our laws allow, particularly when in the custody of enforcement officers. Why is it a good policy decision to strip a very basic protection from younger children and those with intellectual disabilities? My amendment would preserve this crucial protection. The amendment would continue to require Department of Human Service officers to decide whether a child is independently able to make a decision that would allow the child to be transferred to HHS custody, where trained child welfare professionals would be able to conduct a screening and provide child-appropriate services. In a letter on the treatment of unaccompanied children, law professors specializing in child welfare law explained that our legal system is rooted in the philosophy that, quote, children are vulnerable and need to be protected, and that we as a society have an obligation to do so, end quotation. They explain that this protection is even more crucial when children arriving at our border present signs of past trauma, violence, or abuse. I ask unanimous consent to enter that letter into the record.
Without objection, the letter will be made a part of the record.
Thank you. We have all heard many of the terrible stories of Central American youth fleeing violence and arriving at our southwest border, and I hope that we can all agree that we should not remove those provisions that protect the most vulnerable within this group. I plead with and urge my colleagues to support my amendment. I thank the chairman, and I yield back any balance of the time remaining.
The chair recognizes himself in opposition to the amendment. This amendment goes in exactly the wrong direction of what was intended by Judge Carter, who represents a district in the state of Texas, a border state that has experienced much of the difficulty that has arisen as a result of the border surge, and the fact that unaccompanied minors have increased by 945% at its apex in the past few years. In fact, the survey of those minors indicates that they come here because they understood and believed that there was a change in law or policy that would allow them to stay. And in point of fact, the Carter bill provides for protection for those minors who have expressed fear or are victims of trafficking. So minors who are apprehended at the border should be returned expeditiously and safely to their home countries so long as they don't have a credible fear of persecution and have not been trafficked. This is the only way we can dissuade minors from making the perilous journey to the United States. It should not be up to the minor to decide whether to accept being returned safely and expeditiously. Expeditious and safe return should be a matter of policy, so long as they don't have a credible fear of persecution and have not been trafficked. Therefore, it is irrelevant whether the minor can make an independent decision to accept return to their home country. We must send the message that minors will be returned. I urge my colleagues to oppose the amendment.
Would the gentleman yield?
I'd be happy to yield.
Thank you. I appreciate your comments. I think they're right on. I would hope that all of us would recognize that each time we try to say we won't do something such as this amendment, what we're really saying is we don't trust Mexico, we don't trust Guatemala, we don't trust Honduras. Do they care less about their children? Do they love theirs less? And yet we make that assumption that only child custody type decisions made in America are right for a child coming from Honduras. Why would we think that we have that right to make the decision rather than the government? Is it that we think those governments are somehow unfair on human rights? I know of none that have been adjudicated, and I thank the chairman for yielding.
Chairman, yield.
Chairman.
I'd be happy to yield to the gentleman from Texas.
Mr. Chairman, I'm from Texas. I know Judge Carter, a great deal of respect. But that was at least 3 years ago when it was peaking. Those numbers are drastically much lower, first of all, and I think we can document that. Secondarily, to my good friend from California, no, you are not informed, if I might say so with great respect. Those countries don't have the capacity. Those countries are enormously poor. Honduras has been known to have the highest murder rate almost in the world, and they are extremely vulnerable. I would venture to say that they have no Children's Protective Service, period. And as well, they do not have an infrastructure that can protect those children while they watch bloody gang wars in the streets. So the idea of Mr. Conyers' amendment is most timely and appropriate. And I think the question is not what Honduras, Guatemala, or El Salvador will do. We wish them well. It is what the morality of this country will cause it to do. That is the standard by which we are operating in this room, not the standard of Guatemala and El Salvador. And again, I wish them well. Travel the streets of Honduras and tell me whether or not you think it is suitable for a child of the age Mr. Conyers is talking about. So I support the gentleman to the
Reclaiming my
Chairman, I
time.
just want to explain that those numbers are down. Thank you for yielding.
I understand, but I want to point out to you that the numbers are still dramatically higher, comparable to at the apex. For example, in 2011, a little over 6,000 unaccompanied minors presented themselves, were apprehended at our border. This year, this fiscal year, which began last October 1st, we're already at 31,000 people. That's 5 times the number, and we still have a few months to go before we reach the end of this year. So this problem has perhaps abated a little from its apex, but it is still multiple times greater than it was before this border surge began. I'd also suggest to the gentlewoman that it is not safe. We don't have statistics on how unsafe it is, but it is not safe for a child of any age to travel accompanied by human smugglers or not from a Central American country all the way up through Mexico, across our border illegally and into the United States, and perhaps arriving at some of our cities in the United States, which have very high murder rates and rates of violence as well. So I just simply do not agree that the judge's approach here of safely returning these children to their home countries, which are the responsibility of the governments of those countries, is not a good idea. It is a good idea. We should support this bill. For the purpose, the gentleman from New York seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I think it was you, or maybe it was who asked a few minutes ago, do we trust the governments of Honduras and Guatemala and so forth? The answer is no, we do not trust those governments. No one who reads the newspapers can trust those governments. Not their intent, but as was said by the gentlelady from Texas, their capacity. And yes, whatever the numbers may be, we do not want unaccompanied kids traveling to this country. But we must recognize the desperation that makes them do so. No parents send their kids unaccompanied to another country unless they are desperate. We saw Jewish parents in Germany in the 1930s send kids unaccompanied on kinder transports. They didn't do that because they thought that England was a nice place or the United States was a great place. They did that because they were desperate for the lives of their children. And they were right. When these kids are coming here, somebody was desperate. Their parents were desperate for the safety and well-being of the kids. Now, the question is, should we look at the situation for each kid? That's all Mr. Conyers wants us to do. That's all we want to do, and say, look at the situation. Don't assume the situation. Don't assume, A, that the situation is safe when we know perfectly well that most of the time it isn't. Don't assume that a 10-year-old can represent himself and tell and convince a judge that he has a credible fear of persecution, as if he knows what that even is. Don't assume a 3-year-old can do that. Take a look individually and make a determination whether we want to send these kids back to be murdered. That's what we're really talking about. Are we moral? That's what we're really talking about. This bill is immoral because it will subject many children to death. Calling it the Children's Safety Act inverts it exactly. So I support Mr. Conyers' amendment. And now, since I have some time, I also want to support the gentlelady from Texas in her comments that this committee is shirking its responsibility by not doing oversight of the Justice Department in the question of possible obstruction of justice. Now, we have jurisdiction over the FBI, not the House Intelligence Committee. We have jurisdiction over the Department of Justice, not the House Intelligence Committee. This is clearly a subject of intense public interest, and not just public interest, but of intense necessity to look into. The fact that there is a special prosecutor who may or may not be looking into this is not relevant. It doesn't take away our responsibility to do oversight when serious allegations have been made. Now, we know the Senate Judiciary Committee, which has a similar jurisdiction to ours, is apparently going to be looking into this. I understand, well, maybe I don't understand the reluctance to look into this, and I certainly do not understand why we would permit or even invite another committee to invade our own committee's jurisdiction, which is what is being suggested by by some people in the House Intelligence Committee at the moment. It is our responsibility to the people of the United States to exercise our oversight jurisdiction, and the fact that there's a special prosecutor who may or may not be looking into this is irrelevant, because we have oversight responsibility. A special prosecutor looks for crimes. Our responsibility is not to look for crimes, it's to do oversight over the proper conduct of affairs by the Department of Justice, by the FBI, and by other agencies subject to our jurisdiction. That's our duty. And not to look into this, not to hold hearings, is shirking our duty, completely shirking our duty. So I urge that we re-examine this question and not shirk our duty. And coming back to the bill ought to be defeated, and the amendment certainly ought to be adopted, because we do not want, I hope, we do not want to endanger children's lives, and we do not trust the capacity, we know better than to trust the capacity of countries riven by gangs and murder and everything that these kids are fleeing, that these desperate parents are sending their kids to flee. We know they can't handle it. And to assert they can is contrary to all the evidence and all the knowledge, and is complicity in the deaths of kids we would send back. I yield back.
First, the gentleman from California. Oh, does the gentleman from Ohio seek recognition?
Thank you, Mr. Chairman. I've heard
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I heard a couple speakers from the other side now talk about the American people deserve answers. The previous speaker, a gentleman from New York, talked about we need to have hearings. Let me say this. I'm for hearings if we actually bring in the right people. We learned 2 weeks ago that James Comey misled the American people at the direction of the Attorney General. The Justice Department misleading Americans. That should not happen. And should the Judiciary Committee look into that? Of course we should. Loretta Lynch told James Comey to portray the matter as, to portray the investigation as a matter when in fact it was an investigation. He did it willfully, he did it intentionally, he did it at the direction of the Attorney General. That should not happen in the United States. This year, Mr. Comey furthered the perception that President Trump was under investigation when in fact he wasn't, and had been told 3 times by Mr. Comey he wasn't under investigation, but he allows that perception to exist. So if we're gonna have these hearings that the other side wants, we gotta have the right people in here answering those kind of questions, why they did that. Then Mr. Comey orchestrates a leak through a friend to the New York Times with his stated goal of creating momentum for a special counsel. And not just any special counsel, but his good friend, his mentor, Bob Mueller, right? So if we're gonna have hearings, let's talk about those things. Should the former FBI director be giving agency information, agency memos to the New York Times? I don't think so. This committee called for, a few years ago, Mr. Chairman, this committee called for a special counsel in the IRS investigation. The Justice Department said no. Justice Department said, no, we can't do that. Even though the lead agent on the case was a max-out contributor to the president's campaign, they said no. No, we can't do that. Even though people's fundamental liberties, First Amendment liberties, were attacked by the agency with the power that the Internal Revenue Service has, they said no. Several people last year called for a special counsel in the Clinton email investigations. The Justice Department said no. But when it involves someone in the Justice Department, when it involves James Comey's reputation, oh, we got to have a special counsel. So if we're going to have hearings, like the other side suggests, let's ask the right questions. Let's get Mr. Comey in here and ask him some questions that the American people deserve answers to, like my colleague from Florida mentioned earlier.
Would the gentleman yield?
I yield back.
Would the gentleman yield?
Be happy to, well,
Chairman,
you're
happy
The
to
gentleman,
that.
would the gentleman yield to the
yield?
chair? Would
yield to the
gentleman
chair,
yield
sir.
I thank the gentleman for yielding, and I appreciate very much his comments. I want to respond briefly to the remarks made by the gentleman from New York about the issue that is before us and the subjecting these children to unsafe circumstances, because the mere fact that they travel all the way across Mexico, often in the hands of people who are not only engaged in human smuggling, but also drug trafficking and weapons trafficking and other things, it would indicate that we should be doing everything we can to discourage them from ever undertaking that journey. But the idea that somehow these countries are less safe places than places in the United States is not necessarily true either. El Salvador has a very high murder rate, 93.09, Guatemala 70.66, Honduras 36.03, Venezuela 47.04, Trinidad 43.38. But in the United States, the city of St. Louis, 59.0. The city of Detroit, 43.0. The city of Chicago's murder rate has spiked up. I don't have the most recent number for that, but it's said to be perhaps the highest in the United States now. So the argument that somehow these children are coming here because of murder rates in their home countries, where their parents who are illegally present in the United States are sponsoring human smugglers to bring them all the way across Central America and Mexico to enter the United States is simply not true. And they are far better off if they are discouraged from making that journey to come to the United States, and their parents are encouraged to go home and take care of their children where they're supposed to be. So I very strongly disagree with the gentleman from New York, and I urge my colleagues to oppose the amendment offered by the gentleman from Michigan.
Mr. Chairman.
What purpose does the gentleman from California seek recognition?
Mr. Chairman, I would like to speak in favor of Mr. Conyers' amendment.
The gentlewoman is recognized for 5 minutes.
There's been a lot of discussion. I want to talk about the Wilberforce Act and why we came together across party lines to enact that. A lot of it was about sex trafficking of people and especially children. And I'll give you an example of what this bill would do and why Mr. Conyers' amendment fixes it. For children from contiguous countries, there's expedited removal. And the exception is for very young children or for children who have or even non-children, people who are mentally disabled, who can't really make a decision or they're not capable, that there's going to be a secondary review of their situation. At the request of the United States, the UN took a look at how the Border Patrol interviews children. And then the GAO, at our request, followed up with that same inquiry. And what they found is not encouraging. They found that we are turning children away who have been sex trafficked. That's what's happening. And the prevention of that is to take, well, we actually should expand this, but certainly you don't want to just summarily turn vulnerable children who have been trafficked away. And this is primarily children from Mexico. It's not, I mean, I have a great deal of sympathy for little kids who've come thousands of miles, but the population we're talking about here that the bill would specifically target are children who've been sex trafficked from Mexico. If Mr. Conyers' amendment is not approved, we will be sending these trafficking victims back to their pimps to be further trafficked. I don't think that's what we want to do. And I would hope, you know, we have a situation here where all the Republicans vote one way, all the Democrats vote another. That's not a smart way to approach this. And it's not the way we used to approach this. We used to say, and we were led by the religious community, that no, we're going to take a stand across party lines against trafficking. And now we're not doing that. It's a huge disappointment to me that we've come off that bipartisan effort. I think a step forward would be to approve Mr. Conyers' amendment. And I would like also to ask unanimous consent to put into the record the report from the UN that was done at our request and report from the General Government Accountability Office, also at our request, on how the current procedure, absent the removal to HHS, is working at the border. It is not encouraging situation. And I would further like to ask, Mr. Chairman, unanimous consent to put into the record the following statements: the Friends Committee on National Legislation, the Statement on Church World Services, the Hebrew Immigration Group, the Immigrant Legal Resources Center, the Refugee Council, the Juvenile Law Center, the Tahrir Justice Center, the American Immigration Lawyers Association, the Center for Migration Studies, and the U.S. Conference of Catholic Bishops Committee. And I'll just note that when you think back to what we did a number of years ago on the Wilberforce Act, and the fact that the Friends Committee and Church World Services and the Catholic bishops are saying, please don't do this, we ought to stop. And actually it would be great if we could adjourn and have a discussion with each other about why this approach. I have a great deal of respect for Judge Carter. I like him personally. We work together a lot, but I think his effort, this bill is mistaken. And if we could have a collaborative approach, as we did during the Wilberforce Act, it would be much likelier to yield a result that protects victims of child sex trafficking, which this bill does not. So please, I would hope we could support Mr. Conyers' amendment, but it would be even better if we could adjourn to a discussion about what we're doing here that is not just along party lines. And with that, Mr. Chairman, I would yield back with my unanimous consent request on these documents.
Without objection, the documents submitted will be made a part of the record. For purpose, the gentleman from Georgia seek recognition.
I move to strike the last
Gentleman is
one.
recognized for 5 minutes.
I yield to the gentlelady from Texas.
I thank the gentleman very much. I want to build on the spirit of Congresswoman Loughran, but I want to give a historical perspective, and I made the comment that I, too, respect Judge Carter and know the conditions in Texas. But I would take issue with the comparisons of crime rates in our American cities. Yes, that is the case. But the point that I made about the country cited, and the gentleman from California was citing them as some beacons of opportunity, is that it does not compare with respect to the infrastructure that we have in the United States that we attempt to continue to improve, that is protecting children. So we know that we've had violence. We've had children who have been the victim of violence in the United States. There is no doubt. But we have a circumstance in the countries upon which they are fleeing where the entire country is caught up in the level of violence, and there's no space of peace or opportunity to protect the children. So it is not an unusual phenomenon. We may not be familiar with it as the most developed nation in the world, the leading democracy, the country that is the leader of the world, as we have been at least in recent years. That is a distinctive difference. And then if I can take you down the historical pathway, if you read any of the historical essays and books on immigration in the United States, as people migrated from Europe, it was not uncommon in the 18th and 19th century that children traveled alone on ships across the ocean to flee persecution or starvation, or their families may have thought that this was a better route, this beacon of light, this shining city on the hill. And they came here, and many people in this Congress may be, in fact, descendants of those children. Now we have coming from a different region, where the children of a different ethnic background, racial background. And I don't think we can make the distinction to not protect these children, as the historical essays will dictate that children were funneled to a different area and tested and determined what their health condition was. Maybe there were relatives waiting to pick them up on shore, but I really think that that is a problem in the comparisons. Finally, let me accept, I knew that the gentleman from Ohio had intended to yield to me, so I thank him for his intentions. But I'm certainly both challenged and willing to accept his offer. There is no reason why Director Comey cannot be in front of us, or the acting FBI director, or General Sessions. And those questions can be raised. There's no bar to the questioning that would come. What happened previously, determinations were made, and I'm sure that the gentleman had his say in the last session when he was dealing with other leaders of the DOJ. Well, we need to have our say, if you will, but I'm not going to and would not think that this committee would bar anyone from asking questions. What we're here to do is get the facts and engage in oversight, and I think maintain and develop and create a system of integrity that seems to be unraveling at the edges. One person after another is attacking the other person in the administration of who said what, and who is agreeing with what, and what confusion is occurring. What is the level of the Russian collusion, and who impacted the elections? All of those potentially are issues that can be raised as they impact and deal with the Department of Justice. So I am not in any way intimidated by the questions that the gentleman has offered. Let's get at it in the professional way in which we need to do so, and that is that the witnesses come and the members of this committee engage in the appropriate oversight that I think is our duty and obligation as members of this august committee that holds in the highest responsibility as the protectors of the Constitution, and as well in making sure that the rule of law is followed. It is obviously not being followed, and it certainly is our obligation to ensure that
Would
it
the
is.
gentlelady...
I'd be happy to yield to the gentleman.
I want to thank her for...
The time's controlled by the gentleman from Georgia. He can yield
Oh,
to them.
yes. The gentleman yields? Thanks you very much. I think I wanted to congratulate her on the very appropriate way that the Judiciary Committee of the House of Representatives might be able to move under that kind of a plan. I congratulate you and thank you.
I yield back to the gentleman. I thank the gentleman from
And
Georgia.
with that, I yield back.
Mr. Chairman.
Question. What purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
And I will say what I'm going to say because I thought that Congresswoman Lofgren had a great substantive suggestion of backing up, finding if they're middle ground, because we don't want to send victims of human trafficking back to the traffickers. And I thought that she made that suggestion in goodwill. And I don't want my frustration or anything to hamper her genuine and sincere effort to find middle ground. But as chair of the CBC, I still find some obligation to voice concern or hurt by your comparison, just as I did with the President of the United States when he compared many of our urban cities to Baghdad. Your comparison of urban cities to Guatemala and other areas with almost twice the murder rate is hurtful. And I would just ask that you think of it in this way. In those communities, there are a lot of mothers waking up every day to make sure that their kid who's doing the right thing is protected. In those communities, there are a bunch of kids like me when I was young, who was catching hell from the thugs, but also scared of the police. A whole bunch of parents who are trying to do right by their kids and provide them with opportunity, who may be listening to this hearing today because their parents want to educate them on the civil process or civics or U.S. government or how it works. And we just had a moment where we decided that we would tone down what we say and how we say it. I can only speak for me, and I think we're all a product of our life experiences. but I'm from New Orleans, that has a high murder rate, unfortunately. And it's all caused by drugs and lack of economic opportunity, similar to the other cities, similar to the other countries. But for someone who has fought my entire life not to go down that road, to get compared to Guatemala is hurtful. And I just think that if we're going to be the leaders of this country and we're going to set the tone, we have to be very careful about the comparison. And I'm not saying that you want the kids listening to feel any inferior, because I don't believe that's who you are. But I do think that words have meanings, and sometimes they hurt. And I would just caution us about how quickly we can make those comparisons when they're not our communities. And I would just remind you, I live there, and I have a 3-year-old son who lives in what would be one of those communities. And I just think that it sends a message to the people who live in those communities that they're no better than the people in Guatemala, or that their circumstances are the same. And I think that's unfortunate. I'm not going to ask you to do anything. You're the chairman. You do whatever you want to do. But I think that when people use words that hurt, it's oftentimes good to acknowledge that that wasn't the sentiment, or acknowledge that it was a mistake, or just say, I'm sorry. I don't know. But I'm just telling you that I thought that we were working to get to a better place in this body, and I just don't feel it right now. With that, I'll yield back.
Who seeks recognition? Purpose the gentleman from Illinois seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you very much. I just want to follow up on my colleague comments from New Orleans, Mr. Richmond. And to say, to me, this is simply a continuation of what we heard. Mexicans are murderers, rapists, drug dealers. There might be a few good ones, but for the most part, that's who they are. And to say that that's kind of my life experience in the United States of America. I'm a little older than a lot of members of this committee. So I was born in 1953 when separate but equal was the law of the land. Now, I lived in the North, not in the South. So they didn't have a sign that said, Negroes drink here and whites drink there. But I knew which swimming pools not to go to. I knew which schools I was not going to be enrolled in the city of Chicago. I knew what parks not to play baseball in. And so it's, sorry, but it's part of a continuation of using race and at the same time criminalization of a community to combine to create fear and to create a politicization which you benefit from. That's not new in America. I've been living that experience all of my life, and I was born and raised in Chicago, Illinois, which, by the way, Martin Luther King said when he came to my city in 1967, he said he never saw such hate in people's eyes anywhere in the South when he came to visit my city. So segregation and the use of it and the use of races is a pretty old. So now we're dealing with children. Children under the age of 14. I don't know. I have a grandson that's 14. He's a child. He thinks about soccer. He thinks about playing his Xbox. He thinks about what 14-year-old kids think about. The latest hip-hop song that he, compares to some reggaeton music, because he combines them all together, because he's 14 years old. I was into the Beatles, right, when I was 14 years old. That's what kids are about. And you're asking kids to make decisions about life and death circumstances and take away protections about kids at that very tender age? But they're kids from Central America. They're from Honduras. And remember that when you say in America, Mexicans are murderers, rapists, and drug dealers, here's what America understands. Latinos are murderers, drug dealers. Because I got to tell you, you got to be quite an expert to be able to tell the difference between a Dominican, a Puerto Rican, a Colombian, a Mexican, a Salvadorian, or by the same rate, an African American that comes from Jamaica or Africa or from the South. I wouldn't venture to tell the difference if I just saw them where their country of origin, or someone that's white, whether they came from, I don't know, Ukraine or Poland or Ireland, I'd probably have a hard time. So I understand. So people understand that. And that, sadly, is part of what we're confronting here today. Is we're going to be able to take away the protections for children that come from these countries fleeing not just abject poverty, because that would be one thing. Abject poverty would be one thing. Because you see, they could get a job, and they could maybe not be not have everything nutritional that they need. But that's not really what the case is. It's a case of whether they're going to live or die, not whether they're going to have a job or not there that pays better here. And that's really what we're going to take the protection away from those kids. Because remember, the majority of refugees are what? Children. I know that you tend to look at the news and they'll talk to you, well, those jihadists are coming, those hardline, they're coming. And they'll show you the M15 and the gangbangers are coming. But really, they're kids. They're kids coming, fleeing. And that's what we're having here today. So I understand this conversation in that context, that we're going to continue to have this conversation in that context, because unfortunately, that's the context in which I've learned. My friend, Mr. Jeffrey, he's from New York, so he knows a little bit about the history of the Puerto Rican community. My mom and dad came to this country because they were poor, because they had a bad education. And in 1952, they came to New York, Mr. Jeffrey's city. And they didn't have a banner that says, oh, what a good idea that all you hundreds of thousands of Puerto Ricans just showed up. And they came as citizens of the United States. You know what they said about my mom and dad? They were murderers. They were criminals. That they wanted to be on welfare. Oh, and that they were bringing tropical diseases from the island of Puerto Rico. And all the elected officials in New York tried to stop people like my mom and dad from coming. Now, they were citizens. What do they have in common with the people today? The color of their skin and the language that they speak and the origin of the United States and of the world that they come from. And I think that's unfortunate that history has to continue to repeat itself. But maybe there wasn't anybody to stand up for my mom and dad. I'm going to stand up for people who are just like my mom and dad today.
Mr. Chairman.
Where's the gentleman from Washington seek recognition?
Move to strike the last word.
Gentleman was recognized.
Thank you, Mr. Chairman. I wanted to rise in strong support for the Conyers Amendment and go back to something that Ms. Lofgren was talking about in terms of the root causes of why kids and people are coming across the border, and specifically wanted to talk about sexual and gender-based violence in these countries, because I think that we really have to focus on what the situation is and why kids are coming across the border. And I would like to ask unanimous consent, Mr. Chairman, to introduce into the record the Kids in Need of Defense report called Neither Security Nor Justice.
Objection will be made a part of the record.
Thank you, Mr. Chairman. And I quote from this report about the lack of protection and services for victims of gang-related sexual violence and gender-based violence. And this is from a police officer in El Salvador. He says, "There are no viable options in this country for victims of gang violence. If you report, the gang will come after you and the state can't protect you. Even if the gang member goes to jail, there's a network in place to harm you." Mr. Chairman, in Central America, the Northern Triangle countries are among the top 5 countries in the world with the worst female homicide rates. If you go to Honduras, from 2005 to 2012, murders of Honduran women and girls increased 346%. In El Salvador, the Center for Gender and Refugee Studies found that El Salvador had the highest rate of femicide, or gender-motivated killing of women, in the world. In 2012 alone, groups reported that 731 Guatemalan women and girls were murdered, and only 2% of those murdered were investigated. Violence against women rose 17% in 2013. In El Salvador, there were organized armed criminal actors targeting women and girls, using rape as an intimidation tactic in communities. And from 2010 to 2012, an average of 461 rapes per year, Mr. Chairman, 461 rapes per year reported. I think this is really important because we are talking about why kids are coming across the border. Why do parents send their children unaccompanied through the dangers that you rightly pointed out of getting to the United States? Because there are no other options. It's not because they're just sending kids over for the heck of it, because the United States is a great country. Of course we're a great country, but you don't send your kids through that kind of trauma, separation, and danger unless there is a real need. And the specific angle of sexual and gender-based violence has to be considered in this context. And Mr. Conyers' amendment, I think, gets at that and assures that we are looking at these situations, assessing them, and really making a determination that should be made in order to provide for due process, but more importantly, in order to preserve the tradition that this country has of being a place of refuge and a place of protection for people who are seeking that kind of asylum. So I hope, Mr. Chairman, that we will accept Mr. Conyers' amendment and that we continue to think about and articulate not some false facts about why people are coming here and what would cause a mom to send her kid here or what would cause a child to decide to come here on their own, but in fact look at the circumstances in these countries. And I also just wanted to say thank you to my colleague from Louisiana for an incredibly articulate, personal perspective that about the problems with comparing what is happening in our cities to what is happening in these countries. I just think that comparison is harmful, it's detrimental, and it's I think it's actually not accurate at all. So I thank you, Mr. Chairman, and I yield back.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it.
Record vote is requested.
Vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. Issa votes no. Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
The gentleman from, have you voted? The gentleman from Florida.
Mr. Gates votes no.
Gentleman from Iowa.
Mr. King votes no.
Gentleman from Arizona.
Mr. Franks votes no.
Gentleman from Ohio.
Mr. Jordan votes no.
Hands waving is a positive indicator. Gentleman from Florida.
Mr. Deutsch votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 12 members voted aye, 14 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 495?
Mr. Chairman, to your right.
Gentleman from Iowa seek recognition.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 495 offered by Mr. King of Iowa. Add at the end of the bill the following. Section 6, biannual report to Congress.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. And listening to the debate here, and I know there's a disagreement on what kind of recidivism that we have and what the impact is on crime in the United States when we import people from high crimes countries. And I was looking at the numbers that show 227,149 unaccompanied alien children have been brought into the United States from these countries in the past 6 years. So one wonders how many crimes were committed by that universe of people that come from the most violent places in the world. And what this amendment does is requires every 6-month increment a report from the Attorney General on each crime for which an unaccompanied alien child is charged or convicted during the previous 6-month period following their release from the custody of U.S. Department of Homeland Security. And many of them are being released on, on their own recognizance. And I heard the chairman's statements on the violent crime rates within the countries that many of them are coming from. And I just summarized some of that data that I heard from the chairman, and it comes out this way. That shocking number in El Salvador, 93.09 violent deaths per 100,000, shocking. Until I looked up the data that was delivered to this committee from former member and stellar member Randy Forbes of Virginia, who had gone to New Orleans to examine the violent death rate and the crime rates in New Orleans. This was post-Katrina. And there, the violent death rate, that was actually characterized as a homicide rate in New Orleans, was 90 per 100,000.
Mr. Chairman?
Very close to the 93.09 out of El
Gentleman
Salvador.
from Louisiana seek recognition.
We just had a conversation about this. We're going to lose all civility in this committee if he thinks it's appropriate to compare New Orleans to Guatemala. Now,
The gentleman will suspend. The gentleman from Iowa has the right to make a statistical comparison between two locations.
well, you're comparing the people in the locations. That'd be like me comparing them to somebody in the Klan. I don't have a basis to do that.
When the gentleman has completed his remarks, I'll be happy to recognize the gentleman from Louisiana to make his arguments to the contrary, but he's entitled to make those remarks.
We just had a conversation about civility in this United States Congress. Now, I wear badges of bipartisanship because I actually take up and stand up for principles. I am not going to sit here and let him do that. Now, the people I love, the people I respect, and I live in New Orleans. Now, if the gentleman persists on it, then let's go in the back and have the conversation about New Orleans. But I am not going to sit here and do that. And if it takes walking across over there, then I'm prepared to do that too. But it's not appropriate, it's insensitive, and it's nothing more than traditional white privilege of let me criticize a minority city. Now, take it how you want. I'm telling you how I feel.
Look, the gentleman is entitled to express how he feels, but so is the gentleman from Iowa. And these remarks...
And words and actions have consequences, and we just saw it days ago. And we promised to do better because words have consequences.
Words have consequences, so do statistics, and so do arguments. This is the place to do it under the rules of the House. And under the rules of the House, he is entitled to proceed. The gentleman from Iowa may resume his arguments.
Thank you, Mr. Chairman. And I'd suggest that if the gentleman can't participate in an open discussion on this, then it might be better for one of us, and that would be particularly you, the gentleman from Louisiana, then to remove himself from the room, but he can't restrain himself.
We'll suspend. That remark is not appropriate. And the gentleman has offered to have this discussion in private. You can choose to do that or not do that. You are entitled to have a discussion regarding the statistics related to murder rates in various communities and various countries. But the issue of whether or not the gentleman can be here or not is his business, not yours. So the gentleman is recognized, but...
Mr. Chairman, reclaiming my time, I'm simply reciprocating on this regard, but I'll go back to the data, and I will not be intimidated by this kind of thing. It's important that we look at data. In fact, it's more important that we look at the data than it is we listen to the rhetoric that surrounds the data. And these are bodies that are going to the morgue, Mr. Chairman. That's something that is offensive to me. And it's gone on in this country for a long, long time. And I've listened to these debates about the violent death rate in the countries that the people are coming in that are unaccompanied alien minors coming into the United States. I've listened to that death rate, and I've heard the members on the other side of the aisle say we've got to get them out of those countries. We've got to get them out of there because they're subjected to these high death rates. 93.09 in El Salvador, 70.66 per 100,000 in Guatemala, Venezuela 47, Trinidad Tobago 43, Belize 43, Lesotho, there's one outside of what's south of the Rio Grande River, 41.9. Colombia, back in there, number 7 in the world, 37. Honduras, number 8 in the world, 36. And then Haiti, 35. Panama, 34. Brazil, 30. You take the top 13 countries in the world, and 11 of them are not just south of the Rio Grande, they're south of Mexico. And we're talking about having sympathy in our hearts to remove people from those violent areas. All right, that's a point. That's statistically, I recognize that statistic. But you also must recognize the statistic of the violent death rates in this inner cities in the United States of America, of which New Orleans is not the highest anymore. In fact, that 90 has gone down substantially in New Orleans since Katrina. And that's a legitimate point, too, that I intended to make in the flow of this conversation. But East St. Louis is not so good with that 70 per 100,000. St. Louis itself, 49.99. Call that 50. This city here in Washington, D.C. used to be 53 violent deaths per 100,000. There was a time when it was safer for my wife to be, safer for someone who was a typical citizen, ununiformed in Iraq, than it was to live in Washington, D.C. That's the data we're talking about here. When's this committee going to come around to reducing the crime rates within our inner cities? Within Detroit, for example, and the chairman, the ranking member knows, I've gone to Detroit, I've met with the chief of police, I'm very impressed with him. I think they're making some good moves there, and they've dropped down from number 1 to 2nd or 3rd in the nation. It's a long ways to go where Detroit needs to get, but we need to have those kind of conversations.
Will the gentleman
We
yield?
need to be, I won't yield. And we need to get to the point where we understand the real data. That's what this amendment is about, is the real data on the recidivism rate. These kids coming in here, 13, 14, 15, 16, 17 years old, if they're telling, and it may not be telling the truth on that, prime gang recruitment age. Young men, 81% prime gang recruitment age. We need to know the data, Mr. Chairman, and I urge the adoption of my amendment, and I yield back the balance of my time, even though I lost a minute or so in the exchange.
Time of the gentleman has expired. For purpose, the gentleman from Louisiana seek recognition.
Mr. Chairman, I would just go.
Gentleman's recognized for 5 minutes.
I would just go to the data and the point that the gentleman made when talking about violence in inner city communities. We always talk about it, but we never talk about the role that government has played in that. We decided that we would have a war on drugs, and I'm not saying it's Democrats versus Republicans. I'm saying United States Congress as a body decided that they wanted to have a war on drugs, which has caused real pain and has caused the violent inner cities to emerge based on this war on drugs. Now, you take the same crack epidemic, you change who is the primary victims and perpetrators, and let's call it opioids, and all of a sudden we have the warm and fuzzy, loving approach to how we're going to tackle it. We're going to treat it as a mental health crisis. We're going to treat it as substance abuse addiction. We're going to wrap our arms around it, and we're going to treat it in a different fashion. By the way we are approaching opioid addiction and abuse in this country is the right way to do it. And I applaud Congress for realizing that it is the right way. But our response to crack cocaine was the wrong way. What it became was a war on inner city communities where the same addictive drug was found, but you removed so many people from the community, you didn't treat the substance abuse part of the problem, and then drugs kept coming in, so it became this highly profitable market. Now we're treating the substance abuse that we didn't treat the first time. So yes, we play a role in it because our response to crack cocaine was the opposite to what we're doing for opioids. Not to mention, if you got caught with crack cocaine, for the same amount as powder cocaine, you were sentenced to 100 times longer. Now, people who had crack cocaine were primarily young African-American males. People who had powder cocaine were not young African-American males. We now realize that that approach was wrong, which is why Newt Gingrich, which is why Heritage, which is why Koch brothers, which is why NAACP, ACLU, and others have said that we need real criminal justice reform to make it make sense, just like we're doing with opioids. So we have a role, we get some of the credit for how the response to crack cocaine has added and contributed to the violence in a lot of these inner cities, not to mention the lack of funding for public education, economic opportunity, and all those other things that would play a role in it. So if we're gonna talk about those things, at least do it in a fair way that compares apples to apples and tells more of the complete story. With that, Mr. Chairman, I yield back.
Mr. Chairman,
What purpose the gentleman from New York seek recognition?
to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I agree with the gentleman from Louisiana in his observations about the history of of our fighting drugs and of the war on drugs and of the results of that. In fact, we've run the same play twice, and we're still doing it. We created, to a large extent, organized crime in this country by prohibition of alcohol. We generally recognize that that created the large criminal syndicates because we couldn't enforce that law, and people wanted liquor, whether prohibition existed or not. So we repealed prohibition. But we didn't learn our lesson. In the 1970s, we started a war on drugs with the same result. Large organized crime, not only in the United States. Why do you have all these murderous drug cartels in Mexico and Central America? To supply the U.S. market. To supply our market. We're the customers. If there were no drug problem in the United States, you wouldn't have the drug cartel problem in Mexico. And that's the causation, not the other way around. The supply, the demand demands the supply. So we have still not learned that lesson. Now on the opioids, maybe we have learned the lesson. We're following a more intelligent policy. Although we still haven't really repealed the war on drugs, which is still creating murderous gangs and criminal activity. So I hope we have learned our lesson on that. And we have inflicted immense harm in this country and in Latin America, and for that matter in Afghanistan, through our drug policies, through our prohibition drug policies, which we should have learned, and maybe we are beginning to learn, as the gentleman from Louisiana said. Having said that, I don't see anything wrong with Mr. King's amendment. He wants more information. He thinks, I presume, I shouldn't say what he thinks, a great calumny, a great libel has been spread by the administration, by the president, by others, that immigrants to this country commit crimes at a greater rate than non-immigrants. The statistics tell us the opposite. Exactly. The president said that at the State of the Union address. The statistics tell us the exact opposite. I presume this amendment is intended to show that unaccompanied alien children will be committing a lot of crimes. I think the amendment will show, if enacted, that that's not the case. But I don't have any opposition to gathering facts. And I wish the other side of the aisle had supported our other amendment today to gather facts with regard to, that was offered a while ago, with regard to representation in court of unaccompanied minors and whether, in fact, that has a real effect on the decisions. I'd like to know that. I have my own opinion on that. I think it does. Some other people think it doesn't. It would be useful to know those facts.
Would the gentleman yield?
Who asked me for yield? Sure.
Thank you very much. I have a similar reaction, Mr. Nadler, to Mr. King's amendment. He's just looking for fact gathering, but would it not also be equally as important to assemble information about children who are denied entry to the country under this legislation what their future holds. How many of them become victims of prostitution, child sex trafficking, child abuse, murder, and so on? Would you think that that would be a logical amendment to add to Mr. King's amendment?
I would think that would be a very logical amendment. If, in fact, we are sending kids back, as I think is the case to some extent, as I mentioned previously, to be murdered, and we are therefore complicit in that result, that would be something very useful to know on a more systematic basis so that we could act appropriately. I think gathering facts, as I said, I think that the facts, if this amendment were to pass, will show the contrary to what Mr. King thinks they will show, but it will show whatever it shows. I think I would like to know the information that was in the amendment before. I think it was either the gentlelady from Texas or the gentlelady from California who offered it on the effects of counsel. And certainly I would think that what the gentleman from Maryland raises is also appropriate. So again, let me just say that we should recognize, I have no opposition to gaining facts, but we should recognize that the basic purpose of the bill, which is to send more kids back, probably will result in more kids being murdered and subjected to unspeakable violence, and we should not do that without looking into it and having an opportunity on an individual basis to look into it, which is what previous amendments were talking about. The bill is a terrible bill. I don't see that this amendment makes it any worse. I yield back.
Mr. Chairman, Mr. Chairman,
What purpose does the gentleman from Texas seek recognition?
strike the last word.
Almost recognized for 5 minutes.
I think it is important to make a general statement that we would be contradictory if we did not allow members to seek information. And so the aspect of the gentleman from Iowa's amendment that causes the need for information is certainly what the role of this body is all about. But I think Mr. Richmond made a very appropriate intervention in terms of how we use numbers to make a point that may be valid. Now, I know Lesotho, a country in Africa. We have not assessed in those numbers the infrastructure or the level of poverty or the governmental structure in Lesotho that may impact, or what those deaths may be about. It may be conflict. Certainly it's far different from circumstances of gang violence, general street crime, which we know over the years have gone down. I think my good friend from Iowa misses the whole element. Race is still a very sensitive issue in this nation. There are members on the other side of the aisle that have a difficulty in understanding that.
Would the
There are some
gentlelady yield?
I will not yield at this moment. I thank the gentleman for his courtesies. There are some cities that are associated, terminology inner city, ghetto, with people of color. Growing up, I didn't realize that I may have lived in a neighborhood that was predominantly of one color. It was a different era, of course. We just happened to live in a neighborhood. But as one moves into the land of sociological studies and analysis, you begin to understand, if you read former Senator, late Senator Moynihan's work and all of the assessments of what makes people of color tick, why they live in these conditions, high crime rates. I know that during the historical time of the Great Society, when LBJ indicated that I'm going to invest in people between Pell Grants and Labor Department, Department of Education, there was a whole surge of opportunity for people of color. And crime was different. It may have been isolated. People had opportunity. Moving through the skinny budgets of a number of Republican presidents, those hopes and dreams were dashed. And they were, in fact, substituted by bad laws regarding drugs and rounding up folk and institutionalizing people who happen to be people of color and creating added criminals coming back in the streets. Compound that with no jobs. Compound that with the sequester. Compound that with constant policies that continue to undermine opportunities for young African Americans, young Hispanics, young Anglos, young immigrants. So I would hope that the gentleman would join me in eliminating the sequester and fully providing for funding for opportunities that in fact quash the bad pathway that some young people are relegated to doing. But to sit here and associate a data collection document or amendment with a whole litany of statistics calling on cities that population is dominated by people of color, yes, it is offensive, because I still live in an America that is divided by color. I don't teach my children that. They don't live by that. I don't live by that. But the gentleman knows how to raise the buzzwords. He's done it consistently. And that's just not the pathway in which we should go. And I would simply ask the gentleman to join me on lifting the sequester, begin to look at the landscape of, and I ask my colleagues, there's a subcommittee tomorrow, the Criminal Justice Committee, on reforming the juvenile justice system. You're not on the committee, come join us and be part of the solution. But if the gentleman wants to have this amendment on data, why don't he amend his amendment and provide the funding for the Department of Justice and ICE and the FBI that each unaccompanied child have a federal agent that walks around with them from the time they arrive in the United States through the moment that they apply for asylum, when they receive asylum or status, continue walking with them when they go through high school, make sure you continue with them through college. If they go into the United States military, continue that federal officer so they don't create a crime. Let's put funding in there so they'll have that kind of criminal protection of the United States. All I can say is the gentleman should be careful in how we debate these questions. Getting information, sir, is relevant. But the argument is not relevant, and I am particularly sensitive as an African-American woman. I yield back.
The question occurs on the...
Mr. Chairman. Mr. Chairman.
The gentleman from Georgia seek recognition.
I move to strike the last
Gentleman
word.
recognized for 5 minutes.
Mr. Chairman, I rise in support of the gentleman's amendment. He would like to determine through this amendment how many children, refugees, end up committing crimes in the United States of America. I think that's a fair question. Just as the other amendments that have come before his, which I supported, present fair questions, I must take the time to talk about the statistics that the gentleman from Iowa cited from 11 countries of the top 15 for murder throughout the world. And I would opine that it's not, those high murder rates are not because those people who happen to be south of our border are not Americans, or they are, somehow racially inferior. It's not from where they come that caused the crime rate and the murder rates to be so out of line with the rest of the world. Could it be conditions that exist in those countries as opposed to the people themselves? Because why would we punish innocent children? That's what this bill is directed towards. H.R. 495 misnamed the Protection of Children Act. I don't know who named it the Protection of Children, This is actually kicking out protections of children entering this country as refugees. Now, refugees are people coming into the country trying to escape violence, trying to escape war, persecution, the fear of imminent death. That's why a mother would send her children over a perilous 6,000-mile route from Central America through Mexico to get to the shores of the U.S. for safety. That's a problem. Why are the conditions south of our border so perilous that it would prompt a mother to do that? It's oftentimes the war on drugs that this country is waging south of the border that promotes violence. It's also economic persecution that corrupts those governments so that multinational corporations can come in and rape and pillage the land for natural resources, displacing people, killing people who disagree politically and who are protesting these actions by multinational corporations. So you have drug violence, you have violence by right-wing militias that are sponsored by governments. You have no protection for children. And so people want their children to be safe, to be able to live. So they send them to a place where they think that they can get some protection. And that's what refugees have done for many years, and this legislation seeks to close the door on those refugees. And this is another example of our society paying attention to divisive issues for political gain. This comes at a time when there's important things happening in this country. On this Judiciary Committee, which is responsible for overseeing the Justice Department, we've got the head of the Justice Department recusing himself from an investigation which is so important to our democracy, the Russian investigation and any collusion that may exist between the Russians and the Trump administration, and then allegations that the Trump administration has tried to cover up and obstruct the investigation by firing the FBI director. And then the director of the Department of Justice has to recuse himself from that investigation because he failed to report his meetings with the Russians. And so if that's not a whole lot for this committee to be investigating, I don't know what else is. Perhaps the prevention of child refugees into this country is more important.
The time of the gentleman has expired.
With that, I will yield.
The gentleman from Rhode Island, seek recognition.
I move to strike the last word.
Please recognize for 5 minutes.
Mr. Chairman, I associate myself with the remarks of my colleagues who have expressed their willingness to gather information to make important decisions in the area of refugees and immigration. I would just note for two things. One is children in most jurisdictions in this country are actually not convicted of crimes. They're adjudicated, so the answer to this question is likely to be 0. I just raised that in terms of drafting. The author may want to consider that. But I would suggest that if the intention is to try to gather information to make informed decisions, this resolution or this amendment is premised on a notion about the criminality of unaccompanied children. I think we all will learn that the overwhelming majority of these children do not commit crimes. They are fleeing violence and war, conflict, and in fact, come to this country and make tremendous contributions. So I'd ask the gentleman from Iowa, so that we really get a complete sense of information, whether he would be amenable to a friendly amendment to his amendment, which would add after 1232, after 8 USC 1232, and a report detailing the contributions, achievements, and successes of the same group of unaccompanied alien child. I think if he agrees to that, then we can get a full picture, and I have the language to give him if he'd like to look at it.
If the gentleman would yield. Thank
Does the gentleman yield back?
Giving Mr. King an opportunity to look at the language. I've offered a friendly amendment to add after 1232 so that it's a complete accounting, the following words, and a report detailing the contributions, achievements, and successes of the same group of unaccompanied alien child.
If the gentleman would yield. I'd just say in a quick read of that amendment, I appreciate the spirit that you deliver it in. It's complex, and I think it's unquantifiable to measure achievements and contributions in a way in this dialogue that we're in today. I think it's important that we have those discussions, but when I look also at the gentleman's critique of the language on what we might miss with crimes committed by minors, we say within my amendment, submit a report on each crime for UACs charged or convicted. So I believe charged will cover the minors on that. I think we're going to get that data, but I'd like to look at this after the committee, and it's something we could submit as an amendment to the floor if we need to clean up this language in my amendment. So I don't
reclaiming my time, I would just ask the gentleman if the intention is to give this committee and this Congress a full understanding of what the implications are of unaccompanied children coming into the United States. Part of that story is what percentage of them commit crime. The other larger part of that story is what is the nature of the successes and achievements of these. I think we can certainly rely on the Department of Homeland Security to make common sense determinations. What's the success? High school graduation. What's the success? Honor roll. I mean, there are a number of indicators that I think would quantify as a contribution, achievement, or success that would give us at least some context for evaluating the real impact of unaccompanied children in this country. Unless this is just simply an effort to continue a false narrative that these children come in and all commit crimes and significantly undermine the well-being and safety of our country, then it seems to me we ought to have a full picture of what they do. And I think...
Would the gentleman yield?
Sure.
The gentleman's point is well taken, but I think the advice would be that it needs to be more quantifiable than the language that he's put in his amendment. So if he wanted to specify certain things that were easily statistically gatherable, like the crime rate is attainable, such as high school graduation or college graduation or something else like that, I would not oppose that amendment to the amendment, but I think this is too vague, too unspecific, too unquantifiable to gather information that would be useful to the committee. So I would just suggest either that we vote on this. I would not support it, or you can withdraw it and we can work with you on some specific measures that we could insert as we move the bill to the floor.
I would just ask, reclaiming my time, if that's acceptable to the author of the amendment, and if we could hold this after the vote, I'll work on it right now, and maybe before we adjourn today, I can have very specific language.
And if the gentleman would yield, I would suggest instead we follow the chairman's recommendation on this, either vote on it or politely ask you if you would withdraw it. And I think that the topic that you raise is an important one, and we should look at this more broadly and take some time to dig into it. But I'd like to be able to move forward today.
Yeah, no, I'm not suggesting that. What I'm suggesting is vote on it, but hold this amendment if we could till the conclusion of our business today, and I can perhaps present you with language before we leave today that might be acceptable.
I'm going to say, if I could be yield, if you could yield, that I want to have a vote on these amendments and on this bill as we follow through and march through on this.
I'm not
open to having the discussion after the bill passes committee.
Let me intervene here. If the gentleman withdraws the amendment, if he has something ready before the bill is through the committee, we can do that. But I would assure the gentleman that if it is not ready by the end of whatever amount of time it takes to finish this bill today, I would still work with the gentleman to add it.
Thank you, Mr. Chairman. With that, I'll withdraw the amendment.
Mr. Chairman.
What purpose the gentleman from Maryland seek recognition?
I have an amendment at the desk, and this is an amendment to Mr. King's amendment.
All right, the clerk will report the amendment to the amendment.
And this also, I hope the sponsor of the amendment will consider a friendly amendment to his, and it is extremely quantifiable. In fact, it's based on the structure of the underlying amendment itself.
Clerk will report the amendment. The clerk will report the amendment.
Amendment to the amendment to HR 495 offered by Mr. Raskin.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. The last amendment, which we've decided to set to the side for the moment just because of its quantifiability, focused on what might be the positive outcomes for children who are admitted. And this focuses instead on what are the criminal harms that are suffered by children who are denied entry to the United States under this act. And so it would simply strike the period and add a new report, and it says, and to report on any criminal harms suffered by children denied entry to the United States and returned to their countries under this act, including murder, rape, sexual assault, sex trafficking, assault, or child abuse. I hope that the offerer of the amendment would agree that this is something that is very quantifiable and obviously relevant to what we're doing. Nobody...
Would the gentleman yield on that point?
Yes.
How is it quantifiable?
Well, these are crimes that are committed, so we would collect from the countries that the children are returned to reports of crimes committed and who the victims are.
And how would we get that? Do these other countries?
Well, the Department of Homeland Security, presumably we're in touch with them and have law enforcement relationships with these governments.
And they would keep records that are separate with regard to children who are returned to countries and children who are not?
Yes. Well, these governments are obviously keeping the statistics that the gentleman from Iowa has been invoking so that we know the number of murders that are taking place, the number of rapes and
I would question
whether
they keep those statistics.
The State Department has the ability to access this information from those governments, and if not, that's something that we would want to know as well. But
the government would have to break out the statistics regarding children first, but then secondly, children who stayed in Guatemala or whatever country and children who did not. And I don't believe that any of these countries have those statistics, nor do I think it's the jurisdiction of the Judiciary Committee to compel them to put them together.
Well, if we're going to be in the business of keeping statistics on children who are in the United States, who've come here, why would we not want to keep statistics and access them through the State Department or through the United Nations of the children that we return when we're trying to develop a refugee policy that's consistent with the values and the ideals that the United States was founded on? Tom Paine said that America would be a haven of refuge for people fleeing religious and political repression all over the world. So but I'm assuming everybody here is operating in good faith. I assume nothing but the best motives.
If the gentleman would yield, the information that he desires would be desirable in a whole host of circumstances around the world, but the United States doesn't have the ability to gather that information because it is not within the purview of the United States government to gather it, whereas what the gentleman from Iowa is asking for is well within the purview of the United States government. So,
I find it unfathomable that the government of Guatemala or Mexico does not have access to information about children who are victims of serious criminal offenses.
There would be absolutely nothing to stop the gentleman from asking for that data.
Well, and that's precisely what I'm doing with this amendment. I think it's something that is of public concern to everybody in America under our refugee policies to make sure that they're consistent with the values of our country.
I disagree. I don't believe that this information is readily available. And
well, would you agree that if it were readily available, it would be relevant to us?
It would be of interest to this debate. I'm not sure that it has the same impact on United States citizens as crimes committed in the United States.
Wait, in other words, do you think the American people are not equally interested whether or not our refugee policy is returning children to a situation where they're sex trafficked or they're raped or they're murdered? I think that the American people would want to know that, just like we would want to know whether some children who get involved with gangs. I mean, we want information in both contexts.
I think people would be interested in knowing all kinds of information, but it's not within the purview of the United States government to gather that information.
Well, let's try it out. I've got faith in our government and our ability to do it.
I'm sorry, I can't support it unless it is in a fashion that is truly quantifiable, and I don't believe the amendment that the gentleman's offered is quantifiable in that fashion.
I would ask the offer of the amendment whether he would accept it as a friendly amendment.
If the gentleman will yield.
By all means.
I'd like a little more time, and I may ask for some, and your clock runs down to the gentleman. But the thing I'm thinking about is this. My amendment addresses recidivism. It doesn't address the number of crime victims or where they might be or who are the victims of them. But when I listen to the gentleman from Maryland speak of this, I think of the data that I've gathered that has been picked up along the trail from Central America to the United States by those who are migrating into America. 100% of the girls get a contraceptive coming out of their hometown, delivered to them by their parents, because they expect that they will be raped on the way. And when I go into the transfer centers in places like Texas and near McAllen, and I ask the people that are working with those unaccompanied alien minors that are housed in there by HHS temporarily, they will say that actually they've said, we had 7 different sources from different locations said that 100% are victims of sex violence. Now, I don't accept 100%. Some of them have to get here and not be violated. But when they give me that consistent numbers, I think the victims on the way to the United States to illegally enter America are probably in greater percentage than those that are being sent home. So I think we've got a bigger topic here that we should address in a different forum and try to do this broadly so we can see all sides of this.
Just reclaiming whatever time I have left, I agree with you completely that many of the children who are trying to get into America are fleeing horrific conditions and terrible gang violence and rape even as a kind of gang ritual. We know that that is taking place. So they are fleeing that kind of situation. The fact that you know that and that there are statistics available suggests that our government has it within its means and within its enormous budget to access the information about children who become victims when they go back to Mexico or Guatemala or Honduras. If the information's not available, it's not available.
I think it's not.
The time of the gentleman has expired. The chair recognizes himself for 5 minutes on this amendment and yields to the gentleman from Maryland. Before I yield, though, let me just say that we're not talking, I don't think the gentleman from Iowa is talking about children fleeing the violence in these countries. I think he's talking about what they experience once they flee that. They run into these dangers in the other countries they pass through, including Mexico, as well as what may occur when they enter the United States. So again, I have serious doubts about whether this information is quantifiable, but be that as it may, I'll yield to the gentleman from Maryland.
Thank you. I do think that we're advancing somewhat the dialogue here because we're talking about extremely dangerous conditions that nobody on this committee would ever want to subject a daughter or a son or anybody in our family to. And if they go through that on the way up, if we turn them back and we send them back in the other direction, presumably they're going to be subjected to the exact same kind of situation, which is perhaps why there's a lot of skepticism about tightening the standards to the point where it's impossible for kids to get a fair shake once they're in the country. But it seems to me that there are law enforcement authorities north of the border and south of the border who can work to try to figure out the fate of these kids. Otherwise, we're just consigning them to a terrible destiny. We're basically saying you might be subject to rape, you might be subject to sex trafficking, you might be subject to abuse, you might be subject to gang violence, but it's not our problem. And not only do we take no responsibility for what happens to you, we don't even care to ask whether statistics are available. And I just think that's an unconscionable posture for the United States of America to be in. We are the country that was founded on the idea of the rights of men and women and children. That's who we are. We are not an authoritarian country. We are not a despotic country. I think the reason why so many of my colleagues on this side of the aisle reacted strongly to the comparison is because we try to hold ourselves to a higher standard than failed states that have lapsed into right-wing authoritarian government with lawlessness for the people. That's not who we are. So I think that anybody who comes into contact with America should expect the highest ideals and the highest standards. And I hope that Mr. King would be willing to grant this as a very small measure that is completely consistent with the spirit of he wants to do. How are we harmed by getting more information about what happens to children because of the policies that we're adopting here today? That's how we proceed pragmatically to develop the best policies and the best laws over time. I'm happy to yield back, Mr. Chairman, and thank you for yielding to me.
Mr. Chairman.
I'm happy to yield to the gentleman from Iowa.
Thank you. Move to strike the last word.
I've controlled the time. I'm yielding to you.
Oh, excuse me. Thank you. A couple of things I wanted to add to this because we're now we're getting some heart into this discussion, and I'm not going to be prepared to support the gentleman's amendment, but I am going to be promoting the idea that this committee gain a much broader understanding of the scope of this. And I think one of the things that we should do is be informing ourselves as to what a typical path is for a young person that may decide to come to the United States. And I've made an effort to learn and understand this to a degree, and I'm sure there are others that know it better. But I know the chairman led a CODEL down to Guatemala. We looked at the justice system down there. I've tracked this data for years, and the data of the violent death rates within the countries in the world, because I think it matters. One thing I want to put into the record here today, I wrote it down in my little memo sheet, if I can find it. It's been a little, yes, here it is. This is on a library in Acamel, Mexico. It's the Hicab B Library, Acamel, Mexico, and it's posted up there on the gable end, and I have a picture of it. It says, "A nation's culture resides in the heart and soul of its people." And I saved that, and I have that in my iPhone because that's really what matters. And I hear the discussion about race, ethnicity, national origin. It's not any part of it. It's culture that is the part that matters. And cultures do grow within certain communities, and levels of violence vary with a reflection of the culture that they're. And we have, we see that across America. I'd like to see America a lot more peaceful with less division that we have. But I hear a lot of focus on the division rather than the things that are universal to us. And so when I look at these young people, that 81% males on the train of death from El Salvador to McAllen, Texas is 1,500 miles, the same distance as it is from McAllen to St. Paul, Minnesota. And on that train, they expect that they will be raped, and their parents expect they will be raped, and they go to the local pharmacist and buy birth control pills and give them to their daughters and put them on the train. So I don't want to encourage them to be
Reclaiming my time, I appreciate the gentleman's comments. I do not believe that the language offered by the gentleman from Maryland is quantifiable. I can't support that. The gentleman from Rhode Island has resubmitted new language, which in examining, I think, moves us closer to where we need to be. I still think it needs additional work. We'll come back to that in a moment, because now we have to dispose of the amendment offered by the gentleman from Maryland, but my time's expired.
Mr. Chairman, could I seek a vote on my language?
Yes. The question occurs.
Mr. Chairman.
What purpose the gentleman from
After the vote?
Illinois seek recognition?
I'll yield back now, sorry.
Okay, he yields back. The question occurs on the amendment offered by the gentleman from Maryland. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. Amendment is not agreed to.
I would like a recorded vote if I
Recorded
could.
vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis?
We did.
Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes no.
Gentleman from Texas.
Mr. Poe votes no.
Has every member voted who wishes to vote? The gentleman from Texas.
Mr. Ratcliffe votes no.
Gentlewoman from Alabama.
Ms. Roby votes no.
The clerk will report. I'm sorry, gentleman from Florida.
Mr. Deutsch votes aye.
Clerk will report.
Mr. Chairman, 9 members voted aye, 15 members voted no.
And the amendment is not agreed to.
Mr. Chairman, I have an amendment at the desk.
An amendment to the amendment offered by the gentleman from Rhode Island. The clerk will report the amendment.
Amendment to the amendment offered by Mr. Cicilline. On June 5th, add after 8 U.S.C. 1232 the following.
I think that means on line 5, but in any event, the amendment will be considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I want to thank you for your thoughtful and wise counsel in asking that I be more detailed, and I think this amendment achieves what the chairman and the author of the amendment have suggested. And just for my colleagues, it would add the following language: and a report detailing the educational status and community engagement of each alien child for the following year, for the year following their release from custody, including school enrollment and status, 2, academic performance as reflected in school report cards, 3, any honors or awards presented to said child by school or community, 4, participation or membership in community-based or youth service organizations. This is obviously not a fully inclusive list, but it will give us, I think, some sense of the successful integration of the children that are the subject of this report. All of these are quantifiable, can be provided by a school in a simple report form. I think it's the kind of detail that is both achievable and useful, and I'd ask Mr. King to accept my amendment so I can look forward to voting for his amendment.
If the gentleman would yield, he read it. We don't have all the copy that we have leaves off a line or something. In addition,
it's on the back.
Some of these things.
It's on the back, Mr. Chairman.
Okay, you're right. You're right. You're right. I'm not sure why that is, but it is there. So if the gentleman would yield, I will say that I think that this is better, and I'm prepared to support it. However, I would say that there are some of these things that may not be available, and I would like to work with the gentleman. I'll support it now, but I would like to work with the gentleman moving to the floor, because it may need to be fine-tuned, and we may need to make it clear that if it's not available, then schools don't have to go, extra distance to create something that doesn't exist now.
Well, gentlemen yield.
Certainly.
How much of this stuff is Privacy Act protected?
I don't know that any of it is privacy protected. School report
cards are not Privacy Act protected?
I don't believe so. And certainly membership in school organizations or awards, honors.
Well, the gentleman from Wisconsin makes a good point, and if the gentleman, again, is willing, we would want to make sure that that is covered. And we're talking about broad statistics, not individual reports about individual. So
I think that's right.
If the gentleman agrees that...
Well, if the gentleman will further yield, we're not talking about statistics. It says the educational status of each alien child for the year following their release, including 1, 2, 3, 4, and 5. And, I don't think any of us can walk into a high school office and say we want to have the report card for, Mary Jones on that, and, get a copy of the report card. And,
reclaiming my time,
I
Mr.
sure don't want to go back to, go back to your high school and ask for your
Right,
report
reclaiming my time. I'm not under the
do it
supervision.
fine.
Reclaiming my time, Mr. Chairman. I'm happy to work on tweaking the language. I thank you for your support. It is to be reminded these children are under the supervision of the Department of Homeland Security. This is, again, asking for a report. These are not protected. There's all kinds of requirements under supervision. So that's a a red herring. It's a specious argument. This information is valuable and important. It can be collected, and it's asking that it be consolidated in a report, not the individual achievement of an individual student in the same way that the criminal
I will
cases
work
are.
with the gentleman and the gentleman from Wisconsin to make sure that the language.
Mr. Chairman.
Thank you, Mr. Chairman.
First, gentleman from Wisconsin, take recognized.
Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
You know, I sympathize with what the gentleman from Rhode Island is aiming at. However, you know, one of the things that I think this committee should be proud of is drafting things correctly so that between the committee and the floor, we don't have to have a major fix-up. And this thing cries out for, you know, a major fix-up. The other point I'd like to make is, you know, we've, you know, really led the charge in the Congress and in the country to try to protect the privacy of people's phone records, which is why the Freedom Act passed, and passed with very strong support by most, if not all, of the members of this committee when the House considered it in the last Congress. You know, and to say that, you know, the phone records of every American shouldn't be snooped by the NSA, I don't think is much different than, you know, allowing a dragnet to go and get kids' report cards on it. So I would suggest that the amendment be withdrawn, and rather than passing something that obviously is deficient, even by the gentleman from Rhode Island's admission, that he withdraw the amendment and then work with us with something from scratch.
Will the gentleman yield?
I yield.
As I'm sure the gentleman knows, the Privacy Act only applies to citizens and permanent lawful residents. So this category of individuals is not covered by the Privacy Act. I'm happy to work with the chairman, but I would ask that we move forward.
So I'm reclaiming my time. You know, there are a lot of court decisions that say that even the police can't ask for the immigration status, you know, of somebody who's pulled over on a traffic stop. And, you know, does that mean that if I go in and ask for Johnny Jones's fourth grade report card, I've got to say that I know that Johnny Jones is a citizen or a permanent lawful resident? This is one of the problems with having scribbled amendments from the floor, whether it's over across the street or in committee. I again would ask the gentleman to withdraw the, you know, the amendment, which I don't think is accurately drafted, because he talks about the educational status of each alien child. And I don't know whether high school or grade school records, or for that matter, higher education records, indicate the immigration status of the students who are enrolled in the school and, you know, end up completing their courses and getting grades. You know, we've had a big argument in the States about, you know, whether alien children who are not in status should get in-state tuition. And that means you can't ask whether the alien child is in status or is not on that. So, you know, you're asking the whoever is supposed to give these records to the Department of Homeland Security basically to violate the law, and they might be violating the state law. I'm not going to vote for the amendment. I'm sympathetic with what you're doing, but when we do things here, we ought to do it right.
The gentleman yield.
I yield to Chairman.
Given what the gentleman from Wisconsin has said, would the gentleman from Rhode Island agree to withdraw the amendment and work with me to fashion an amendment that addresses some of the concerns just raised? I am sympathetic to the gentleman's amendment, but I'm also sympathetic to the gentleman from Wisconsin's concern that drafting on the run can create problems sometimes.
Mr. Chairman, might I offer the insertion of one word that I think will get to this issue? I don't at all.
I'd be amazed if one word will get.
Well, I think it will, Judge. I think it will, Your Honor. If you add "and a report detailing the aggregate educational status and communication of each alien child," you can collect the same information. No one has a stronger privacy record in this Congress than I do. I take those issues very seriously. But the notion that a child under the supervision of the Department of Homeland Security cannot be required to share their educational status, their community involvement, is It's simply not the case.
Yeah,
There are
but
all kinds of conditions of supervised release
You know,
with the Department of Homeland Security.
reclaiming my time.
No, it's not your time.
No, it is his time.
Oh, I'm sorry. It is.
Boy, the gap is getting wider and wider and wider here. You know, let me say that, you know, the flaw in the gentleman from Rhode Island's argument is that most of these agencies that would be compiling these records, either in the aggregate or for individuals, do not have the immigration status of the people whose records are being compiled. You know, I doubt you can go to any university, and I don't know whether Rhode Island gives in-state tuition to out-of-status alien students at the University of Rhode Island, and say, I want to get, you know, the transcript of what grades this person has. Nowhere will it say that there has been an inquiry as to what the immigration status of the student is. So you're putting a burden on the Department of Homeland Security to get information that is not being kept by the people who are supposed to divulge the information. Now, if you want to be stubborn, I'm going to urge that the amendment be rejected. I want to work with you.
Will the gentleman yield?
Of course, I'm glad to.
Again, if you look at the amendment that we are attempting to modify with this amendment, this involves individuals released from the custody of the Department of Homeland Security pursuant to 8 U.S.C. 1232. The immigration status is determined by the release from the Department of Homeland Security. The individuals are identified by name.
My time is already over. Federal law prohibits the school from disclosing this
For
information.
citizens and permanent lawful residents.
Okay, but
These are not citizens who are in the
how do you
Department of
know?
Homeland Security.
Without objection, the gentleman from Wisconsin recognized for an additional minute. If he would yield to me.
I yield.
I thank the gentleman, and I would strongly urge the gentleman from Rhode Island to withdraw the amendment. He has a strong commitment from me to work with him on getting to where we can gather some useful information about what children who are released that are in the custody of the federal government has, but I think it needs a lot of work, and I just think that he'd be better
Mr.
off.
Chairman, I regret that it's taking my dear friends on the other side of the aisle longer to understand this than it took me, but I'm happy to work with you, and I'll withdraw the amendment. So
I thank the gentleman.
We're slow learners.
I see that. Yield back.
The question occurs on the amendment offered by the gentleman from Iowa. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is agreed to. Are there
Chairman,
further
we have a
amendments?
recorded vote.
H.R. 495. First, the gentleman from New York.
I have an amendment at the desk, Mr. Chairman.
The clerk will report the amendment.
Amendment to H.R. 495 offered by Mr. Nadler. Strike Section 4 of the bill.
Without objection, the amendment is considered as read. The gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, this amendment would strike Section 4 of the bill, a particularly obnoxious provision that fails to recognize the inherent difference between children and adults. Under current law, when an unaccompanied minor is apprehended, his or her asylum claim is initially presented to a CIS officer in a non-adversarial proceeding rather than to a judge in immigration court. If the application is denied, he or she still has the opportunity to present the claim to an immigration judge at a later proceeding. But the initial determination is made by a specially trained asylum officer in plain clothes in an office setting, which is more appropriate for unaccompanied and often unrepresented children. This important protection was contained in the Trafficking Victims Protection Reauthorization Act, which was signed into law by President Bush in 2008. The so-called Protection of Children Act, however, which is this bill, which would in fact do nothing of the kind, would strike this provision and would require children to present their initial claims in an adversarial proceeding in immigration court, as if they were adults. But they are not adults. Congress recognized that children are developmentally different from adults, and they must be treated differently. Children have different levels of cognition, of language skills, of emotional development, and maturity of judgment. That is why CIS guidelines require an asylum officer to conduct, quote, child-appropriate interviews, taking into account age, stage of language development, background, and level of sophistication, close quote. This bill, however, would subject children to rigorous cross-examination by an ICE trial attorney in open court about their past traumas, which may include sexual abuse, child abuse, and other violent experiences. And since there is no guarantee of legal representation, These children, many of them small children, would be forced to defend themselves in an intimidating adversarial setting. How does that amount to protection of children? Many of these children have escaped unspeakable violence and horror in their home countries, and they have risked their lives to find safety in the United States. They are scared, alone, and likely do not speak English. It is absurd to expect them to represent themselves in an intimidating formal legal procedure. It is not a loophole when we treat children like children. It is the protection that a civilized society grants to the most vulnerable people among us. My amendment asks for no greater protection than is already provided under current law, as I said, signed by President Bush in 2008. We should leave the present system in place and continue to treat children as children in a reasonable and humane fashion. I urge support for the amendment and I yield back the balance of my time.
Chair thanks the gentleman, recognizes himself in opposition to the amendment. I must oppose this amendment, which would strike a provision that seeks to fix a significant loophole in asylum law. The Trafficking Victims Protection Act of 2008 included provisions for minors applying for asylum. Amongst numerous changes made by the bill, making it easier for minors to seek asylum, the TVPRA amended the procedure for processing asylum applications of unaccompanied alien minors. An asylum officer at USCIS has initial jurisdiction over any asylum application filed by an unaccompanied alien minor, including applications filed by minors in removal proceedings. This allows a minor who would normally have been placed directly in removal proceedings to get 2 bites at the apple for the purposes of their asylum claim. They can have their asylum case heard first before an asylum officer, and if their claim is not granted, they can have it heard again before an immigration judge in removal proceedings. Currently, USCIS is granting 60% of unaccompanied minor applications at the first bite. If an asylum officer doesn't approve the application, it is referred to an immigration judge. Combining these 2 bites at the apple with adjudication standards at USCIS, where fraud detection was not a priority under the prior administration, the vast majority of minors who affirmatively seek asylum are now successful in their claims. According to HHS, the vast majority of these minors are 15 to 17 years of age and are essentially considered adults in their home country. Unaccompanied minors should get the same 1 bite of the apple as do all other individuals who are crossing our borders in search of asylum. By the way, the asylum proceeding is not open to the public, and therefore the information is confidential. The bill makes this important reform. The bill makes an important reform, and this amendment strikes it, so I urge my colleagues to oppose it. For purpose, the gentleman from California seek recognition.
I'd like to support the Nadler
Gentleman is
amendment.
recognized for 5 minutes.
Section 4 of the bill eliminates the initial jurisdiction over asylum claims for children from the asylum office, and I think that is a huge mistake. If the bill is implemented as written, children who have been persecuted or trafficked for sex would have to make that claim first in an adversarial immigration proceeding or hearing instead of a more child-appropriate interview before an asylum officer. Now, everybody who's been involved in the criminal justice system knows that it is not best practices to interview child sex victims in that setting. Every police department in the entire United States has specially trained people who are not in uniform, who are trained to elicit information from children who are not mini adults. I mean, they have different developmental issues to get the truth about what's happening. I think our current system falls a little bit short of that, but to eliminate it completely and to have the first time a child who has a claim because they have been persecuted or trafficked, to make that claim in immigration court is not the right thing. It's not the right thing. And when you think further that these children's, I mean, the chairman mentioned 17 or 18-year-old children who are not fully developed, but think also there's a large number of these kids, they're 8, they're 9, they're 10 years old, that they're supposed to go into immigration court without a lawyer and explain in front of a whole courtroom of people that they have been sexually molested and trafficked. That's not going to happen. That's just not going to happen, and it's not right to put that in the law. Now, as I said earlier, I think that we could, if we sat down together in a collaborative way, that we could work to address the issues of concern to the chairman and others in a way that did not do damage to child trafficking victims and children who have been victimized in other ways. This bill is not going to fix the problems. This is not a loophole that this is closing. And so I think Mr. Nadler's amendment is an important step forward in bringing justice, and I intend to support it, and I hope that the majority will think long and hard about whether this wouldn't make sense, or if you want some variation on it, whether we shouldn't adjourn and sit down together and reason together on how we can address issues that you think are of concern in a way that does not do violence to children who have been persecuted or trafficked by adults who have violated their human dignity.
Would the gentleman yield for a
I would be happy to yield.
Thank you very much, and forgive a rather simplistic question, but we had no hearing on this bill, and so we've not had the ability to ask any experts or people who are actually involved in the process about what goes on. So I'm afraid I've got to turn to you, Ms. Lofgren, because you seem to be a real expert on it. But if we don't adopt Mr. Nadler's amendment, would this mean that we are reducing the opportunity for all children to have a fuller investigation of their claims and their situation, or is it just children in that age 15 to 17?
I think it eliminates initial jurisdiction over asylum claims for unaccompanied children. And the initial jurisdiction now is USCIS asylum officers in the case of non-contingent children. This eliminates that. And so I guess the answer is yes.
So if I'm getting you right, if we don't adopt his amendment, then unaccompanied minors of any age would have a reduced opportunity to talk about their situation and why they're seeking asylum in the United States.
Yes, it would have to be in the format of an immigration proceeding.
Thank you.
And I yield back, Mr. Chairman.
Question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye. Aye. Those opposed, no. No. In the chair, the noes have it. The amendment is not agreed to. Record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? No. Mr. Franks votes no. Mr. Gomert? No. Mr. Gomert votes no. Mr. Jordan? No. Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? No. Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? No. Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? No. Mr. Gates votes no. Mr. Johnson of Louisiana? No. Mr. Johnson votes no. Mr. Biggs? No. Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
Gentleman from Wisconsin.
Mr. Sensenbrenner votes no.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Has every member voted who wishes to vote? Clerk will report. Oh, the gentleman from Iowa.
Mr. King votes no.
Clerk will report.
Mr. Chairman, 9 members voted aye, 16 members voted no.
And the amendment is not agreed to. Are there further amendments? Will the gentleman from California seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 495 offered by Ms. Lofgren. Strike Section 2 of the bill and insert the following.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Mr. Chairman, this amendment would strike Section 2 and replace it with a provision that treats children from Mexico and Canada in the same manner as children from Central America are currently treated. This would ensure that Mexican children who are fleeing trafficking receive no fewer protections than other kids simply by virtue of the place of their birth. Now, here's how it works today. Under current law, unaccompanied children are placed into 2 different processes depending on whether they're coming from a contiguous country, either Mexico or Canada, or a non-contiguous country, any other country. For the contiguous country processing, DHS permits them to withdraw the application, we had the discussion, and return to their home country only if it's clear that the child has not been a victim of a severe form of trafficking and there's no credible evidence that the child will be at risk of being trafficked and that the child's able to make an independent decision. Contrary to that, for the non-contiguous children, it requires that children be transferred from the Custom and Border Patrol custody within 72 hours to HHS or ORR custody. Now, once in custody, the attempts are made to place the child in the least restrictive setting possible. Children are placed in deportation proceedings to determine whether they are eligible for asylum, for U visas as victims of crime, for T visas as victims of trafficking, for special immigrant juvenile status, voluntary departure, or other forms of relief. These cases are reviewed by not only the judges, but the USCIS asylum officers if asylum is sought. And that is a far preferable procedure than the contiguous country processing. Earlier, I put into the record 2 reports, one from the United Nations that was done at the request of the American government, and the other, a GAO report that we requested about how this is going for the contiguous countries. And here's what those reports said. Almost all Mexican children are returned after not receiving effective screening. This is what the reports discovered. Most many CBP officers do not ask Mexican children any, and certainly not all, of the required questions. They just return the children immediately with a cursory screening. A lot of the supervisors are either unaware of the TVPRA requirements or they have not ensured that inquiries regarding trafficking are actually made. Many CBP officers don't know what trafficking is or persecution, 2 of the things they've been required to screen for because they haven't been adequately trained in that subject. CBP officers have no specialized training in how to work with children and interview techniques appropriate for children. That's not their training. Their training is to go catch people who are intruding, to keep us safe at the border. It's not to elicit information from vulnerable children. Border Patrol stations are inappropriate environments for interviewing children. And I think those of us who've been down to see the CBP stations, the holding cells, can explain why that doesn't work. You've got a chaotic environment, hundreds of people, everybody knows everybody else's business. You've got armed officers in uniform. You can't get a child victim to say in front of everybody else to an officer, and they're afraid, the intimate details of what has happened to them if they are a sex trafficking victim. Mexican children are currently being interviewed in close proximity to other children in non-private settings. There is no place in America in a law enforcement setting that would be considered acceptable. There's no police department that if you have a belief that a child has been sexually abused, that you would interview that child in front of other kids and adults by a uniformed officer. That's not best practices. And so it's important that we strike this amendment. I'll have another amendment later to have best practices, but certainly we should not subject all children to the deficient procedures currently in place for children who are from contiguous countries. I think it's important that this amendment be adopted, and I see my time has expired, so I yield back, Mr. Chairman.
The chair thanks the gentlewoman, but I must oppose this amendment. I recognize myself. Over the past 8 years, I and many others watched with dismay as the prior administration failed to enforce our immigration laws, effectively sending the word south that if you come to the United States, the, quote, new law, end quote, will allow you to be admitted into this country. The sad irony of this is that very message has resulted in far more sex trafficking of minors who leave their countries in Central America, travel 1,000 miles across Mexico, often with human smugglers who in many instances are themselves sex traffickers. This change is necessary to eliminate the incentive to make that dangerous trek and ensure that they go home safely once they are encountered, in the hopes that they will not continue to arrive in this country in numbers approaching 10 times the numbers they were just a few years ago. The William Wilberforce Trafficking Victims Protection Authorization Act of 2008, in addition to expanding protections for trafficking victims generally, made procedural and substantive changes to immigration law as it deals with apprehended, unaccompanied alien minors that have unfortunately contributed to the border surge. In 2014, an unprecedented number of unaccompanied alien minors were apprehended along our borders, nearly 70,000. Part of the reason for this surge, and the reason why we have been unable to stop it, is that the TVPRA of 2008 created two distinct sets of rules regarding unaccompanied minors apprehended from contiguous and non-contiguous countries. Under the TVPRA, minors from contiguous countries, such as Mexico, can be immediately returned if they consent, have not been trafficked, and do not have a credible fear of persecution. However, minors from other countries must be placed in often lengthy removal proceedings in immigration court, which court dates are years in the future. During this time, they are usually released into the United States, often to the very parents who paid to smuggle them across 1,000 miles of Mexico into the U.S. It is imperative that we end these conflicting rules and subject minors to expeditious and safe return if they have not been trafficked and do not have a credible fear of persecution. Otherwise, we will continue to see a dramatic surge of minors arriving at our borders, actually seeking our Border Patrol agents in the belief that they will be released into the United States. The immigration law has to stop encouraging minors to make these dangerous treks. This amendment would actually place all apprehended unaccompanied minors into removal proceedings, doing the exact opposite of the reforms contained in this bill. It would expand the current dysfunctional system in which minors are released to their unlawful alien parents, often never to be heard from again. In order to end the surges that have plagued the past several years, we must cease putting most apprehended minors in lengthy removal proceedings and instead quickly return them to their home countries. I urge my colleagues to oppose the amendment. The question occurs on the amendment offered by the gentlewoman from California. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The
I'd
amendment
like a
is not agreed
recorded vote, Mr. Chairman.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Mr. Iapol? Mr. Iapol votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Iowa.
Mr. King votes no.
The gentleman from Ohio.
Mr. Jordan votes no.
The gentleman from Idaho.
Mr. Labrador votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
Has every member voted who wishes to vote? The gentleman from California.
Mr. Issa votes no.
The clerk will report.
Mr. Chairman, 8 members voted aye, 18 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 495? For purpose, the gentlewoman from California seek recognition.
I have an amendment.
The clerk will report the amendment.
Amendment to H.R. 495 offered by Ms. Lofgren. Page 3, line 22, strike "and" at the end of the page 3, after line 22, insert the following and redesignate provisions accordingly. By redesignating paragraphs 3 through 5 as paragraphs 4 through 6, respectively, and inserting
Thank you, Mr. Chairman. This amendment would provide the following. An unaccompanied alien child shall be interviewed by a dedicated U.S. Citizenship and Immigration Services immigration officer with specialized training in interviewing child trafficking victims. Such officer shall be in plain clothes, shall not carry a weapon, and the interview shall occur in a private room with no other adults present. Now, why have I offered this? As I mentioned earlier, the report that we commissioned has made it clear, actually this is a report commissioned by the CBP, that agents and officers find it difficult to elicit accurate information from children for a variety of reasons, including the absence of specific training on how to interview children and the fact that questioning takes place by uniformed agents and officers in a public setting and the intimidating environment of a detention facility. Interviews typically last no more than 10 minutes and often involve agents and officers reading questions contained on Form 93, a screening tool that is available only in English and was not intended to replace an appropriate, child-friendly interview. Now, there's been a transformation across the United States of how to deal with child victims. And virtually every law enforcement agency in America have adopted child-centered interviewing models and protocols to obtain reliable information during the investigation. That approach recognizes that the amount and quality of information obtained during an interview with the child often depend upon the setting in which the interview is conducted and the level of training and expertise possessed by the interviewer. Interviews should be conducted in a child-friendly setting that is safe and private. And although law enforcement personnel may observe interviews with children because we have video cameras in all of these rooms, the interviews themselves are typically conducted by trained forensic interviews. Now, a child that has been sex trafficked has suffered a tremendous trauma, and they are likely to require special attention and additional time, certainly more than 10 minutes of reading a form to get the actual information out there. I think that we don't know what the answer would be, but hopefully all of us have an interest in finding out the truth. And we're not going to get the truth about what's happened to children unless we adopt this amendment. This amendment is in keeping with the best practices of law enforcement all over the United States. It should be brought to bear in these proceedings as well.
Gentlewoman yield.
I would be happy to yield.
I think the gentlewoman is on the right track, but I have a couple questions. I'm concerned about the no other adult present requirement at the lines 12 and 13. What if the child has an attorney?
I would ask unanimous consent to strike the last four words, the last three words on line 12 and the word present on line 13.
Without objection, the modification is made, and I'm prepared to accept the amendment.
Thank you.
Question is on the amendment offered by the gentlewoman from California. Those in favor will say aye.
Aye.
Opposed, no. The ayes appear to have it. The ayes have it, and the amendment is agreed to. Are there further amendments? If there are no further, for what purpose does the gentleman from Rhode Island seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment. There is no amendment to report.
I believe it's coming right now.
Are there copies for the other members of the committee to look at?
I think they're being distributed.
Clerk will report the amendment.
Amendment to H.R. 495 offered by Mr. Cicilline. Strike Section 3 of the bill.
The gentleman from Rhode Island is recognized for 5 minutes.
Thank you, Mr. Chairman. Under current law, an immigrant child can qualify for Special Immigration Juvenile Status, or SIJS, if the child establishes to a state court judge, among other things, that the child cannot be reunited with one or both parents because of abandonment, abuse, or neglect. Section 3 of H.R. 495 would change the eligibility requirement for SIJS to offer protection from deportation only to a child who can prove that reunification is impossible with both parents because of abandonment, abuse, or neglect. My amendment strikes that change to the SIJS eligibility and retains current law. I agree with Chairman Goodlatte, who recently said that children are among the most innocent and vulnerable among us and merit the highest protection of the law, end quote. And there are no children more vulnerable than those subjected to abuse and abandonment. This status is meant to protect this unique and narrow class of vulnerable children. For example, children who flee to a caring parent in the United States to escape an abusive parent in their home country. UNHCR conducted a survey of over 400 unaccompanied or separated children who had fled to the United States from the Northern Triangle of El Salvador, Honduras, and Guatemala. The survey found that more than 20% of such children cited abuse in the home as the impetus for fleeing. H.R. 495 would absurdly change the SIJS eligibility to require the removal of a child back into the hands of the parent or guardian who abused, neglected, or abandoned the child. This makes no sense. Prohibiting such children from being eligible for SIJS and returning them to the same abusive parents they fled plainly defies the logic of this immigration program, which is expressly designed to protect children. In addition, vetting by both the state juvenile court system and USCIS double verifies that the child deserves protection. The process can move forward only if a specialized juvenile or family court determines and issues an order certifying that the child has suffered abuse, abandonment, or neglect by a parent, and that reunification with that parent is not viable. The USCIS performs its own extensive screening and analysis. The effects of this change could be devastating. Advocates estimate that nearly half of the applicants for SIJS would be affected by this change in law. I see no benefit to this cruel change in policy other than to make it easier to remove children who can demonstrate that they've been abused, neglected, or abandoned. Deporting traumatized and abused children should not be our priority, and I ask my colleagues to support my amendment.
Would the gentleman yield?
And I'll yield the balance of my time to the gentlelady from California.
I would just like to support the gentleman's amendment. I think he's explained it well. At first blush, it seems strange that if you had one child who was not a parent who was not abusive, but the other one was, that you'd be eligible for this status. But in most cases, the abusive parent is where you fled from, and the non-abusive parent is here. The important thing to remember is that the child who gets this status is prohibited from petitioning to benefit their parent. This is not, people have expressed concern over so-called chain immigration, but once you've got this status, if you later become a citizen, you cannot petition for your parent like other citizens can. And so I think this is an important safety valve for children who've been abandoned. It's been part of the law for a very long time, and I think it would be a mistake to change it. And I commend the gentleman for his amendment, and I yield back to him the balance of his time.
Thank the gentlelady, and I yield back.
I recognize myself for 5 minutes in opposition to the amendment. I must oppose this amendment that strikes a part of the bill that is required in order to prevent the abuse of the U.S. immigration system. Alien minors who have been abused, neglected, or abandoned by their parents should be and are eligible for special immigration juvenile visas. However, an unintended consequence of the Trafficking Victims Protection Reauthorization Act of 2008 allows a minor to receive SIJ status, which grants permanent residence even if only one of his or her two parents have abused or abandoned them, and even if the minor can be safely reunited with their other parent. The TVPRA expanded the SIJ definition to allow for a juvenile or other state court to consider if reunification is possible with one or both of the child's parents. Practitioners argue that the plain language of the statutory revision means that family reunification must only be not viable with one parent, even if reunification with the other parent is possible. This loophole has been exploited and has burdened state courts and the USCIS with adjudicating their portions of the SIJ matters of children who are safely living with a parent or guardian instead of focusing on the truly deserving children who Congress intended to be recipients of the special immigration juvenile visas. H.R. 495 corrects this unintended consequence so that aliens are eligible for SIJ status only if they cannot be unified with either of their parents. I strongly urge my colleagues to oppose the amendment. Question is on the amendment offered by the gentlewoman from California. Those in favor will say aye.
Aye.
Opposed, no. No. Noes appear to have it.
Mr. Chairman, I ask for a recorded vote.
Recorded vote is ordered. Those in favor of the amendment will vote aye. Those opposed will vote no, and the clerk will call the roll.
Mr. Goodlatte? Mr. Sensenbrenner?
No.
Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. King votes no. Mr. Franks? No. Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
Are there any members who wish to record or change their votes? Gentleman from Virginia.
Mr. Goodlatte votes no.
Gentleman from Florida.
Mr. Gates votes no.
Gentleman from Texas.
Mr. Poe votes no.
Gentleman from Arizona.
No.
Further members who wish to record or change their votes? Clerk.
No.
Any further members who wish to record or change their votes? If not, the clerk will report.
Mr. Chairman, 8 members voted aye, 17 members voted no.
The amendment is not agreed to. Are there further amendments to H.R. 495?
Mr. Chairman,
For what purpose does the gentlewoman from Washington seek
I
recognition?
have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 495 offered by Ms. Jayapal. Strike Section 2 and insert the following. By amending paragraph 3 to read as follows. Transfers of unaccompanied alien children. In general, except in the case of exceptional circumstances, any department or agency of the federal government that has an unaccompanied alien child in custody shall transfer the custody of such child to the Secretary of Health and Human Services not later than 72 hours after determining that such child is an unaccompanied alien child. Mandatory training. The Secretary of Homeland Security, in consultation with the Secretary of Health and Human Services and independent child welfare experts, shall mandate appropriate training of all personnel who come into contact with unaccompanied alien children in the relevant legal authorities. Policies, practices, and procedures pertaining
Without objection, the amendment is considered as read. The gentlewoman from Washington is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I fear that this bill tosses aside the United States' historic role as a shelter for children seeking safety and subjects them to inhumane treatment in detention. My amendment would simply ensure that when children are detained, that they are detained in conditions that are safe and humane. And in fact, this is an issue that many faith communities have weighed in on across the country. The position, for example, of the Catholic Church is that detaining young migrant women and children as a response to their flight from persecution violates human dignity and human rights. My amendment would ensure, as was said, that children are transferred to the custody of Health and Human Services within 72 hours. It makes certain that children who are being detained are actually in the care, if it's longer than 72 hours, in the care of child welfare experts rather than in the custody of law enforcement agents whose job it is to enforce the law, not to care for children. And this is critical, Mr. Chairman, because we do have some precedent around this. In June of 2014, a complaint was filed on behalf of over 100 unaccompanied children who reported experiencing abuse and mistreatment in CBP custody. For example, one 7-year-old boy mentioned in the complaint was severely developmentally disabled and suffered from acute malnutrition when CBP apprehended him. But he was detained for about 5 days without any medical treatment, and eventually he was hospitalized and underwent emergency surgery. I want to say that there are CBP agents who have done admirable work, have changed diapers, and done their best to care for children in their custody. But it is clear that children should never be detained in the custody of law enforcement agents who have limited resources and are ill-equipped to care for these children. If anything, I hope my colleagues can agree that it is not, nor should it be, their job. In addition, it's dangerous to permit CBP to maintain custody of children long-term, given the many issues that we've seen in the past. My amendment also does require training for those who come into contact with these unaccompanied children on best policies, practices, and procedures, and it's really an attempt to help those who are there and who have to deal with this situation that may be far beyond their abilities at this moment. It also does provide for the presence of child welfare experts at the border to ensure proper screening and treatment of these unaccompanied children, because many of the children are fleeing places where the police frankly turn a blind eye, or at worst are complicit in violence perpetrated against them and their families. So we need to make sure that children who have suffered these long journeys can trust people in uniforms and feel comfortable sharing those sensitive details about why they're seeking safety. My amendment also protects girls by ensuring that women officers are continuously present during the transfer and the transport of unaccompanied immigrant girls. And we know that this is an important safeguard. In 2010, a guard at the Hutto Detention Center in Taylor, Texas, pled guilty to charges related to sexually assaulting 5 women who he drove from the detention center to the airport for detention. He was allowed at that time to transport these women on his own. So we just need to put in place some common sense measures that if we are going to be detaining children, that they don't get held for longer than 72 hours, and that we provide some resources and training. My amendment really is about simple, basic protections for children that I certainly as a parent would want for all children, regardless of who they are or where they come from. Around the world, we've seen parents make incredibly difficult decisions about how to protect their children, and sometimes the consequences are devastating. From island Kurds drowning off of the shores of Turkey to the thousands of children who do arrive alone at the border, the one thing that I believe these children have in common is that they are seeking a better future and fleeing for their lives. Just yesterday, we recognized World Refugee Day, and we remember the refugees who fled violence, such as those fleeing Nazi Germany, Burma, Cuba, Vietnam, and Sudan. And we have to ensure that we are responding with compassion and with the resources to protect these unaccompanied children. Mr. Chairman, I'd like unanimous consent also to introduce for the record a statement from the U.S. Conference of Catholic Bishops, the Committee on Migration, that is on both this bill as well as another bill that we'll be considering. And in this letter, there's a quote from Pope Francis, who has said, "Among migrants, children constitute the most vulnerable group because as they face the life ahead of them, they are invisible and voiceless." The letter goes on to say that we must recognize this vulnerability and remember, when forming our laws and policies, that many unaccompanied children are fleeing for their lives. Mr. Chairman, I hope that both sides of the aisle in this committee can support this amendment and just ensure that we have protections in place for these very vulnerable, the most vulnerable children who are coming to the border and deserve to be treated with dignity and respect. I yield.
Gentlewoman's time has expired. Without objection, the letter will be included in the record, and I recognize myself for 5 minutes in opposition to the amendment. The bill ensures a speedy court process for unaccompanied alien minors whereby they will have at least an initial hearing before an immigration judge within 14 days. It's been reported that more than 40% of the unaccompanied alien minors fail to appear for their immigration court dates. The faster court process will insist on ensuring that these minors appear for court and do not abscond and become immigration fugitives. This provision will ensure that unaccompanied alien minors do not wait for years on end for their hearings as they receive work authorization while their proceedings are pending. Both in the interest of the minors, in the proceedings, and the integrity of our immigration process, a 14-day hearing requirement is essential. Such a requirement would be impossible if minors are released to HHS to be resettled within 72 hours. With regard to the specialized care, this amendment creates a costly and convoluted system whereby welfare professionals are injected into the immigration process. The goal of this amendment seems to further entrench unaccompanied minors here in the United States rather than ensuring their safe and prompt return home. Detention is already costly as ICE creates state-of-the-art facilities for children and families at a very high cost. For these reasons, I oppose the amendment and yield back the balance of my time. We're about ready to vote. The question is on...
Mr. Chairman?
Chairman.
Okay, when the bell rings, I will recess the committee. The gentlewoman from California is recognized for 5 minutes.
Mr. Chairman, I thank you for, I know that we are going to be called away to votes, but this is an important amendment, and I feel an obligation to speak in favor of it. I, along with Mr. Gutierrez and Ms. Jackson Lee and some of the lawyers on the subcommittee staff, went down to the border.
If the gentlewoman would suspend, we are called for a vote. The committee is recessed and members are requested to come back immediately after the vote. Committee is recessed.
The committee will reconvene. When the committee recessed, we were considering an amendment offered by the gentlewoman from Washington, Ms. Jayapal's amendment, and Ms. Lofgren was using her time. She is not here. Is anybody else seeking time on the Jayapal amendment?
Mr. Chairman.
First gentleman from Maryland seek recognition.
Thank you, Mr. Chairman. I was actually going to ask the author of the amendment some questions. So I don't know what the appropriate thing to do is at this point.
She needs to get here quickly.
Yeah. All right. Well, I tell you, let me start just by saying two things that I wanted to state in any event. If I could move to strike the last word, Mr. Chairman.
There she is.
There she is. Okay. Mr. Chairman, one of the things I wanted to say was that in American law we do treat children in a sharply different way than we treat adults. We treat children with a kind of solicitude and a kind of paternalism and maternalism that we don't see in the rest of the law. So in juvenile justice, for example, we don't prosecute and convict children for offenses. We adjudicate the offenses, and it's been a theme of our jurisprudence for, I think, around a century now that the governing principle of juvenile justice is not punishment, but rehabilitation and education and setting the child again on the right path. The other thing I wanted to say, Mr. Chairman, forgive me if I'm sounding like a broken record here, but for those of us who've just joined the committee as freshman members who love this committee and love what it's about, it is difficult to get on top of some of these issues without hearings on the bills. And for those of us who come from state legislatures, it's unorthodox to say the least, and it's difficult to feel as if we're voting with complete information when we don't have hearings and testimony by professional witnesses. So I did want to ask my colleague, Ms. Jayapal, about her amendment. If she could explain, as I understand the amendment, that unaccompanied alien children would be turned over to the custody of Health and Human Services. Is that the current practice today?
Yes, that's the current practice today. And basically what this amendment is saying is we don't want to hold, and right now the bill says up to 14 days. That's a long time for a child to be held by immigration, by Homeland Security, who aren't trained and who aren't prepared with the resources that they need to have in order to take care of kids. And we just have to recognize that this is about children. That's what we're talking about. We're specifically talking about kids. And so what we're saying is that within 72 hours, my amendment would say that within 72 hours, they would get transferred to people who actually know how to work with kids, or trained to work with kids, and they would be able to have a place where if it does take more than 72 hours, less than 14 days, more than 14 days, that they would have the proper care that they need. That does not seem unreasonable to me, and I recognize that I am somebody who's worked on immigration for a long time. I've been to the facilities at the border. I've been with kids who have been in this situation, and really it's unconscionable that we would treat them like adults. We really need to differentiate and recognize that they're children.
So just to be clear on it, today such children are rendered to the custody of Health and Human Services, but under this legislation, without your amendment, they no longer would be?
Correct.
They would remain within the custody of the Department of Homeland Security?
For up to 14 days.
For up to 14 days. Okay, so what is the practical effect of your amendment?
The practical effect is that we actually maintain our status quo, and that we make sure that kids do get transferred over within 72 hours to people who can look after them. That's really the practical effect, is kids will get the care that kids deserve.
Okay, but and again, let me just ask you, and I understand we're in the realm of hypotheticals and speculation, but since we didn't have a hearing on it, so at least I don't have a clear sense of what the reason is for making the change. Can you articulate what the reason is for making the change, or your best understanding of it?
Well, I would really have to ask the majority why they would be proposing this bill and this change, because to me, it doesn't have a rationale other than that this would wrap immigrant kids up into the same rhetoric of how immigrants in general are being described, which I also don't agree with, that they're somehow criminals and dangerous. These are kids we're talking about, kids who are coming across seeking asylum, seeking safety, and we should recognize that they need to be treated, everybody needs to be treated with respect, but certainly the most vulnerable.
Okay, and just to reclaim whatever time I have, I wonder if I could shift the question to the chairman. Mr. Chairman, I wonder if you could explain the rationale for switching from the current process to the 14 days within Homeland Security.
The effort is to get people not absconding, not returning, and into court as rapidly as possible.
So, but my puzzlement is just that we're holding them for a longer period. Is that right? In other words, under the status quo, they're being brought to a hearing on a more expedited basis.
Right. But the problem is that there's no way, practically, to get them into a hearing in 72 hours.
Okay. Thank you. Ms. Jayapal, if I yield to you.
Well, your time's expired, and I have to return to the gentlewoman from California who was in mid-sentence, I think, when we recessed, so she's recognized for 5 minutes.
Thank you, Mr. Chairman. I do want to speak in favor of Ms. Jayapal's amendment for several reasons. First, I remember very well Ms. Jackson Lee was with me, Mr. Gutierrez, and several others, where we went down to look at the border when we had unaccompanied minor children that had basically caught the administration by surprise. And we had children, the facility we visited, it was primarily children from toddlers to about 11 years of age. These kids were sleeping on the cement floor. The Border Patrol agents were doing their very best to try and take care of these kids, but that really wasn't their job. It's not what they're trained to do. They were sending out for pizza to feed these kids. It was really a ridiculous situation. Kids were getting sick. There was no medical care. There were inadequate bathroom facilities. There was no place for kids to get clean. It was just a time bomb in terms of disease, and it's not really an appropriate way for children to be housed. Nobody disagrees with the need for people to appear at their hearings. I don't think there's any disagreement whatsoever on that point. This is not the way to do that. You don't need to be in the custody of Border Patrol as opposed to Health and Human Services to ensure appearance at a hearing. That same trip, we went, and a subsequent trip, we went to visit some of the facilities that are licensed or contracted with Health and Human Services. One, the Southern Baptists have a facility that's kind of like it's like a summer camp, and there were kids that were in dorms you can tell what's going on with kids because they're not very good at feigning it. When you went into the Border Patrol and you saw these kids and they were so miserable, then you went to the Baptist home and the kids were kids. They were cheerful. They were getting some schooling. They had smiles on their faces. They were, and they were in an orderly situation. We went at a subsequent visit to a similar facility that was run by the Catholic Church, also under contract with Health and Human Services. There's a thing about being good to small children that our country is for, and I think this bill, and I don't think I'm sure not intended, because I know Judge Carter is a very decent man, but the impact would be very wrong. And Ms. Jayapal's amendment would go a long ways towards fixing it. I do think, and I'll just say a point on the 14-day hearing. First, We don't have the capacity to do that because we have failed to add judges. And I hope that we have some hearings on this, Mr. Chairman. We're about to have an even bigger emergency when it comes to immigration courts because there's a whole generation of immigration judges that are nearing retirement age, and because of the working conditions, they're all going to retire. Plus, we're already behind the 8 ball when it comes to having enough judges just to deal with the matters currently before us. So the 14-day period, whether you think it's a good idea or a bad idea, we're not going to meet it because we have failed to put the resources into the judicial end of the immigration system to actually meet that requirement. Secondarily, I've done, and I assume the chairman has as well, asylum cases. It's not easy to put together an asylum case, and to do it in 14 days with a child who may or may not be very good at explaining themselves, especially if it's a small child, it's not a realistic time frame to do a very complicated immigration matter, and I think those of us who've done it realize the truth of that. So I do think that the amendment offered by Mrs. Jayapal is absolutely right in terms of treating children well, but I also think that in the underlying bill, the timeframes are problematic indeed. And I'm hopeful that we could adopt her amendment, or if there's something in particular you think is problematic, let's work together and deal with it, because the two options are not, I like Ms. Jayapal's amendment, but it can't be that we want these little kids to be in lockup. That can't be the right answer. So that's my take on this, Mr. Chairman, and I continue to think we would be better off if we would recess this markup and work through these issues in a more collaborative manner. And I see my time is up, so I yield back.
Question is on the amendment offered by the gentlewoman from Washington. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. The amendment is not agreed to. Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? No. Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. DeSantis? No. Mr. DeSantis votes no. Mr. Buck? Mr. Ratcliffe? No. Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? No. Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye. Oh, sorry.
Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee?
She's already gone. Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
The gentleman from Georgia, Mr. Johnson.
Mr. Johnson votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 10 members voted aye, 12 members voted no.
And the amendment is not agreed to. Are there
Chairman?
further amendments? For purpose, the gentlewoman from
I
Texas.
have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 495 offered by Ms. Jackson Lee. In Section 2, strike 2012 and insert 2012, except that the amendment made by subsection A1B shall not take effect until the number of immigration judges who are employed and are in service is increased by 70 or over the number of such judges employed and in service on the date of the enactment of this act. And there are employed all additional
Without
staff.
objection, the amendment is considered as read. The gentlewoman is recognized for 5 minutes on her amendment.
I'm trying to find. Did you give me one, please? I think you skipped me. Thanks. Thank you very much, Mr. Chairman. I have been working on this matter for a good while, not based upon my own independent proclivity, but speaking to immigration judges in really the busiest federal district, the Southern District, as relates to immigration cases. And so I would hope that this would be a bipartisan effort because even though we have disagreement on what the underlying message and results of the Protection of Children Act, which would strip longstanding and critically needed protections from child refugees and, would deal with the idea of refugees and trafficking victims, and as well to respond to the unaccompanied children in a way that I think is contrary to our values and what is good. We have heard over and over again, for those who visited the border, have seen the needs of children who are fleeing conditions that cannot be changed with a Band-Aid. And so my amendment simply delays the effective date of the bill until a number of immigration judges is increased by 70, a concept which is consistent with H.R. 1985, the Justice for Children Now Act of 2017, a bill that I introduced in the last Congress and earlier this year, which authorizes the appointment of 70 additional immigration judges by the Attorney General to reduce the substantial delays in removal proceedings and crushing caseloads carried by current immigration judges, which for some judges exceed 3,000 cases. The U.S. Customs and Border Protection Agency reported that last year alone, over 52,000 children were caught entering the United States, an unprecedented number that has caught our country without the necessary tools, such as immigration judges, which can help to determine, with counsel, of course, how these children should be handled. By law, these children are sent to various offices of the Department of Health and Human Services after their arrest and are supposed to be given due process. This means that each child is reviewed in court before a decision can be made about their immigration status. However, funding for the immigration courts that process the removal hearings has not kept pace with the increase in cases, and those numbers are down, as we indicated earlier in our debate, from the surge of a couple of years ago. The result, Mr. Chairman, is a current average delay of 578 days to hear over 366,000 removal hearings. The situation is untenable for all parties involved, law enforcement, taxpayers, and individual petitioning for relief. And as my colleague, Ms. Loughran, said, we did see CBP officers, Customs Border Patrol officers, buying diapers, getting formula, and really going beyond the call of duty. That is, of course, when you do not have the process in place to make sure that the children do get due process. My amendment will help ensure a just trial for the children and maintain the integrity of the U.S. immigration system, which is already overtaxed. The Jackson Lee amendment will help reduce the backlog in removal proceedings so that these affected individuals have a fighting chance at a modicum of due process. The judges could be appointed immediately to conduct hearings in a timely and efficient manner, and it would help the administration of justice. I would add that my amendment includes a provision for additional staff to support the immigration judges. We have, for too long, been shortchanged for immigration judges. This is a common sense amendment, and it responds to a bill that I don't agree with, but the bill is untenable in terms of the speedy removal when we don't have the process. There are many people who attempt to debate whether immigrants have due process rights in this country, but there's case law that says that if you're within the borders of this nation, you have a right to due process. So I'd like to submit into the record a series of articles that confront this very dastardly condition. Immigrants face long detention and few rights. The data shows that 18,000 immigrants had no criminal conviction, not even for illegal entry or low-level crimes like trespassing. More than 400 of those with no criminal record have been incarcerated for at least a year because they have no process of getting into the immigration court. 11-year-old Nadwin survived a journey from Honduras, which we have established is the largest murder area, is currently in detention alone. If I might, Mr. Chairman, indulge a Human Rights First U.S. Immigration Court, a ballooning backlog that requires action. I ask unanimous consent to submit those documents into the record.
Without objection, the documents.
I ask my colleagues to
are the
support the Jackson-Lee amendment. I yield back.
The chair recognizes himself in opposition to the amendment. We share an objective of getting more immigration judges and especially more immigration judges in Texas and other places along the border. The Executive Office for Immigration Review has been detailing judges to the southern border since 2014. While additional immigration judges along the border as well as throughout the interior of the United States would certainly be a welcome addition, it is unnecessary to predicate enactment of this bill on that addition. H.R. 495 will be part of the solution, but the problem will just be further compounded if we simply do nothing while we wait. This amendment creates nothing but delay, and therefore I must oppose it.
Mr. Chairman.
The gentleman from Michigan seek recognition.
I rise in support of the
Gentleman is
amendment.
recognized for 5 minutes.
I want to congratulate Ms. Jackson-Lee on her amendment to add additional immigration judges, which there seems to be general agreement on. Now, this amendment requires immigration courts to have additional resources so that they can meet increased burdens imposed by this bill. So there's little to quarrel about in that respect. Now, the next point that I'd like to make is that currently over 500,000 cases pending before about only 300 immigration judges are available to actually hear cases. Many of these judges have as many as 1,500 open cases at any given time. They often hear more than 30 cases a day and complete nearly 800 cases a year. In comparison, federal judges complete 500 cases a year. Now, the National Association of Immigration Judges have explained that immigration hearings with a child respondent takes longer than adult hearings, particularly because there is no appointed counsel for these children. And so for those reasons, I am pleased to commend the gentlelady from Texas and urge support of her amendment. I thank the chair.
This gentleman from Rhode Island seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I too strongly support the gentlelady's amendment and would like to yield my time to her.
Thank you. I think the clock needs to go back to 5 minutes. Thank you. I want to thank the gentleman from Rhode Island for yielding. I want to thank the ranking member for his very astute words, of which I'd like to build upon, and that is that we have a series of numbers that I think are crucial that we should put into the record. We note from the Human Rights First takes a particular note to cite the American Bar Association's Commission on Immigration to the former George W. Bush administration ICE Assistant Secretary Julie Myers Wood, who have called for increased funding for the immigration courts to address the backlog and maintain the integrity and fairness of the immigration system. To address the ballooning backlog, Congress should allocate for 75 immigration judges in FY 2017 and 75 in 2018. I've offered a compromise of 70. In fact, a number that is very evident and clear indicates that the number of cases pending before the court right now or forthcoming will soon exceed 500,000, 500,000. Far too many for a court staff with only 254 immigration judges, a fraction of the number needed to timely address removal. Now, let me address the question of timing. This particular legislation has to go through the committee, go through the floor, go to the Senate. I think that is sufficient enough time for the DOJ to simply add 70 judges. So this is not a delay per se. It is to match the movement of this bill through the legislative process and to make sure before it is completed and before it goes to the president's desk, he adds 70 more judges that are being pleaded for by those who deal with this system. Mr. Conyers made a very good point. Children, and Mr. Nadler made a very good point earlier about, as I believe, the ability of children to make decisions, legal decisions. Certainly a courtroom makes it even more difficult for children to make legal decisions. Then to be backlogged so that they are not even in the court for such a long period of time. This young man that's 11 years old survived a journey that has killed many adults. He traveled from Honduras to the United States border over land almost entirely by himself. He almost drowned crossing the Rio Grande River near Texas in an inflatable raft. Now, I don't want to go down memory lane to talk about the violence and why this child would risk, or his family would risk, all manner of death for him to come. But I will say that Norton once witnessed a boy his own age gang raped in a neighborhood park after the child refused to join a local drug gang. I think that's a little different from the violence that was cited. And so this is a kind of child that needs to make sure that we have judges in a court, that this child is not now delayed in a detention condition and then expected to go through a court process. There is the HHS. By law, 72 hours as long as children can be kept in CBP custody after the children are turned over to the Federal Department of Health and Human Services, and that means that they can be there forever, or they might reunite with their family. But under this legislation, a court will intervene. The system is going to change. We're going to remove the protections for these children. The court steps in, and there are no courts. I would simply ask that this be an administration of justice amendment that is bipartisan, and ask my colleagues to support the Jackson Lee Amendment, which is right in the middle of the request in 2017 of 70 judges and 2018 of 75 judges of immigration judges. And I might add, Mr. Chairman, we had a dial-in right now to immigration courts across America in the Southern District. They would tell you that the transfer of judges leaving one jurisdiction to the other just does not work. It is not an effective administration of justice. Count me as telling you the facts. I'm in the Southern District. I talk to these judges all the time. I ask my colleagues to support the Jackson Lee Amendment, and I yield back. Thank you.
Question concurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. Roll call vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Issa? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins, Mr. DeSantis, Mr. Buck, Mr. Ratcliffe. Mr. Ratcliffe votes no. Ms. Roby, Mr. Gates. Mr. Gates votes no. Mr. Johnson of Louisiana. Mr. Johnson votes no. Mr. Biggs. Mr. Biggs votes no. Mr. Rutherford. Mr. Rutherford votes no. Mr. Conyers.
Aye.
Mr. Conyers votes aye. Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia. Mr. Johnson votes aye. Mr. Deutsch. Mr. Gutierrez. Ms. Bass. Mr. Richmond. Mr. Jeffries. Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu. Mr. Liu votes aye. Mr. Raskin. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Schneider. Mr. Schneider votes aye.
The gentleman from Iowa.
Mr. King votes no.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Idaho.
Mr. Labrador votes no.
Gentleman from Florida.
Mr. DeSantis votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 10 members voted aye, 14 members voted no.
It is not agreed to. Are there further amendments to H.R. 495? For purpose, the gentleman from Georgia seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 495 offered by Mr. Johnson. Strike Section 2 and insert
Without
the
objection,
following.
the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. I rise to offer an amendment to H.R. 495, which would strike the provision prohibiting government funds from being used to provide counsel to unaccompanied children and replaces it with a requirement that the government appoint or provide counsel to them. Currently, children appear in immigration court without any representation. They stand across from ICE trial attorneys and are expected to adequately and effectively represent themselves. How is that okay? My amendment makes sense. Children, those under the age of 13 particularly, should not be expected or required to appear in immigration court proceedings in front of an immigration judge and in opposition from a member of Trump's deportation council without legal representation. I would say to the proponents of H.R. 495, at least make this a fair fight. It's one thing to have utter disregard for the future of children, but can't we at least give them legal representation before they are subjected to the pressures of immigration proceedings and deportation matters? If this amendment fails, it would be a step back from long-standing and bipartisan support for efforts to provide counsel to unaccompanied children. As recently as 2014, the GOP-led House Appropriations Committee instructed the DOJ to better serve populations, such as children, to improve court efficiency through pilot programs aimed at improving legal representation. This makes intuitive sense, of course. Children with lawyers are more likely to appear for their court dates, if for no other reason than they have someone in whom they can confide and whose counsel they can absorb. And no surprise here, children who are represented by counsel are more likely to win relief. This is also a nonpartisan issue. The National Association of Immigration Judges states that legal representation is absolutely essential to ensuring that children have meaningful access to asylum and other protections. So, ladies and gentlemen, there you have it. Providing legal representation to children is decent, it's fair, and it's the right thing to do. The lack of an attorney severely disadvantages severely disadvantages a child's prospects for relief, and this is something that we should not stand for. With this amendment, we have the ability to ensure that children have access to asylum and other protections and are not unfairly taken advantage of by this process. While the Protection of Child Trafficking Act takes a step back, this amendment strives to take a step forward in our efforts to provide unaccompanied children with the counsel that they need. Let us treat these children with empathy and integrity. I ask my fellow members to vote yes in favor of this amendment and provide unaccompanied children with appointed counsel. And with that, Mr. Chairman, I will yield to the gentle lady from Houston.
Mr. Johnson, I cannot think of a more important amendment that has been offered this afternoon. Just listening to you, I'm baffled by what the actuality will be if this amendment reaches the desk of the president. What you are saying is that right now in the underlying bill, counsel is denied to a child who has the least amount of ability to be defensive or to defend themselves. I know that it is tied to no federal resources, but in essence it means that they're denied the opportunity for counsel. And so I want to really enthusiastically support your amendment because I've grown up with the concept of due process and the right to counsel. Whether it was as television lawyers have been seen, and you all acknowledge that when you walk into a courtroom, America tells you that you have a lawyer. If it's not from the television lawyers, it's certainly from the news accounts of individuals being represented in many, many different ways by counsel. And then coming to the Judiciary Committee and recognizing the importance of lawyers in the system of the administration of justice, and to find out that we are actually considering a bill that would take away the rights of children to have counsel. So I support your legislation because I think we can't do anything else. Then we will extinguish due process and really the administration of justice and really an understanding of what is fair if we do not support your amendment. So I rise to support your amendment and I yield back.
I thank the gentlelady for her support, and with that, I yield back.
Chair thanks. The gentleman recognizes himself in opposition to the amendment, which would allow taxpayer funds to be used to supply attorneys for unlawful aliens in removal proceedings. Section 292 of the Immigration and Nationality Act states that, quote, in any removal proceeding before an immigration judge and in any appeal proceeding before the Attorney General from any such removal proceedings, the person concerned shall have the privilege of being represented at no expense to the government by such counsel. American taxpayers are already forced to shoulder the government's expenses incurred placing someone in removal proceedings. They should not also be required to bear the cost of the alien fighting the very deportation process they are already funding on the government side. The burden should not be placed on the taxpayer. I oppose this amendment. I urge my colleagues to do the same. For the purpose of the gentleman from California seek recognition.
Mr. Chairman, I actually am...
The gentleman is recognized for 5 minutes.
Just briefly, I agree with the gentleman's amendment, and let me explain why. As you've said, well, the taxpayers' money used for illegal aliens. First, we're talking about children. Obviously, an 8-year-old is not capable of representing themselves and meeting due process requirements. But two, I have a bill to do something like the gentleman's amendment, and when we had the analysis done, we actually discovered that because of the waste that's included in having unrepresented people in the system, it actually would not be a cost. Because you have here, let me just set the scene. You've got an immigration judge, and you have an 8-year-old who doesn't speak English standing in front of you. A lot of the immigration judges will hold that matter over because they are concerned that the child, number one, has no idea what's going on. They can't follow it. They're not represented. And there are costs to holding matters over because you're paying all the lawyers who are there, mainly the prosecutors. And so when the full analysis was done, it actually didn't increase the cost because of the efficiency increases. And I see my colleague, Mr. Gutierrez, here, but there's an irony here. The chairman mentioned that you've got people who are bringing children in who are traffickers, and that is a concern. That's why we have the Wilberforce Act to begin with. So if you've got some criminal who is trafficking children for sexual purposes, and that person is apprehended, the sex trafficker is entitled to be represented by a lawyer in the prosecution. The victim of the trafficking is not entitled to be represented. There's something wrong with this picture. And I do think that we should acknowledge that. I mean, the victims, who are the children who've been trafficked, are the ones who need our attention and our concern. And so I really think the gentleman's amendment goes a long ways towards fixing it. I thank him for offering it. I don't know if he wants it. I would be happy to the gentleman from
I just want to
Illinois.
echo the sentiments of the gentlelady from California. Look, the children come from Honduras, El Salvador, Guatemala, because of crime. Be very clear. So the drug dealer, the human trafficker, the leader of the gang, victimizes them. If we prosecute the person that's victimizing the applicant for refugee status in the United States, we grab him, he gets a lawyer, but their victim doesn't. And I think we have to understand that, as a woman once said to both gentlelady from California, Zoe Lofgren, and I, when we visited, she said, I can raise my children in El Salvador, I just can't keep them alive. I can feed them, but I can't keep them alive. I didn't come here because I didn't have a way to feed them and to give them clothing. I could not keep them alive. So you have to understand the fundamental difference in why this child is before you and why the child is a victim of crime and therefore needs an attorney. Thank you.
Reclaiming my time, I'll just recall the trip that we took to the border, and Mr. Gutierrez and I were talking to a grandmother with 3 little girls. The grandmother knew that she was going to be deported back to El Salvador, and she accepted that. But she brought these little girls because they were about to be snatched by gangs and put into circulation for the sex trade. And she saved them by leaving. I think, the stakes on this are very, very high. I'm again regretful that we are in this format without an opportunity to really sort through this in a more collegial fashion, but I do think the gentleman's amendment helps a lot. And with that, my time has expired, and I yield back.
Mr. Chairman. The gentleman from Rhode Island seek recognition.
I move to strike the last word.
I was recognized for 5 minutes.
Thank you, Mr. Chairman. I enthusiastically support the gentleman from Georgia's amendment for all of the obvious reasons. I mean, we require legal representation of children in virtually every other proceeding. We don't allow children to represent themselves, and the immigration court, with the consequences that follow, should be no different. When you think about many of the children who are in these proceedings, they are fleeing horrible violence, persecution, trafficking, other circumstances which make them even more vulnerable. And it's sort of hard to believe that while we've recognized that children, because of where they are developmentally, should be represented in complex legal proceedings, that somehow in the context of removal proceedings, those same conditions don't apply. There's obviously enormous evidence that children who are represented by counsel are more likely to appear. There's also considerable evidence that children who are represented by counsel are more likely to win relief because the law is properly applied to the facts as presented. And as the gentlelady from California pointed out, I know from my own experience, many years practicing as a criminal defense attorney, that those defendants who were representing themselves often consumed much more of the court's time as things needed to be explained, as continuances were sought, because the efficiencies that skilled counsel can bring to that are absent. So there's a lot of reason to say it's penny wise and pound foolish to deny children legal representation. It's inconsistent with what we know about the developmental needs of children, and really inconsistent with a long and bipartisan history of treating children very differently than we do adults in legal proceedings. And I would say, sort of finally, in addition to all of the efficiencies and all of the history that we will be rejecting by this provision and why this amendment is so urgent, it's important to remember that our legal system is the envy of the world. And one of the reasons it's the envy of the world is because we insist that people are properly represented. And we insist that children and the best interest of the child is the governing standard. The difficulty of children at very young ages to understand legal concepts and to understand or to grapple with language challenges make the notion of compelling children to be in a proceeding against an experienced, trained lawyer, and that an 8 or 9 or 10-year-old will be somehow required to engage in those proceedings in a meaningful way makes a farce of our judicial system. And so I thank the gentleman for offering this amendment. In many ways, you have to ask ourselves the question of who have we become as a country if we are going to compel children into legal proceedings, to kick them out of the United States, and in addition to all the other injustices in this legislation, we're also going to strip from them the right to be, or the requirement that they have the assistance of counsel so they can participate in these proceedings in a meaningful way.
Would the gentleman yield?
I prefer to yield to Mr. Johnson first and then to the chairman. Right. Or the chairman first and Mr. Johnson, whichever.
All right, well, I thank the gentleman. I just want to respond to his rhetorical question about who we have become, to note that this law, before which these children would have been returned safely home to their countries without this process, but now a law was created by your party. Ms. Lofgren was the chairman of the subcommittee and did not provide for this or any of these other provisions that you're offering amendments for now. So who we have become, I think, is people who are responding to the realities that the American taxpayers should not and cannot be required to provide the cost of bearing these counsel.
Would the gentleman?
Well, I'm reclaiming my time. Well, let me be very clear. I think there is no question that if there are proceedings which are prescribed for in this legislation, let my position be very clear. Children should be represented by counsel in those proceedings, and I yield the balance of my time.
I thank the gentleman, and since my name was mentioned, I would like to say that as time goes by, we learn more things. We don't know everything there is to know at one moment in time. And what we have learned, although the Wilberforce Act did a lot of good things, one of the things that was a failure, frankly, was to provide for representation of small children. That's why I've introduced the Fair Day in Court for Kids Act to remedy that. But I think, since the chairman mentioned it, the Republicans have been in charge for some time as well. As a matter of fact, Republican members were with us on a bipartisan effort to do the Wilberforce Act, and now you're saying that was wrong. I think you're wrong at this point, but certainly we need to make sure that we're constantly looking at the law, making improvements as more information and evidence compiles. That's our obligation as legislators, and one I take very seriously, and I thank the gentleman for yielding.
Mr. Chairman.
What purpose the gentleman from Washington seek recognition?
Move to strike the last word.
Recognized for 5 minutes.
Thank you, Mr. Chairman. You have raised several times that we should not put the burden of the costs on the taxpayer and the deep concern for taxpayers. And I wouldn't necessarily disagree with the concern for taxpayers, but if we're really concerned about taxpayers, then number one, we should pass comprehensive immigration reform because it would bring $1.5 trillion into the economy. Number two, I'm on the Budget Committee, and we had 3 economists come and testify. 2 of them were majority witnesses. One runs a conservative think tank. And when I asked him about immigration, and specifically mass deportation, increased detention, all of these bills that we've been voting on without a hearing in this committee, what he said is they published a report, and I don't have it in front of me, but maybe we can pull it up. They published a report saying that that would be a tremendous cost to the country and that it was fiscally irresponsible to move in that direction. And so I don't understand why we're suddenly talking about taxpayer burden, because if we're really concerned about taxpayer burden, we would actually move in a different direction. We would have real hearings about the issues of our broken immigration system, something that there has been bipartisan agreement on for so long. And yet, in this committee, and I'm on the Immigration Border Security Subcommittee because I thought maybe we would engage with some of those critical questions. But in this committee, we have not had hearings on any of these things. So people are voting on these bills, some new members. I'm lucky to have worked on this issue before. I know a lot about it. But we should be talking about real solutions. This bill is not one of those real solutions. If enacted, this bill would result in more deportations, more returns, and less immigrants entering the country. And maybe there are some people on the other side of the aisle who would applaud that for reducing immigrant entries. But this bill fundamentally harms the health, safety, and well-being of children. Let's just be very clear about that. And when it was said earlier by one of my colleagues on the other side of the aisle in this committee that a nation's culture resides in the heart and soul of its people, I have to ask, what exactly are we saying with that comment? Are we saying that other cultures somehow don't have heart and soul, and that's why we're trying to pass these bills to keep immigrants out? Are we saying that somehow our heart and soul in America is so great that we're not going to provide for an attorney for children who are in need, or that we're not going to detain children for more than 72 hours? What is so great about the heart and soul of the American people if we do those things? And by the way, did we forget that the heart and soul of American people was actually brought over by immigrants unwilling and willing on slave ships, and unless you were Native American, that the heart and soul actually did a lot to build this country of other cultures? So I fundamentally don't understand why we would put this bill forward, why we would make arguments that somehow this is benefiting the taxpayer to not provide legal counsel. And I want to rise in support, strong support of Mr. Johnson's amendment, because it would bring some small amount of justice to a terribly unjust bill. I mean, really, the idea that we would allow children, some of them toddlers, to appear alone in court is unfathomable to me. We know that our system works better and that we're better as a country when we make sure that everyone has access to a qualified attorney to help them navigate the system. And there's statistics around access to counsel. Among children with legal representation, 95.4% appeared for their court hearings. So even if you didn't care about the morality, you could talk about, if the point is that we want kids to appear, then we should provide them with legal representation. And it would streamline the courts. But what we know is that today, 88% of the 3,200 children that have been ordered removed from July to December of 2014 didn't have an attorney. So we have a lot of work to do, Mr. Chairman, on how we actually respond to the issues. And quite frankly, we talk about civility, and I just have to say that increasingly the idea that immigrants somehow are a detriment to this country is so unjust and unfair to our history, to our values, and yes, to the heart and soul of who we are as Americans. I yield back.
The
Yes.
time of the gentleman has expired.
Mr. Chairman?
It's got 11 seconds.
I have 11
I'd
seconds, Mr. Chairman.
I'd ask that a report by Dr. John Montgomery, Senior Vice President of NERA Economic Consulting, which finds that the net costs of this proposal to provide counsel, the savings could exceed the cost of providing publicly funded counsel.
Without objection,
I move that this be
the
placed
report
in
will be made a part of the record.
Thank you.
Question
I yield
occurs
back.
on the amendment offered by...
Mr. Chairman,
For the purpose, the gentleman from Illinois seek recognition.
I ask to strike the last word.
Gentleman is recognized for 5 minutes.
I'd like to rise in support of this amendment and share with a story of a young refugee who blessed me with his presence yesterday in my office. He's from my district. I had a chance to meet with him. He's 8 years old, from Honduras, born there. When he was 5 years old, he was kidnapped. And shortly after his release, he made his way to the United States. He wrote a letter to the president, and I just want to quote one of the lines of his letter, and I'll tell you this is a handwritten letter. He says, "I must share with you the sad reality that we live in because our countries of origin are full of crime and violence. This is why our parents risked our lives to bring us to safety in the United States." I'll reiterate what he said, that parents risk the children's lives because where they're living is so fraught with danger. Raul Ortiz, an 8-year-old young man, just finished 3rd grade, holds as his hero Abraham Lincoln. If you talk about the heart and soul of a nation in the spirit of its people, Raul Ortiz reflects the heart and soul of this nation. A nation of immigrants, a nation of refugees, many of whom came to this country seeking refuge from persecution, from violence, and finding in a country opportunity and a chance to live out their American dream. That's what these kids are seeking. Part of that American promise is the right to counsel. And I believe that this amendment moves us in that direction, and therefore I support it strongly, and I ask my colleagues to do the same.
Would the gentleman yield?
I yield to my colleague from Georgia.
Thank you, sir. I find it ironic that the title of this legislation is the Protection of Children Act of 2017, and it's premised upon protecting children brought into this country or brought to this country for purposes of child or trafficking, but yet we would withdraw protection, legal protection for these kids once they get here. This is really not protection at all. That's why we should really rename this act the Promotion of Child Trafficking Act of 2017. And with that, I yield back.
Question occurs on the amendment offered by the gentleman from Georgia. All those in favor respond by saying aye.
Aye. Aye.
Those opposed, no. Any the chair, the noes have it. The
Recorded
amendment's not
vote,
agreed to.
please.
Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnston of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Mr. Gutierrez votes yes. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Iowa.
Mr. King votes no.
The gentleman from Idaho.
Mr. Labrador votes no.
Has every member voted who wishes to vote? The gentleman from California.
Mr. Issa votes no.
Yes, the gentleman from Florida.
Mr. Gates votes no.
Clerk will report.
Mr. Chairman, 10 members voted aye, 12 members voted no.
And the amendment is not agreed to. It's my understanding there is another amendment. The committee will stand in recess for votes on the floor, and we will reconvene immediately following these votes.
Okay.
So, the committee will reconvene. When we recessed, the gentleman from Illinois had indicated that he has an amendment, and the clerk will report the amendment.
Amendment to H.R. 495 offered by Mr. Gutierrez. In subparagraph D, as
Without
inserted...
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Today's bill requires DHS to investigate the immigration status of any person who agrees to care for an unaccompanied child who is released from the custody of Health and Human Services. It also requires DHS to deport any person who is unlawfully present. My amendment would strike this provision from the bill. If it's included, it will result in many children languishing in federal custody for months or years. It would make families who could be reunited and give their children a home reluctant to come forward, and could put other siblings who may or not be U.S. citizens at risk of being placed in foster care. According to the U.S. Conference of Catholic Bishops, tracking nearly 400 cases where they were involved in placing unaccompanied minors with parents or close relatives, in more than half of those cases, nearly 60%, there was at least one U.S. citizen child in the home. So here's the choice you are making families make. Give a home to their traumatized, smuggled, refugee child who just crossed Mexico to get to the United States and risk being deported, and therefore leaving their U.S. citizen child or children without parents, possibly placed in foster care. These are the choices you are making impossible for good, decent people who are raising families in the United States. Furthermore, because immigration cases can take months, years to work their way through the backlog immigration courts, this will mean that thousands of children will languish in federal custody for long periods of time. Now, Mr. Chairman, I was a school teacher, elementary school teacher, and I'm a dad, and I'm a grandparent of a 14-year-old. And before that, I was a social worker with the Department of Children and Family Services, the state of Illinois. So I'm not an amateur when it comes to child welfare issues, both as a teacher and as a former social worker. And according to federal law, the standard for welfare of the child is to place them in the least restrictive, most family-like setting possible. Further, government, quote, must consider giving preference to placement with a fit and willing adult relative. The Trafficking Victims Protection Reauthorization Act requires the Department of Homeland Security to place a minor with a suitable family member as a priority over foster care. The family member under existing law who sponsors the child undergoes a home study by HHS to determine if the placement with them will meet the needs of the child. But apparently the majority feels that being a fit parent, being a reliable adult guardian, and having a visa are synonymous. Well, let me tell you something about parents, about Latino parents, and about immigrant and refugee parents. For any member of Congress to insinuate that immigration status determines one's fitness to care for, nurture, raise a child, well, has never met an immigrant refugee family. It's outrageous insult to say that your visa status determines your fitness for parenthood. Secondly, it is self-defeating as stewards of the taxpayers' money to demand that we hold children indefinitely and create barriers to them being placed in the least restrictive, most nurturing environment possible, which, of course, is first with parents. Think about it. We know parents will provide the best care, the most love, and do the best they can. They may not be always what the majority believes. Yet this bill seeks to make it harder for that family to reunite and survive. And I'm just bring my experience, Mr. Chairman, to members as a school teacher, an elementary school teacher, and a social worker. I used to go before the court every day and prepare family studies when I had times that I had to take protective custody of children. And the first thing that judge would ask me, did you find a grandparent, Mr. Gutierrez? Did you find an aunt or an uncle so they can be with their first cousins? Which in many cases, we all know we grow up, our first cousins are like our other brothers and sisters. Those were the first questions they would always ask me. And as a elementary school teacher, anytime there was a problem and I called the family together, the first thing I looked for were grandparents, aunts and uncles. That's people with family ties. That's what we do. It's not only what the law says we should do, it's what the best practice is for children. Let's not treat children seeking refuge in the United States any differently and put them in any less of a protective setting than we put our own children. Because you all remember that the Pope came to visit us and he said, follow the golden rule. You know, like do unto others as you would have them do unto you. In this case, do unto other children as you would have them do unto your own children. Thank you, Mr. Chairman.
Chair thanks the gentleman and recognizes himself in opposition to the amendment. When an unaccompanied alien minor is apprehended by law, they are placed in the custody of the Office of Refugee Resettlement within the Department of Health and Human Services shortly after their entry into the United States. HHS has indicated that they operate a set of facilities with private nonprofits until a parent, relative, or sponsor can be identified. The federal government must be required to obtain information on individuals with whom unaccompanied alien minors are placed, as they are often brought across the border by smugglers who are paid by the children's parents who are already in the U.S. illegally. On April 2, 2014, U.S. Customs and Border Protection conceded that the Obama administration's policies against deporting immigrant minors, as well as its practice of reuniting them with their parents, were factors in the steep increase in minors crossing the border without legal guardians. To make matters worse, oftentimes HHS does not even know who the, quote, sponsors are. Problems have occurred when the government hands over unaccompanied alien minors to guardians, quote unquote, regardless of the guardian's immigration status, background checks, or even knowing if the guardian has any legal ties to the child. For example, in 2014, a Honduran man unlawfully present in the United States, living in Baltimore County, faced federal charges after a 16-year-old female unaccompanied minor sent to live with him told police he smuggled her into the United States and he engaged in an inappropriate sexual relationship with her. Federal officials gave Pedro Lara Portillo, 42, guardianship over the girl, who is also from Honduras, through the HHS process. Clearly, whatever HHS is doing to identify sponsors for these minors is inadequate to protect their safety. This teenager was just one among tens of thousands of children who have come north from Central America, often traveling alone and sparking a crisis as officials try to figure out how to house them. For these reasons, HHS must obtain more information on who the minors are placed with. HHS must also share that information with the Department of Homeland Security. If minors are being placed with unlawful aliens, DHS should have the ability to put those unlawful aliens in removal proceedings. Hence, I rise in opposition to this amendment to remove the requirements protecting UAMs from potential abusers and urge my colleagues to do the same. For what purpose does the gentlewoman from California seek recognition?
To strike the last word.
Gentlewoman is recognized for 5 minutes.
I agree with Mr. Gutierrez's amendment, but I also agree with the concern you have expressed about the need to make sure that children are placed in an appropriate manner. Mr. Gutierrez is right. The best place for children is with a family member, and if those family members know that they'll be deported if they step forward to take care of a small child, it's going to be very hard for them to do that, especially if they have other children who would then be left without any parent. So Mr. Gutierrez's amendment is absolutely essential. Now, on the point you've raised, we were very critical. I know that the Republicans on the committee were critical. The Democrats were as well, because there was insufficient investigation of the placement of minor children. After that failure, new efforts were made to better vet the individuals, the adults and relatives who were stepping forward to provide temporary housing for these kids. In fact, DNA matches were put into effect so that if someone said they were the family member, you could actually find out if that was the case or whether it was made up. Other background checks were instituted. I'm not saying that we couldn't do more, maybe we could, but the bill which prevents people from stepping forward who are relatives is not the answer. The answer is to make sure that we have absolute sure vetting of people who say they are family members. And with that, I think we have complete agreement. So I think Mr. Gutierrez's amendment is absolutely essential, and I thank him for offering it, and I don't know if he needs additional time.
Thank you so much. I take the time, some additional time. So I listened to the chairman, and the chairman gave us this terrible case. And then he said, tens of thousands of these children come, as though tens of thousands of them are coming into this very same situation that this unfortunate young woman found herself in. The truth is, she's the exception to the rule. What we should be doing, if we care so much about these children, is redoubling our efforts to make sure we investigate appropriately the households. I mean, let's not, because really, what does checking, okay, let me go back to my original. What it says is you must check you must check the immigration status of the parent with which the child is to be placed, and deport that parent if we find them to be unlawfully in the United States. How does that protect the child? I get the argument, but what we're really doing is going after the parents and trying to deport them. And I will concede, and I'm sure most of us, that there are parents of unaccompanied minors who are undocumented in the United States. But that's the best place for that undocumented child as they go through the court system is with their parents. If you say you want to investigate the parents too, not just for their suitability of whether they can care for the child, but their immigration status, then you're really eliminating the best household for that child to be raised in. And you're really not protecting the child, because what you're doing, you can give me cases of bad placements. I will give you tons of cases of private jails where there is rampant abuse of children and adults. And I will give you cases of rampant abuse in the foster care system that is broken in the United States of America. The foster care system that is broken, and private jail system that is broken. So let's go back to what we know works. And I didn't get a legal background before I came to this. I'm just a school teacher and a social worker, but I worked with children. I know a little bit about them, so I hope that we can all support this amendment. And I return the balance of time to the gentlelady.
And I yield back, Mr. Chairman.
Question occurs on the amendment offered by the gentleman from Illinois. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. The amendment is not agreed to. Recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Gutierrez votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Florida.
Mr. Rutherford votes no.
Gentleman from Texas.
Mr. Poe votes no.
Has every member voted who wishes to vote? The gentleman from Florida.
Mr. Deutsch votes aye.
The gentleman from Arizona.
Mr. Franks votes no.
The gentleman from Rhode Island. Have you voted?
I'd like to vote again. Aye.
Count him once.
Mr. Chairman, have I
Gentleman from
voted?
California. You are not recorded.
Mr. Issa votes no.
Mr. Chairman, I think we have Mr. Nadler is running towards the door. If we could just stall for a minute.
There he is. A grand entrance by the gentleman from New York.
Mr. Nadler votes aye.
The clerk will report.
Mr. Chairman, 11 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 495? A reporting quorum being present, the question is on the motion to report the bill H.R. 495 as amended favorably to the House. Those in favor respond by saying aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably.
We get a record?
A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan?
Hey, thank you very much.
Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Mr. Gutierrez votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Tennessee, Mr. Cohen. You are not recorded. Not on 33, the 3rd, 78, or 45? Not in any one of those formats.
Mr. Cohen votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 15 members voted aye, 12 members voted no.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2826 for purposes of markup and move that the bill be reported favorably to the House. The clerk will report the bill.
H.R. 2826, to provide for an annual adjustment of the number of admissible refugees and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement, and as I do, I will advise members that it's the intention of the chair to recess the committee at 6:30 in time for members to participate in or attend the ladies softball game, which I hope there are members on both sides competing in or attending, but that's our targeted adjournment for today. With regard to H.R. 2826, the United States has a generous refugee program and has provided millions of people fleeing persecution with safe haven. Just last fiscal year, we resettled 84,994 refugees, and while we should continue that great tradition, it has become clear that our refugee laws can be abused and need reform. The Refugee Act of 1980 created our current refugee resettlement process, in which the President sets the annual limit for the number of refugees the United States can resettle during the next fiscal year. And the Act set forth who could be considered admissible as a refugee and how and when those refugees could adjust to lawful permanent resident status. In addition, the Act put in place a process for the federal government to work through non-governmental agencies to resettle refugees. 37 years later, members of Congress and the American public are voicing a growing number of concerns about how many and the way refugees are admitted to the United States, as well as what happens once they are admitted. But the federal government has done little to respect those concerns. Under the previous administration, when a state or locality expressed security concerns about refugee resettlement, the administration simply repeated the soundbite that refugees undergo the most rigorous background checks of any immigrant to the United States. That statement ignored those of several security officials that if there is no information regarding a potential refugee in the databases that are checked, then no derogatory information will show up during the check. And it ignored the fact that in many failed states like Syria, there is no reliable information about refugees. We know that over 300 individuals being actively investigated for terrorist-related activity by the FBI came to the United States as refugees. And we know that at least 2 of the 10 successful terrorist attacks carried out on U.S. soil since September 11, 2001 were perpetrated by individuals who entered the U.S. as refugees. So we should certainly be concerned about resettlement of refugees from countries that are hotbeds of terrorist activity. In addition to security concerns, if a state or locality express concerns about the costs of refugee resettlement or the lack of available employment opportunities, the prior administration did little in response. It was simply their view that, quote, the federal government has the right to resettle refugees all across America, end quote. And while that may be true, it is not necessarily the best practice. I know that many resettlement organizations do wonderful and necessary work, but essentially ignoring the pleas of communities across the U.S. and leaving refugee resettlement decisions to the administration is no longer a viable option. Also ripe for change is the process by which the annual refugee ceiling is set. Currently, the president sets the refugee ceiling after, quote, appropriate consultation with Congress, end quote. But such appropriate consultation had become simply a September meeting between the Secretary of State and some members of the House and Senate Judiciary Committees, at which the Secretary told us how many refugees the President had decided could be admitted. This was the case under multiple administrations. In 2015, when the Secretary did in fact provide us a number during the consultation, the final FY 2016 determination by the President was 10,000 more than what the Secretary had told us just days before. So among its many reforms, H.R. 2826 sets an annual limit for refugee admissions, curbing the President's limitless power. And the bill places the power in the hands of the states and localities to determine whether or not refugee resettlement is best for their communities. After 37 years, it is time to make some needed reforms to U.S. refugee law and policy. H.R. 2826, the Refugee Program Integrity Restoration Act, does just that. I urge my colleagues to support the bill. I commend the gentleman from Idaho, Mr. Labrador, for his hard work on it, as well as a number of other members, both on the committee and off the committee, who have contributed to this. And I now recognize the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Ladies and gentlemen, we're in the midst of a global refugee crisis. There are currently more displaced people, approximately some 60 million, than at any time since World War II. They are in refugee camps in Africa. They're on boats, in trains, and traveling by foot from the Middle East to Europe. And they are coming to our border from Central America. These are the world's most vulnerable. Many of them are women and children. Unfortunately, the majority's apparent answer is to cut refugee admissions by more than half. This bill also follows the Trump administration's shameful executive order to shut down refugee processing, particularly from Syria, a country embroiled in a 5-year civil war. The majority would say no to Syrians caught fleeing Assad's use of chemical weapons on his own people on the one hand, and the brutal savagery of ISIS on the other. The so-called Refugee Program Integrity Restoration Act would destroy the very foundation of refugee resettlement as we know it. It is perhaps more apt to call it the Refugee Program Destruction Act, because if enacted, it would destroy the U.S. refugee resettlement program. Let us remember that only yesterday we observed World Refugee Day. It marked a celebration of the strength and value of courageous refugees everywhere. This great Judiciary Committee must do better than honor refugees on a Tuesday, then vote to destroy the program that resettled them on a Wednesday. For example, The bill prioritizes religious minorities for resettlement as a matter of law. While we can all agree that those fleeing religious persecution should be protected, it makes no sense to elevate religious persecution above other forms of persecution. And like the Trump executive order, I'm concerned that this provision will be interpreted to block Muslim refugees from entering the United States. Another section of the bill would permit governors or local governments to block resettlement. In my home state of Michigan, I opposed the governor when he tried to exclude Syrian refugees from being resettled in Michigan. And while I'm pleased that he changed his mind, the experience shows how this provision would allow base emotion and the politics of the day to drive refugee policy. These types of provisions take us down a road that is uncomfortably close to the religious bigotry we saw in this country against Catholics before the election of John F. Kennedy and other religious minorities. The bill would also erect new, costly, and ineffective hurdles for those seeking to start a new life in America after having been found to be refugees. These are nothing less than dangerous proposals. They are dangerous to those who will be turned away because of an arbitrary cap that is far below what is actually needed and what we are capable of doing. But more than that, these policies betray our values, and in that way, they are dangerous to what makes America great. Now, I've watched with dismay as the president talked of building a wall and issued an executive order with the intention of closing our country to Muslims. I know the Muslim community in and around the greater Detroit area and my district. These are hardworking, for the most part, family-oriented people of faith. Their dreams are the same as immigrants who came before them: safety and protection from oppression, educational opportunities for their children, and a better life for those willing to work for it. The bill we're marking up today, similar to Trump's executive order, plays on our worst fears. It would have us turn our back on those most in need of refugee resettlement. It is inconsistent with the letter and the spirit of American and international refugee law, and so I strongly oppose this bill, and I plead with my colleagues to do the same. I thank the chairman, and I yield back the balance of my time, if there's any.
Thank you, Mr. Conyers. It's now my pleasure to recognize the chief sponsor of the bill, the gentleman from Idaho, Mr. Labrador, for his opening statement. So the gentleman does not choose to make a statement? Or?
No, I waived the opening statement.
Very good. The chair now will turn to the ranking member of the Subcommittee on Immigration, Border Security, the gentleman from California, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. H.R. 2826 would create a huge shift in this country's history of welcoming and protecting refugees from around the world. I think it really is an attack on refugees and the programs that serve them. The bill, in my view, does not enhance security or address current problems in the refugee program. It fails to recognize that refugees are fleeing persecution and that we have a moral and legal duty to provide them with safe haven. The bill seems to be based on the faulty premise that refugees in general pose a danger to the country, that their numbers need to be reduced, and that they need to be kept under surveillance. I was particularly disappointed, as the ranking member has mentioned, that this legislation comes before our committee just one day after World Refugee Day, when all of us paused to commemorate the struggle, courage, and contributions of the many refugees that have so profoundly strengthened our nation. And I would note that in my own congressional district, we are vastly enriched by refugees from Vietnam, the largest number of Vietnamese Americans in the United States, right in the city of San Jose, who have created a tremendous business environment, wonderful children, a very valued portion of our community. As the ranking member, Mr. Conyers, has said, we're really in a worldwide refugee crisis at the moment. We have not seen this many refugees since World War II around the world. Yet, this bill severely hampers the ability of our country to respond to the crisis. Among other things, it strips the president of his ability to set annual admission levels and statutorily reduces the number of refugee admissions by more than half compared to fiscal year 2017. I think that's a mistake. I guard the legislative prerogative as much as any other member of Congress, but I think the president needs to have the ability to respond to international crises and events and not be hampered by an arbitrary number in law. You know, since World War II, America has accepted millions of refugees. In the 80s, under Reagan, as I mentioned, we resettled hundreds of thousands of Vietnamese, at times taking more than 10,000 refugees a month. In the 1990s, we accepted hundreds of thousands of refugees from the former Soviet Union. And I would note that when the travel ban went into effect and people all over the country went to airports to protest, one of those who went was the co-founder of Google, Sergey Brin. And when the reporters asked the billionaire why he was there at 1 in the morning at the airport, he said, well, I'm here because I'm a refugee. And I'm glad that Sergey Brin formed Google in Mountain View instead of Moscow. It made a big difference to my constituents to have all those great paying jobs here in the United States. Refugees from around the world have become enormous contributors to our economy, to the fabric of our country, our society, and my district. Now, at this moment of great need, I think we should really be trying to increase our capacity to resettle refugees, not decreasing it. The level set in this bill is low, and I think it sends a dangerous message to the rest of the world, relinquishing our historic leadership. As mentioned by Mr. Conyers, it also prioritizes religious minorities for refugee resettlement as a matter of law. That is a radical departure from established law that provides protection from persecution based on race, on religion, nationality, political opinion, membership in a political or social group. This provision would deprioritize Iraqis and Afghanis who supported U.S. armed services, or women who are fleeing sexual enslavement or female genital mutilation by Boko Haram, or political dissidents from North Korea. I think another provision allowing governors and local legislatures to deny refugee placement in their communities is a restriction that applies to no other group of immigrants and sends a message that refugees are undesirable and unwelcome in our communities. I would note that although much has been said about the vetting of refugees, they are the most studied group of people who come into the United States of anyone who comes in. And some have said, well, we can't get information from some of these regimes. That's true. But would we really place great weight on the records provided to us by the Assad regime? I don't think so. What we do is spend 2 or in some cases 3 years examining each applicant, reconstructing their lives and the lives of the villages they grew up in to make sure that their stories hold up. We also do DNA testing to make sure that the people who say they're related to each other are. The idea of keeping refugees out is just not a good one. I don't think it's consistent with our values and our history. I think also it's worth remembering that just over 75 years ago, a ship called the St. Louis, carrying nearly 1,000 Jews fleeing Nazi Germany, sailed so close to the United States that passengers could see the lights of Miami. But rather than welcome those refugees, America turned them away. Many of those Jewish refugees perished. They were killed by the Nazis when they were forcibly returned to Europe. That marked a change in U.S. refugee policy and in the world's refugee policy. It's a mistake to upend the principles that have guided us since that time, as this bill does, and I hope that we will not adopt it. And I yield back the balance of my time.
Chair thanks the gentlewoman. The chair now recognizes the gentleman from Idaho, Mr. Labrador, for purposes of offering an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2826 offered by Mr. Labrador. Strike all after
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I am honored to introduce H.R. 2826, the Refugee Program Integrity Restoration Act of 2017. I have long been a supporter of the refugee program and the important humanitarian mission that it serves. The United States should be a beacon of hope to those in dire need who face persecution, torture, or death on account of their religion, race, national origin, political opinion, or membership in a particular social group. As a former immigration lawyer, this is more than just theory. I have seen this program firsthand. The refugee program, however, is outdated and is now in need of reform. The process is wrought with fraud, unchecked executive authority, and potential threats to our national security. These deficiencies have been highlighted in several hearings and by numerous witnesses. When former FBI Director James Comey testified before this committee in 2015, he made very troubling statements about the inability of law enforcement to properly vet incoming refugees. Compared to countries where U.S. intelligence has a strong footing, many refugees are coming from failed states, such as Syria, where there is very little U.S. intelligence presence. The simple fact is that we do not know who these people truly are, and former Director Comey made it clear that he could not give assurances for the safety of the communities that were accepting refugees. This is not only unacceptable, but it further undermines the legitimacy of the program and hurts those that it should help. The reforms outlined in this bill do much to restore the refugee program's integrity that has been lost over the past several years. The statutory changes modernize a statute that was written over 30 years ago and that could not have contemplated the problems that we face now. By updating provisions related to waiver authority, termination of refugee status, and the process for adjustment of status for refugees, H.R. 2826 takes the necessary steps to bring the refugee program into the 21st century. This bill goes to great lengths to strengthen the infrastructure of the program and combat fraud and threats to our national security. By improving our fraud detection at the earliest stages of the process and including recurrent security checks after refugees admitted to the country, U.S. law enforcement can better assess fraud patterns, identify future threats, and thwart attacks before they can occur. The provisions of this bill truly anticipate the needs of future Congresses to protect against unchecked executive action. By setting the ceiling through statute and requiring congressional action in advance of any adjustment, Congress finally brings the refugee ceiling determination in line with all other statutorily set immigration caps. Further, by providing a voice to state and local governments, this or any future administration cannot dictate resettlement without substantive input from the states and communities that will be impacted. The amendment in nature of a substitute that I have introduced today removes Section 13 from the original bill. Upon further review, this section is now more relevant to other legislation. For that reason, I have offered the ANS to remove that section of the base bill. This bill is the result of a collaborative effort of many members, and I want to thank all members who provided good ideas, input, and language. I especially want to thank Chairman Goodlatte for his strong leadership on this issue and for fostering the collaborative spirit that has brought us here today. H.R. 2826 is a strong bill that will greatly improve many facets of the refugee program, and I urge the members of this committee to support the ANS and the underlying bill today. And with that, I yield back.
Chair thanks the gentleman. Are there any amendments to H.R. 2826?
Mr. Chairman, did we get a copy of the manager's amendment? I can't find it here. Could I get a copy, please?
We will provide a copy. One was supposed to be at your
Maybe it was and I've lost it, but I
desk.
do not have it.
We'll find one for you.
Mr. Chairman, I have
First, the
an
gentleman
amendment.
from Michigan to correction.
I have an amendment at the desk and ask that it be reported.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2826 offered by Mr. Conyers. Strike Section 9.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Members of the committee, my amendment would strike the provision of H.R. 2826 that empowers state and local governments to prohibit the resettlement of refugees in their communities. Specifically, Section 9 of this bill states that no refugee may be placed in a community where a governor, a state legislature, a local chief executive, or local legislature takes any action formally disapproving refugee resettlement. Now, this section panders to the xenophobic notion that refugees are undesirable, a danger to our communities, and a drain on our society. Nothing could be further from the truth. Refugees make significant positive contributions in our society. A 2014 study by the City of Columbus, Ohio, found that refugees had contributed $1.6 billion to the economy and were twice as likely to own a business as the general population. In February of 2016, Bloomberg News published an article on my city titled, "Detroit's Comeback Has an Arabic Accent." According to this article, foreign-born residents make up about 9% of Detroit area's population and have contributed significantly to our economic output. Indeed, refugees have been American leaders in science, the arts, public service, and business. They include such luminaries as Albert Einstein, Miriam Makeba, Madeleine Albright, Sergey Brin, co-founder of Google. The governors of a few states included Indiana, Michigan, New Jersey, and Texas tried to block resettlement of refugees under the Obama administration. I'm pleased that many have either backtracked or alternatively their efforts were struck down in the courts. But unfortunately, this bill and this administration would embolden those same governors to close their doors to refugees. Section 9 of this bill does not reflect the values of a majority of Americans. Tellingly, a November 2015 study by Lake Research Partners found that a strong majority of American voters believe that the United States should do more to help refugees, or that it should continue to offer its current level of help. Nonetheless, this provision would allow local officials to trump the federal government and attempt to wall off entire communities from refugees, thereby forcing local refugee and faith-based organizations to close or move. Many refugees have lived in temporary status for years prior to entry, and we should be building bridges to help them succeed in our country instead of erecting walls. And so I urge my colleagues to support this amendment, and I appreciate the time that I've had to present it and yield back the balance of my time, and thank the chairman.
Chair thanks gentleman. For purpose, the gentleman from Idaho seek recognition.
Mr. Chairman, I oppose the amendment.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. During the past several years, communities in states including New Hampshire, Tennessee, Indiana, Idaho, South Carolina, and Texas have expressed concerns about refugee resettlement. Current law requires resettlement agencies to regularly meet with representatives of state and local governments to plan and coordinate the placement of refugees. But the extent to which such consultation occurs varies widely depending on the resettlement agency, the state, and the locality. And the former administration made clear that states have little recourse if they express the will of their residents that they do not want to resettle refugees. In fact, the former Assistant Secretary for Population, Refugees, and Migration told the Immigration Subcommittee that the federal government has the right to resettle refugees all across America. She also noted that the refugee program only works with the support of the American people, very much at the level of communities and societies and towns to come forward and help these refugees, help them get jobs, and help them move on. But she refused to say that if a community does not want to resettle refugees, the government will not resettle them in that community. And she repeatedly referred to communities that express concerns as hostile. But such communities can have legitimate concerns about things such as security, employment opportunities, and even the cost associated with refugee resettlement. In 2011, Manchester, New Hampshire requested a moratorium on refugee resettlement after concerns that the community was becoming saturated with refugees and that the NGO charged with resettlement duties was not meeting the required standards for resettlement. Instead of taking the concerns seriously and allowing such a moratorium, the administration decided to continue with the resettlement of 200 refugees down from the 300 initially proposed for resettlement. And some residents in South Carolina raised concerns about proposed refugee resettlement over the last few years, stating that the local government was not properly consulted. While the State Department acknowledged that the resettlement agency did not properly follow guidance and consultation, the agency bore no consequences and was still allowed to resettle the refugees. States and localities should be able to determine whether refugee resettlement is best for their community. Many localities are actually welcoming. We have many in Idaho that welcome refugees. But the community should decide, not the resettlement agency. HR 2826 allows that. Thank you very much, and I yield back.
For purpose, the gentlewoman from Texas seek recognition. I'm sorry, California. It's been a long day.
In support of the amendment.
Gentlewoman is recognized for 5 minutes.
I understand the comment made by our colleague from Idaho that there is a need to work with communities on the placement of refugees. I don't think that's what the bill does, and that's why I think Mr. Conyers' amendment is an important one. As we know, refugees, and Mr. Conyers has indicated, play an important role in our country. But if you think about, let's say this example, you've got a governor who says, I don't want any refugees, but you have counties and cities who say, we do want these refugees. Well, the cities and counties are overruled by the governor, but really what we're saying and what I'm hearing the proponents of the bill say is that they want to empower localities. Well, this bill does not do that. I do understand, and I've actually talked to one of our colleagues in a small community in Texas who expressed to me concern, not hostility towards refugee placement, but concern that a small town was not able to cope with the numbers. I think that's legitimate. If we wanted to say we're going to require the State Department to have a consulting relationship with localities prior to placement, I think I could support that. But I don't think this prohibition is a very wise idea. I also think what we haven't talked about is the implication, not only that this whole bill has on some of the finest organizations that we have in this country, and that is the refugee resettlement organizations, most of them religious-based, who they have employees, they have to have plans, and they can't just completely change everything overnight. I mean, they've got an important role to play, and were it not for the Lutherans and the Hebrew Aid Society and the Catholics and on, we would not have a refugee program that works at all. I mean, we very much rely on those groups. I've heard from many of those organizations that they would have to lay people off, and then when the numbers went up, they wouldn't have anybody to resettle them. We haven't addressed the impact on our partners in the refugee program. I think that's a mistake. So I support Mr. Conyers' amendment, and I think actually if we sat down together and didn't approach this in a partisan way, that we could actually come up with some solutions that we could all agree with to issues that exist on the program. That has not happened here, but I stand ready to do that if we want to take the time to do it, and I would recommend that. In the meantime, I think Mr. Conyers' amendment is worth supporting. I do support it, and I'd be happy to yield to the...
I'd ask the gentlewoman to yield to me.
I will yield to you, Mr. Chairman.
I thank the gentlewoman for yielding, and I appreciate her comments. I would just point out that the consultative process that you describe is already a part of the law. And the problem we have is that it's not happening. And when advice is received, it's not being followed. So the intent of the gentleman from Idaho, I believe, in the legislation, which I and others on this committee have participated in, is to give the states and localities some leverage to say, look, you're not listening to us, we're not going to participate. So I'm all ears about other ideas about how to address that problem, but the solution the gentlewoman mentioned is already in the law, and unfortunately, it's not working.
Reclaiming my time, I do think giving a veto to anybody is a mistake, especially when we know, I was talking to some students during the vote, and one of the young ladies who's here on a trip to Washington comes from what she described as a blue dot in Kansas. And the governor of Kansas has, which is interesting because when Brownback was a member of our body, we worked together with him on refugee programs. In fact, he was a leader on refugee programs, but has now taken a more hostile approach. The town she's in is very much into resettlement. To give the governor veto over that town, I think is a mistake to do. All I'm saying is that if the consultation process is insufficient, let's put our heads together to come up with something that's meaningful, that doesn't basically destroy the program completely in a significant portion of the country, because this is a politicized action in some states, and we all know it. There are certain governors that have used the refugee program to demonize for re-election purposes. really doesn't serve the needs of our refugee program, nor the needs of localities that might have a different point of view. But I appreciate my time is up, so I would...
Without objection, the chair would recognize the gentlewoman for an additional minute.
And I would yield to the
opportunity yield
chairman.
the ranking member.
Well, thank you very much. I appreciate the Lofgren presentation because it puts a common sense approach on here. But I just wanted everyone on the committee to know that a majority of Americans, voters, believe that the United States should do more to help refugees and that it should continue to offer its current level of help. And I think that if we follow that polling, we would end up supporting our proposal here, and I think we'd more importantly be doing the right thing. And I thank the gentlelady for her presentation.
Thank you, and I would yield back.
Mr. Chairman.
What first gentleman from Texas seek recognition?
Just strike the last word.
Gentleman was recognized for 5 minutes.
Well, I think I just was moved to comment by Congresswoman Loughran's very thoughtful offer, and to respond, Mr. Chairman, to the ignoring or either the lack of response to what is already in the law. That's, I think, an appropriate fix to ensure that the consultation is both effective and required. You can add a reporting feature to it, but where we are now with this legislation is a shrinking of the footprint of America that has boded us well over the decades in terms of our international role and place of leadership. It is a frightening shrinking. We're on the Judiciary Committee, so we're not on the Foreign Affairs Committee. But the holistic future of this country depends upon not only its domestic needs and the parochial terminology that is so destructive of America first, because anyone who makes the comment that I'm making would suggest, you're not for America? I absolutely love this nation without question, and those who are within it to give them an opportunity. But I also love and recognize the gift that America has given to the world, its status of leadership, its moral grounding that puts it light years above other nations around the world, Western democracies included. This doesn't do anything but squeeze that footprint, and we have grown that footprint through the generosity of our citizens, either those who have gone to the front lines on D-Day, Vietnam, Korea, and beyond, or the wonderful volunteers, ecumenical organizations that have worked so extensively with those individuals who come to this country to do well and to do good. The Church World Service is 71 years old, a humanitarian organization. They are urging the members of the House Judiciary Committee to oppose H.R. 2826 because refugee resettlement is a long-standing, life-saving American tradition that has recently become unjustly maligned and politicized in the midst of today's global refugee crisis. The consequences of far-reaching legislation such as this bill cannot be overstated. And we know from sacred texts, of which so many members profess, that nations will be judged by how they treat the most vulnerable, the widow, the orphan, the refugee during trying times. There are refugee camps scattered across the earth, from the continent of Africa into Mideast and beyond. These refugees, of whom I spent 2 Sundays ago, Mr. Conyers, and I'm rising to support your amendment. During Ramadan, I went to the Hawa Mosque, where they give out food every weekend to tens upon tens, if I might say, newly minted refugees, humble, grateful, thankful, fleeing persecution. I wanted to say individuals who are so grateful to be in this country. And the Church World Service knows that, as well as the stories that we hear of refugees that have come to this country and done outstanding things. None of us want our citizens to be harmed. None of us. The New York mayor of Utica, New York, said their city had a rebirth. A family coming in from Laos opened a healthcare agency, ranked by Columbus CEO magazine as the 5th best healthcare agency. This makes no sense. And I think the gentleman from Michigan's amendment takes us back to the position of leadership. And for any cities, counties, states that do not want refugees, there is a process for them to not have refugees. But Ms. Loughran is right. Counties and cities like Houston, Harris County have taken in refugees to no detriment to its citizenry. And I chaired the Interfaith Ministry for a number of years before coming to the United States Congress, one of the most joyful nonprofits I've had the chance of chairing. A faith-based organization that encounters Meals on Wheels, deals with young people, and for decades have dealt and been the welcoming arm for refugees, of whom they remember today and their children remember. This is a bill finding, screaming, and screeching toward a problem that does not exist, creating a problem, and narrowly defining who America is. I just don't accept it. And I asked the gentleman, first of all, I asked to support Mr. Conyers' amendment, and then I conclude by saying I asked the amendment be accepted, and I asked the bill to be reconsidered. I yield back.
Question occurs on the first the gentleman from Georgia.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I move in, or I rise in support of the Conyers amendment, which would strike the portion of the bill that gives states and local governments the authority to prohibit resettlement of refugees in their communities. And I'm struck by an email that I got from a constituent of mine on Monday. I met her on Saturday, this past Saturday, at World Refugee Day that we celebrated in Clarkston, Georgia, which is a refugee hub located in the 4th Congressional District. And at that event, she told me about her, the fact that if it were not for this country accepting refugees, that she would not be here. She told me that her grandparents escaped to this country from the USSR and Poland around 1917. She said that her paternal grandmother, Bessie, who was the middle child of a family of 16, was 16 years old when she escaped with her 8-year-old sister, Rose. The family only had enough money to purchase tickets for just those 2 children. And when they arrived at Ellis Island in New York, they were almost sent back to the USSR. They spent a week in an Ellis Island cell before they were allowed in. And 2 years after they came here, the entire family back home was murdered and buried in a mass grave. The grave is unmarked. And she said that only her great-grandfather, Moses, and her grandfather, Harry, were able to escape Poland, and the rest of the family perished in Auschwitz. And she told me that she could not in good conscience turn any refugee away. She said that leaving people to die is in direct contradiction to the foundation of this country, and that our forefathers came here to escape oppression. They were fearless, and we must be too. And so she told me that we must be better people than we are being to be anti-refugee. Can you imagine back then if the state of New York or the county that Ellis Island is located in, those people decided on their own that they didn't want to accept any refugees? Can you imagine how many people would have been killed and how much would have been lost by America from the contribution made by the progeny of those who were allowed into this country as refugees many years ago? That's our history. That's our legacy. And that legacy is threatened by this harsh and mean-spirited bill, the underlying legislation here. Instead of actually discussing reforms to strengthen the refugee program, this bill instead targets those fleeing persecution, violence, terror, sexual slavery, and torture. It cuts by half the number of refugees eligible for admission. This bill would make it harder for refugees to get a green card and makes it even more difficult for a refugee to obtain asylum. The bill distorts the definition of the word refugee to mandate that in order for a refugee to be granted asylum, the petitioner must show that threats of violence were specifically directed towards the individual seeking asylum. This change is inconsistent with U.S. and international law, and it would lead to the denial of thousands of applicants for asylum who are fleeing some of the most terrible environments in the world. Mr. Chairman, I ask that my colleagues support the very reasonable and very American Conyers Amendment, and I ask that you also oppose the underlying bill, and with that, I yield back.
Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? No. Mr. Farenthold votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? No. Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Snyder? Mr. Snyder votes aye.
The gentleman from Florida, Mr. Gates. Okay. Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 8 members voted aye, 11 members voted no.
And the amendment is not agreed to. For what purpose the gentleman from Iowa seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2826 offered by Mr. King of Iowa. Page 7, line
Without
5.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This is an amendment that I offered the last time this bill was marked up that passed the Judiciary Committee here by a vote of 15-7. And it's one that I'm just remiss that I didn't present this to Mr. Labrador to be incorporated into the underlying bill. But what it does is this: it recognizes the limitations that exist in the bill, respects them, and under Section 9 that lays out these limitations, and under current bill says in any state in which the governor of that state or the state legislature have taken any action formally disapproving of resettlement in that state. That component that gives local control to the resettlement of refugees, and my amendment adds to that in any state which also has a referendum or a plebiscite or a ballot initiative, that will also be respected as if it were a governor's decision or a state legislature's decision. It's really pretty simple, and we, I recognize that some states have a referendum process, some states do not, and for those states that do, we want to make sure that we respect the authority of the states to offer the referendum, the ballot initiative, or the plebiscite. And so that's the summation of this amendment. It's relatively simple, and I understand that it enjoys some support, so I urge its adoption. I'd be happy to yield to the chairman.
It has my support.
And that concludes my opening statement, and I urge its adoption. Yield back the balance of my time.
Anyone else? What purpose the gentlewoman from California seek recognition?
I oppose this amendment, and I'd like to say
The gentleman
why.
is recognized for 5 minutes.
As mentioned, this would alter Section 9 to allow voters to ban refugees. Now, the original bill is bad enough. It limits the exclusionary authority to governors, state legislatures, chief executives of a locality, or the local legislature. This would expand the refugee ban to allow voters to decide whether to deny refugees the ability to resettle in their communities. I can foresee some very xenophobic election campaigns that will be a product of this amendment. It would take this prohibition to the next level. And I don't think emboldening anti-immigrant campaigns actually solves the problem in the underlying bill. I would also note that polling shows a decisive majority of Americans favor welcoming refugees. For example, Indiana Governor, now Vice President Mike Pence, our former colleague, issued an order to ban Syrian refugees in Indiana. A local Indiana organization called Exodus Refugee Immigration got a preliminary injunction preventing Governor Pence from enacting his ban. Now, what was the basis for the injunction? The federal judge in that case found that Governor Pence's directive clearly discriminated against Syrian refugees based on their national origin, a provision that is prohibited in the Immigration and Nationality Act. Allowing a vote on an exclusionary measure doesn't transform it into an acceptable action. I recall there was a time when neighborhoods were allowed to decide that they were white-only neighborhoods, where only white people were allowed to live and to buy a home. For example, in 1916, the city of St. Louis passed a ballot measure that created an ordinance that designated some areas, and this is direct from their statute, not my language, quote, as Negro blocks, unquote. That passed with a majority of voters, but it fomented a race-based ballot initiative in St. Louis. It was followed in other parts of the country. The result was lasting and enduring patterns of segregation that still, they trouble our country to this day. I mean, they are a problem for our country. this could have the same impact. I do think that depending on the rationale for denying refugees, it could also lead to litigation and unconstitutional problems. As you note, all the federal courts that have looked at the Trump administration's travel ban have found it to be unconstitutional. Why? Because it's based in the view of these multitude of federal courts, including judges appointed by Republican presidents, that it was based on religion and therefore violated the Establishment of Religion clause found in the First Amendment. I can easily envision that kind of problem stemming from this amendment as well as, frankly, the underlying bill. So I think this is an amendment that ought to be opposed. I certainly oppose it, and I would hope that we would see our way clear to not creating the kind of situation that our country was saddled with and still suffers from in terms of discrimination in housing that used to be legal and fortunately is no longer legal in this country. And with that, I would yield back the balance of my time.
What purpose the gentleman from Michigan seek recognition?
Mr. Chairman, I rise in opposition to the King Amendment.
The gentleman is recognized for 5 minutes.
I am not going to take that much time because Congresswoman Lofgren has made a wonderful case in analyzing the situation and the history of this kind of problem. Ladies and gentlemen, this amendment takes us back to those early days of voter-supported segregation and would have a devastating impact on communities for years to come. And so I hope those of you who have been around long enough to know how far we've come when segregated housing laws were the thing of common acceptance, have now been eradicated by the Supreme Court. And please, let's not turn the clock back at this point. I yield to
Would the gentleman yield?
lady.
The gentleman yield for, and something I forgot to say, but I've been thinking about, which is how we deal with refugees in this country very much shapes how America is viewed in the world. And to allow a governor or a city council or the town to vote against settling refugees is really delegating the prestige of the United States to a mayor of a small city or a large city for that matter, and is very unwise. We have suffered, in my judgment, through some of the comments made by our president that are hostile to the refugee program. We had been in a position of being kind of the leading light of freedom in the world. The Statue of Liberty is there for a reason, that even though we couldn't accept all of the refugees, obviously, that exist in the world, but we set an example, and we hope that others will follow our example, and to delegate that decision so that our reputation as a nation is damaged by, mayors or a xenophobic electorate, I think is a very serious mistake. And I thank the gentleman for yielding to me so I could add that comment.
Would the gentleman yield?
I'd be pleased. First of all, I wanted to just express my gratitude for the historical recollection of the gentlelady from California. And I'd be pleased to yield to the gentlelady from Texas at this point.
I thank the gentleman, and I can't read what the offer of the amendment intentions are, but I can assure my colleagues that sinister results will occur, because the language says to take an action formally disapproving a resettlement. That by its very language is negative, and it draws, as Mr. Conyers mentioned, the kind of negative connotations of yesteryear, but more importantly, any election to disapprove obviously is victorious through negative representation of what you're trying to disapprove. I don't think it's necessary. It's overkill. We already have governors rejecting it and others rejecting it, and towns now able to reject it. We've already stated that the bill itself could be answered by strengthening the consultation and not bringing up this negative image of refugees, but we're obviously where we are. Now, let me finish by saying on a lighter note that, Mr. Chairman, the ladies of the softball team would wonder whether or not we could recess so that members could get to that game and support our members of Congress, Republicans and Democrats.
Would the gentlewoman yield?
I'd be happy to yield.
I announced about an hour ago that we would do so at 6:30. I would like to finish this amendment, and then we'll recess as soon as we're...
I thank you, Mr. Chairman. I'm sorry that I missed that statement. With that, I yield back to Mr. Conyers. Thank you.
What purpose does the gentleman from, gentlewoman seek? They both seek recognition. The gentlewoman from Washington seek recognition.
Move to strike the last word.
Gentlewoman's recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in strong opposition to this amendment, asking people to vote on whether or not to ban refugees has significant national security concerns, in addition to all the excellent points that Congresswoman Lofgren and Congressman Conyers have made already. And I think it's important to note that this has never been a partisan issue, whether or not we should support refugees, but I think it is important to introduce the national security perspective on this. And there was a statement just 2 years ago, a statement in support of the U.S. commitment to refugees signed by 10 Republicans, included Governor Jeb Bush, included Senator Mel Martinez at the time, Honorable Carlos Gutierrez. And in this letter, they say, our policies towards refugees are at the heart of our American values, and as the 2010 Council on Foreign Relations Independent Task Force on Immigration Policy stressed, the U.S. commitment to protect refugees from persecution is enshrined in international treaties and domestic U.S. laws that set the standard for the rest of the world. When American standards erode, refugees face greater risks everywhere. And the letter went on to say that, in fact, what Congress should do is eliminate many of the unjust barriers that deny or delay U.S. protection to legitimate refugees. And actually, it went on to talk about the need to pass comprehensive immigration reform. In addition, at the end of 2015, 20 national security leaders, including both Republicans and Democrats, including Henry Kissinger, General Petraeus, and others, said this. They said, we must remain vigilant to keep our nation safe from terrorists, whether foreign or homegrown, and from violence in all its forms. At the same time, we must remain true to our values. These are not mutually exclusive goals. In fact, resettlement initiatives help advance U.S. national security interests by supporting the stability of our allies and partners that are struggling to host large numbers of refugees. Mr. Chairman, my state, the state of Washington, first started admitting refugees when we had Governor Dan Evans, a Republican, a very good man who looked at the situation of the Vietnamese refugees at the time and created a place for those refugees to come. He was so moved by the terrible situation and the plight of those Vietnamese refugees. It's continued to be a home for refugees across the world. It's one of the top 10 states for refugee resettlement. So I'm not necessarily worried that in my home state we would find support for banning refugees, but I think that to leave an issue of this consequence that has this level of magnitude for the United States' reputation in the world and for our national security interests would be foolhardy. And I don't think that we would take other great national security interests that we have and say to the American public, okay, we're going to leave this to you. I think we would keep that jurisdictional responsibility as Congress. And so I don't really understand why we would take any kind of a vote to allow the public to ban refugees from their communities when we know that generals, national security experts across the country have said that in order for us to be able to do what we do in other parts of the world, we need to be able to provide protection to refugees in those countries. And in fact, in Washington State and Seattle, we settled some of the first Iraqi refugees who were translators for U.S. military forces in Iraq, and I remember meeting with one of them. He had lost one of his limbs because a device exploded, and he was caught in the middle of it. And had he stayed in Iraq, he would have faced tremendous persecution because he was actually helping U.S. forces. So this has enormous implications, our policy around refugees, moral implications that have been spoken to so eloquently here, but also national security implications. And I would urge us to not give in to some desire to stir xenophobic attitudes in certain places across the country or use this for political gain, but instead to think about what is in the best interest of our national security and what upholds the values that have been so core and so critical to America as a shining light in the rest of the world. And I hope that we'll reject this amendment. Thank you, Mr. Chairman.
Would the gentlelady yield?
I do.
I'd like to ask unanimous consent to put into the record a statement of the State Cato Institute drafted by David Byer,
Without objection, will be made a part of the record.
as well as the Church World Services, the Hebrew.
Without objection, made a part of the record. I do know the gentleman from Illinois wants to be recognized. I do know that the full amount was used by the preceding speaker, so I hope the gentleman will get his point across very efficiently.
I will be brief, and I hope to be finished in much less than the full 5 minutes. But I do rise in strong, strong opposition to this amendment, an amendment that I take very personally. As we think about the prospect of a referendum, a political campaign to talk about banning refugees, it strikes me that it would take on two forms. The debate would be either playing on people's economic fears or playing to their xenophobic prejudices. I say this as the grandson of an immigrant to this country, a refugee from the pogroms of Tsarist Russia. What my colleague from Georgia spoke about earlier, and he mentioned a woman named Bessie. My grandmother, Molly, came with her 5 siblings, one of whom was named Bessie, who was probably 4 years old at the time. They came from a very dangerous place to a country that at that time was not such a welcoming place to Jewish people. It was a time of great anti-Semitism that played out in many places around this country. To come to the point where we are today, to have even the possibility of an election that would play to prejudice and xenophobia, to me, seems to be in direct contradiction to the country that we are, to that more perfect union that our founders talked about. I take this as an affront as a grandchild of a refugee, as a representative of communities that have welcomed refugees, as someone who, through my entire life, whether it was Jews from the former Soviet Union or today Muslims and Christians from the violence in Syria, have worked to help refugees. This is not who we are, and I urge my colleagues to strongly oppose this and vote against it, and I yield back.
Question occurs on the amendment offered by the gentleman from Iowa.
Chairman.
The gentleman from Texas seek recognition.
Mr.
She's
Chairman,
already spoken once on this.
Yes, I have. I'm just going to submit into the record the document, excuse me, from the Church World Service that indicates its extreme opposition, and as well that it is not in any way representative of what America is and what it is
Without
to the world.
objection, it will be made a part of the record.
Thank you. I yield back.
And the question occurs on the amendment offered by the gentleman from Iowa. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
And the chair, the ayes have it. The amendment is agreed to. With that, the
Could we have a recorded vote on that, Mr. Chairman?
A little slow, but we'll go ahead. A recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte? Thank you. Votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Isa? Mr. King? Mr. King votes aye. Mr. Franks? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Yes. Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Biggs? Aye. Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes yes. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? No. Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes yes.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 11 members voted aye, 8 members voted no.
The committee will stand in recess in a moment. I want to thank all the members who have persevered and stayed until this late hour. The committee will reconvene on this issue when we are able to issue notice. And I expect it to be next week, but we do not have a set time yet. With that, the committee will stand adjourned for the day.
Thank you, sir.
Thank you, sir.
Very good.